Yes, they'll represent the interests of those constituencies. I think that's different from representing a particular view.
Yeah, okay. Hi, Jeff. You're just so you know that you're live and on camera and you're unmuted.
To not use it for anything. Working together, dog.
Morning, everyone.
Morning, Ishmael.
Morning, George.
Morning, Ishmael.
Morning, David.
And anyway, say look.
Judge is so frustrated. He's so upset.
Ms. Johnson?
Morning,
Ms. Johnson,
Judge.
morning, how are you?
Good, thanks. And you, Judge?
I'm well. Is everybody here? Online?
Yes, Judge, it appears so.
Good morning, Judge. We are here.
Okay.
Okay. Good morning,
Yes.
Mr. Jamie.
And
Morning, Judge.
Advocate Stansfield.
Good morning, good morning.
Good morning.
Case
morning,
number
Mr.
3.
Buxton.
Sorry, Judge.
Okay.
Case number 3473 of 2022, Peter Becker and the Minister of Mineral Resources and Energy and 2 others.
May it please the court, I appear for the applicant in this matter together with my learned friend, Mr. De Beer.
Thank you, Mr. Fadlander and Mr. DBA.
May it please the court, I appear together with Ms. Kaywood on behalf of the first respondent.
Thank you, Mr. Buxton and Ms. Coward.
Morning, Judge. I'm here with Ms. Stansfield for the first and second respondents.
Thank you, Mr. Jamie. Where is Ms. Stansfield?
She has, she is
She
here.
has not settled yet.
No, she had settled and she's
Okay.
imminently going to arrive on screen, Judge.
Morning, Judge.
Good morning, Ms. Stansfield. Okay, Mr. Fadlander.
As your ladyship pleases. Lady, we've submitted very full heads of argument, and we are not going to take the court through all of that. We of
Yes,
course
I've noted as well that you've allocated a generous amount of time for the hearing of this matter today.
that was the generous proposal of our learned friend, Mr. Jamie, which we accepted with gratitude, lady.
I don't think after elaborate heads that you've submitted, you should take that much time. But
No,
we'll see how we
It was only generous, my lady, because of my learned friend, Mr. Butler's slow pace, but if he can, be very happy to finish it.
Okay, let's proceed. We'll see how far we go.
Thank you, lady. Thank you. So we are not going to take the court through all of the heads of argument. And possible to cut to the heart of the case.
Yeah.
The first matter is the following, that the minister invited Mr. Becker to make representations about whether he should be discharged.
Yes.
And then before Mr. Becker had made his representations, the minister publicly announced that Mr. Becker would be removed from the board. And I'll show your ladyship why I say that. And we say this is the clearest possible example of a breach of the rules of natural justice to make this announcement, make this decision and this announcement while the matter is pending. And if we are correct in our submissions in that regard, then we say the application has to succeed. Secondly, we are going to submit that the minister made at least 9 material misdirections, bad reasons, and reviewable errors when he made his decision. And we will point out and submit that if even one of those is a material misdirection, then the decision has to be set aside. One bad decision is enough to put an end to the matter. So that's the second thing we'll submit, and we'll go through what we say are the misdirections. Then thirdly, we will submit that the decision is reviewable and that this is demonstrated by the decision of the Constitutional Court in the Matau case. And my learned friend, Mr. De Beer, will address that issue. Fourthly, we will make the submission that this is an anticipatory discharge. Mr. Becker was discharged not because of what he had done, but because of what the minister fears that he will do when the board has to make a decision. And we say that is not misconduct. Misconduct is what you've done, not what somebody fears you will do, however reasonably that fear is held. So those are our main 4 points. But before we get there, I want to deal with a couple of preliminary points. I just want to firstly sketch the functions and powers and the duties of the regulator and the board as set out in the Act. And then I'm going to say something brief about the minister's multiple reasons, and then I'll get onto the substance. So can I then take your ladyship to the powers and duties of the board, of the regulator and the board? I don't know whether your ladyship has a copy of the Act in front of her.
I can get it from my computer.
I think it would be helpful. I'm sorry, we should have put it up in the bundle of authorities.
In your bundle.
Lady,
No,
if I might
it's not in
note,
any.
there was a supplementary bundle that we handed up, gave to you yesterday, and it is the first item in that bundle. I don't know if that is something that is handy.
Thank you.
There
If your
are so
ladyship,
many documents that I received. There are so many. Oh yeah, there it is. I do have it.
Excellent.
Yeah.
Thank you. So if I can then take your ladyship through the key elements of the Act for present purposes. Section 5 of the Act deals with the objects of the regulator. Does your ladyship have that?
Let me go there quickly. Okay. Let me open it from my computer to be quick.
My lady, apologies to interrupt. Perhaps I can screen share the Act and then we can all view it at the same time. If
Okay, you can share it. It's fine if you do have it online.
I
That
do
would
have
be
it.
helpful. Thank you.
Okay.
Can everyone see my screen?
Yes, I can see it.
See the screen?
Excellent. Yeah.
Right, there we go. Right, thank you. Could we go to section 5 of the Act?
Yep.
Right, and we see there that section 5A, section 5 sets out the objects of the regulator. The objects of the regulator, A, provide for the protection of persons, property, and the environment against nuclear damage through the establishment of safety standards and regulatory practices. B, exercise regulatory control related to safety over the siting, design, construction, operation, manufacture of component parts, decontamination and commissioning and closure of nuclear installations through the granting of nuclear authorizations. And that's the core function of the board, as I'll show your ladyship in a moment, is nuclear authorizations. Then item C, 5C, exercise regulatory control over other actions to which this Act applies through the granting of nuclear authorizations. And 5E is interesting in relation to the submissions which we'll make shortly, fulfill national obligations in respect of international legal instruments concerning nuclear safety. If one then goes to section 7, one sees the functions of the regulator, and the most important function for present purposes is 7.1a. The regulator may, subject to this Act for the purpose of achieving its objects, grant or amend nuclear authorizations. That's the core power and core function of the board. If one then goes to section 8.2, one sees that it says that the board must ensure that the objects of the regulator referred to in section 5 are carried out, and B, exercises general control over the performance of the regulator's functions, and the board represents the regulator, and all acts performed by the board or on its authority are the acts of the regulator. So there we have it. The key functionary for present purposes is the board, and the board's key function is to grant or not grant nuclear authorizations. The essence of all of this is that the board must be independent. And this seems to be accepted by all parties, and one can understand why that is so, because of the devastating consequences of a body which is not independent, granted authorization without taking proper care about safety issues for other reasons. The consequences are just so far-reaching for all of us that the independence of the board is a matter of great importance, and that's recognized in the Act. And it's a matter of obligation. We've referred in our heads of argument, if I can just take your ladyship there, to our heads at paragraph 16.
Then?
Thank you, lady. There we make the point that 16.1, South Africa has ratified the Convention on National Security, which gives rise to various obligations on the part of the state. 16.2, Article 8 of the Convention provides, first, each contracting party shall establish or designate a regulatory body entrusted with the implementation of the legislative and regulatory framework referred to in Article 7, and then 2, each contracting party shall take the appropriate steps to ensure an effective separation between the functions of the regulatory body and those of any other body or organization concerned with the promotion or utilization of nuclear energy. So those who are promoting or utilizing nuclear energy must be separate from the board, because the board has to stand as a sort of watchdog to make sure of safety. And then I want to go to the minister's heads, because there's a paragraph there which may be somewhat misleading in this context. I'm sure it's not intended to be misleading. But would your ladyship go to paragraph 27 of the minister's heads?
Yeah.
It's on page 10 of the minister's heads.
Then?
This is what the heads say. It says a working relationship between the minister and the board is ensured by section 49 of the Act, which deals with disagreements between the minister and the board. In terms of subsection 2, should the minister fail to resolve their disagreement in terms of recommendations contemplated in these listed sections, the minister's decision is final. That's quite correct. But it's only in respect of those sections that the minister has an override. Those sections deal with fees for nuclear authorization. They deal with providing financial security. They deal with making regulations for safety standards. They deal with regulations dealing with the development of land in the area. So on all of those matters, the minister has an override. But your ladyship will notice that what is missing from there is the board's power to grant authorizations. That is not subject to the override. And there's absolutely no power on the part of the minister to interfere with or override or do anything else with regard to the decisions made by the minister, by the board when it authorizes. By the board. The board's power to authorize is the board's power, and no one else can exercise this power. And there's another passage in the heads which deals with that, but I'm not going to go there. The paragraph 27 is correctly stated. But what it perhaps omits to state is that as far as authorizations are concerned, the minister has no role whatsoever. So if the minister disagrees with the board on those matters, that's just bad luck, because the independence of the regulator is a fundamental principle, and the minister does not have the power to override the board with regard to its decision-making powers created by the Act. So that's the relationship between the minister and the board. Then I need to say something about discharge of a member of the board. If we can go back to the section, to the Act, if that could be screened again, the minister is given only a limited power to discharge a member of the board. It's a very pointed, limited power. Your ladyship will see that on the screen, section 9. The minister may at any time discharge a director of the board from office A if the directors repeatedly fail to perform his or her functions effectively. B, if because of any physical or mental illness or functioning the member is incapable. And C for misconduct, and misconduct is of course on what the minister relies here.
And the misconduct is not defined as to what type of misconduct.
Misconduct is not defined, that is so, lady. We make the important point though, the important submission, that before a discharge decision can be lawful, the minister must prove that the member committed misconduct. Because if there's no misconduct, then the minister does not have the power to discharge. The power to discharge only arises when, as a matter of fact, not a matter of opinion, when, as a matter of fact, the member has committed discharge. If, as a matter of fact, there's been no misconduct, then the minister has no power to discharge. That brings me to the next subject which I want to address, which is what I referred to as the minister's various multiple reasons. Because your ladyship will have noticed that the minister has had and exercised 3 formal opportunities to explain his reasons.
Yes.
The first time was on the 16th of February this year, when he said to Mr. Becker, I'm thinking of discharging you for the following reasons. Would you like to make representations? So, and he then set out his reasons for thinking that it might be appropriate to discharge Mr. Becker. Then the second time was when he actually decided to discharge Mr. Becker, and he gave his reasons. And your ladyship will have seen those, but I'll come back to them. It's annexure PB1 to the founding affidavit. I don't need to take your ladyship now. But it's the decision made on the 25th of February when the minister actually discharged Mr. Becker, and he set out why he was doing so. So that's the second set of formal reasons. And then there's a third set of reasons when the minister made his answering affidavit after all of these events.
Yeah.
And the point I need to submit is to be clear, the only reasons on which the minister is entitled to rely in justifying his decision are the reasons which he gave when he made the decision. You can't rely on reasons which he came to afterwards. The reasons which the misconduct on which the minister relies and to which he is bound is set out. Can I take your ladyship? That's in the record. It's PB1, page 61. That's the minister's letter. And I'm referring in particular to page 66 of that letter.
Page 61.
Page 61 starts at 61, and then at 66 is the paragraph which I want to refer to. Your ladyship will have seen that the minister sets out the history of the matter, sets out the various things that have happened, the various things that have been done. And then at paragraph 16 on page 66, it says, as a result of all of the preceding, I'm of the view that A, B, C, D, and E. And then paragraph 17, therefore, in accordance with section 9 and 1C of the Act, I'm of the view that you've committed misconduct and I discharge you. So the reasons on which the minister can rely are those set out in paragraph 16, of course informed by the preamble in the previous paragraphs of that letter.
Yeah.
But those are the minister's reasons. What the minister can't do, and that's common cause, is that he can't rely on reasons given afterwards. For example, in the answering affidavit, you can't patch it up by coming with other reasons afterwards. That was said in the Nurser case. We've given your ladyship the reference, and it's in our bundle of authorities. Perhaps I should just, does your ladyship have that handy?
Yes, I do have your bundle here. Is
Amidst
it
all of the
the
other
one that is
papers.
bound in black?
It's bound and it's thin. Yes, my lady.
Is it bound in black? Is
It's
this
got
the
a
one?
no, that's the big one. No, there's a thin one which is bound.
I think
I
saw
think, if your ladyship has it. Is that
Okay.
right, Michelle?
I'm not sure if it was bound, but again, if necessary, I can screen
this
share.
thin one.
Yeah.
The thin one, yes.
Yes.
Okay.
Would your ladyship go to page 41 of that bundle of authorities?
And there?
Your ladyship will see that's an extract from the decision in the National Energy Regulator case. Are we at the same place, my lady? Page 41.
Yes, I'm at page 41.
Then, my lady, your ladyship will see paragraph 39.
Yeah.
And the third
Where
line,
is the heading of saying expect reports?
that's so, my lady.
Okay.
And on the third line, the court says, this is now the Constitutional Court speaking, and the court says the following: it is true that reasons formulated after a decision has been made cannot be relied upon to render a decision rational, reasonable, and lawful. Then they talk about expert reports, which don't arise here. So you can't rely on what comes up afterwards.
Afterwards.
Yeah. And so for that reason, I am not going to address the various allegations which are made by the minister or the chair in the affidavits, which deal with questions of staff morale, the reputation of the board, recusal, all of those things. Those things are not raised by the minister in his reasons. They are raised in the answering affidavits. I should say they're unsubstantiated by any facts, but it doesn't matter because they're irrelevant, because they are not part of the reasons which the minister gave when he made his decision.
I thought so,
So
as
that's
well,
by way of
because
preamble.
at that point, the board had not even had one meeting when this all happened. So how is this, how has it impacted the staff morale? Other than Mr. Becker going to the staff to ask for some documentation, could that be a reason for relying on the staff morale issue?
Lady, I'm as much at sea on this as your ladyship is. It doesn't seem to. It seems to be a sort of a loose floating allegation without any evidence to support it anyway. There's no one who says we've been demoralized by what Mr. Becker has done. It's just a sort of loose floating allegation, but it doesn't really matter because it's not the reason which the minister gave.
Yeah.
And the minister is limited to the reasons which he gave.
I would like us to go to those reasons because I've got some questions.
Would your ladyship like to go there now?
Yeah.
Right. That's at page 66, the relevant part of the
Record.
the Bible.
From there?
This is what these are the reasons which he gave. He said, as the director of the NNR, you've placed yourself in a position in which you have a personal interest which conflicts with your duties to the NNR. You have publicly vocalized your opinions on nuclear activity and your opposition to the lifespan extension of Kuberg, which is in conflict with the independent, neutral role and function of the NNR. There can be little doubt on how you would vote if you were still a member of the board when the question of the lifespan extension of the Kuberg station comes before the board. You're thus not qualified to make a decision on the board. Your continued involvement when you're unable to, here's the misconduct alleged, your continued involvement when you're unable to bring an independent mind to bear on decisions in relation to the safe operation and or extension of Kuberg, because you've already indicated your position, amounts to misconduct in my view. C, you hosted meetings with civil society organizations, either in your capacity as a member on or of the NNR board, and you gave the impression that you are acting on behalf of the NNR board with no authority to do so. D, you've acted in conflict with your obligations both in law and contract. And E, the conflict of interest that exists is material and fundamental, because it's impossible for you to avoid or manage the actual conflict as well as the appearance of conflict. But on the face of it appear that you have no hesitation to make the public aware of your conflict. Therefore, I'm of the view you've committed misconduct. So those are the reasons. I don't know what
Let's go to the second one, B.
Yes.
Earlier on, you said that the board should be independent, and that is of great importance.
Yes, Lord.
If
Already.
a director of the board goes public and make his views known, are the members of the public going to be able to say now he's saying whatever he's saying in his personal capacity, or he's representing his organization? Or are they going to see him as a member of the board that is supposed to be independent?
Yes, lady, the correct independence is a matter of fact. You either are independent or you're not independent. If you take a position because you're instructed to do so by the people who nominated you, then you're not independent. If you're Labour, if you're coming from Labour and you take a position on safety because that's what the Labour unions want you to say, then you're not independent. If you come from if you come from the employers, but it's a different matter to say you're not independent because you expressed an opinion. If you express an opinion, that's your opinion. You're entitled to your opinion. And it doesn't make
But this is an opinion coming from an activist who's against nuclear energy. Yeah. This is an activist who's a spokesperson for this organization that nominated him to the board.
That is some lady, but what the Act requires him requires the board to decide is not the desirability of nuclear energy. What the board has to decide is the safety of any proposal comes before it.
Exactly. The board is the regulatory body.
Yes. Now, Mr. Becker has not expressed a view, committed himself as to the safety of any application for authorization which has been made. If he did, that would be a matter which you'd have to raise questions about and say, well, how could he do that? But he's expressed his views, and he's expressed them clearly on the desirability of nuclear energy as a power source. That is an entirely separate matter from the question of the safety of any application which is proposed, because that is a technical, it's a different question, it's a technical question. The first one, the question of desirability, is a mix of questions. It's a political, social, economic, technical, all sorts of things, moral. But the safety question is a technical question, and on that he was and remains independent. And there's no suggestion he has any instructions from anybody on how to vote on safety of any application, and neither has he committed himself on that.
Is he not supposed not to be taking sides in as far as his functions in the board is concerned?
Well, he mustn't
I don't have a problem with the fact that he's the member of that organization. But once you get to a certain position, that is a member or a director of the board, was he not supposed to be neutral in that respect? Besides the fact that
there's no on the question.
Sorry, you can.
I'm sorry, lady, I interrupted.
Okay, you can proceed.
He's required to be neutral on the question of safety of applications, but other members of the board have also expressed views on the desirability of nuclear. I'll show your ladyship shortly that Mr. Matopo, who's a member of the board, is an active supporter of the use of nuclear energy. He's publicly said so, he propagates it, he advocates it, and he's entitled to do so. What Mr. Matopo is not entitled to do, and what he hasn't done, is to say, therefore, I agree that these applications are safe and must be approved.
But Mr. Matopo's views were not publicized in any print media.
No, they were, my lady. They are publicized. They're published, and I'll show your ladyship that. He's written articles in the media in which he sets out his views.
In which media is that?
I can't recall off the hand what it is, but I'll be assisted by my colleagues. Mr. Matopo has published on the subject. Can I come back to that, my lady?
Certainly. You may proceed with your argument then.
Thank you, my lady, and I'll come back to it when I deal with Mr. Matopo. So then this brings me to the first, what we say is the fatal procedural flaw in the minister's decision, which is the way in which he made his decision and pre-committed himself. What happened, your ladyship will remember, was that when the minister suspended Mr. Becker on the 18th of January, he called on Mr. Becker to make representations
Yes.
the 11th of February as to why he shouldn't be discharged.
Yes.
That was the 18th of January. Answer me by the 11th of February. And then on the 3rd of February, this is what the minister said publicly. And can I take your ladyship to the record? This is now before the representations have been received.
Yes.
This is what the minister said publicly. It's
Are you
paragraph. It's
referring
page
to
50.
the radio interview or
The radio interview. That's
Okay.
Newsroom Africa.
Newsroom? Yeah. Where is it?
It's page 50 and 51. And the passage I'm relying to is on page 51.
There.
Well, perhaps I can go to page 50 first. Page 50, on the third last paragraph, he says, fourth last paragraph, answer. He says, the minister says, we are not fighting. All I'm saying is I'm giving Mr. Becker an opportunity to do working against nuclear. He must do that. But you can't be in the board of something you're working against, but that will be judged when it goes to court. But it's simple. You're an anti-nuclear activist. You can't sit on the board of nuclear and get all the details of the plans and go and plan a program against that entity. It's not allowed. And then on the next page, he says, second paragraph, but if the courts say we must take him back. I'm sorry, is your ladyship with me?
Yes, I'm
Page
with you.
second paragraph from page 51. If the courts say we must take him back, we will. But to me, it's a serious conflict of interest. In other words, he's gone, but we'll take him back if the court tells us to do so.
Which paragraph is that? Sorry. Page 51.
Page 51, lady.
Where is that?
There's
A, there's Q, there's A.
Yes, the second paragraph on that page 51.
Oh yeah, but if the court say we must take him
If
back.
the courts say we must take him back,
Okay.
we will. But to me, it's a serious conflict of interest.
Okay.
So when you say the courts will say, if the court says we must take him back, that means you think he's gone. He's going to be gone. And if the court says we must take him back, we'll do so. So he's made up his mind about it already. He's said, if the courts say we'll take, and I'll show your ladyship later some other passages of what the minister said, but this is what he says before he even receives the representation. He says, you can't do this, it's not allowed, but if the court says we must take him back, we'll do so.
At that stage, he was only suspended.
At that stage, he was suspended.
There was no court action that was taken.
There was an application pending, which was then settled. In respect of the suspension.
Was he not referring to that urgent application?
I'm sorry to interrupt, my lady. Could my learned friend, Mr. Butler, it's Abigail Jamie, could Mr. Butler perhaps just refers to the record that is the page reference?
Page 51. Page 51 of the record, my lady.
Oh.
Page 51, Mr. Jamie.
As a court business.
I was asking Mr. Badlander if the minister was not referring to that urgent application that was filed at that point because it was not settled, perhaps?
No, that's not what the minister's explanation is. The minister's explanation when this is raised is he says, I was just expressing a prima facie view. He doesn't say I was referring to the suspension. He says I was expressing a prima facie view, but I was waiting to receive the representations. But that's not what he says. That's not his explanation. And the whole thrust of what he's saying here is what you're doing is unlawful and is impermissible, and you can't be on the board. And I'll show your ladyship some other passages later where he says a similar thing. But once you say take him back, he's not saying, in other words, I'll decide when I see his representations, which is what the minister now claims he was saying. He says, I'll take him back if the court orders me to do so. And we say the minister is simply unable to. Can I just show your ladyship where the
reason why, sorry, Mr. Badland, the reason why I'm saying perhaps he was referring to the court because there was a court challenge at that time.
Yeah.
He, in my view, he can't be referring to court without any action being taken towards that direction.
I get the point, my lady. But you have to see what the minister's answer is to this. Can I show your ladyship what the minister says in response to this?
In his answering papers.
His answering papers, yes. I'm sorry, my lady. Yes, it's page 361 of the record.
Yeah. Three six one.
361.
Yeah. And then,
Paragraph 205.
and then.
What the minister says is, in order for me to take the decision I took on 18 April 2022, and your ladyship is right, that's a suspension decision. I had to have consideration of the information before at that time. Based on the allegations of the NNR, I had to identify if possible grounds for dismissal were present and take a prima facie view on the actions of the repellent. However, my mind was not closed to the possibility that the applicant's representations could sway me and convince me otherwise. But that's the explanation he gives. He says, I was still open to the representations. But that's not saying I'll take him back if the court orders me. He's saying, which is a different thing entirely. He's saying he claims in his affidavit, I would take him back if I was persuaded. But what he said was something quite different. He said, I'll take him back if the court orders me to do so. And so we make the submission that the minister can't escape this. He had in fact decided. He went through the motions, but when he was speaking his mind without guidance from his lawyers, he made his position very clear. Mr. Becker would go, and he'd take him back if the court ordered him to do so. And we submit that that's a clear breach of fairness, of the rules of natural justice, because you can't decide a case before you've heard the party. And we say that the facts, and I'll show your ladyship some other passages which lead to the same conclusion in due course. We say that the facts lead to only one possible conclusion. There was a fundamental procedural irregularity which can't be cured. Perhaps I should show your ladyship what were those other things that he said, which will perhaps assist in this regard. Now, this is what he said after he'd made the decision, but he explains what his attitude was. Your ladyship will find this at page 262 of the record.
262.
262.
Then?
And this is, you'll see there's a heading, the minister's public comments.
Yeah.
Saturday, 7 March 2022, News 24 reported on comments made by the minister at an ANC conference that day in an article titled, I Will Fire You. Peter Mantashe promises those who do not support nuclear programs. The author of the article recorded, quote, Energy and Mineral Resources Minister Peter Mantashe says that those who resist nuclear power while serving on the board of the National Nuclear Regulator will be fired. Not suspended, fired. Next paragraph. The minister was quoted as saying, if you resist nuclear energy, if you resist nuclear and you're a board member, I fire you. Simple. That's his attitude. His attitude is, if you oppose nuclear energy, I fire you. Simple. And so it's not open to the minister to say, oh, he was just waiting for representations. His position is quite clear. If you do this, I fire you. And so we say that this is the clearest possible breach.
Was he not referring to the nuclear that he wanted in Port Elizabeth?
Then he says he wanted it in Port Elizabeth, my hometown, yes.
We here at Quebec right now.
Yes, we are at Quebec. Milady, may I then move to the next topic? So we say that there could hardly be a clearer indication that the minister had made up his mind. And when these statements that he said, if you do this, I fire you, he doesn't suggest, say, oh, I used to think that in May, but I didn't think that in February. This is his attitude. His attitude is, if you do this, I fire you. Then I need to come to the core part of my part of the submissions, which is the 9 reviewable errors. And I need to make the submission, my lady, that the starting point is when there are mixed reasons for a decision, good reasons and bad reasons, then the bad decision, if it's material, results in the decision being set aside. That's one material reason which is bad is enough for the decision to be set aside, no matter how many good reasons there are. And that doctrine goes back in our law nearly 100 years to 1931 in the case called of Patel versus Witbank Town Council. And in our authorities, we show your lordship what the Supreme Court of Appeal through Justice Cameron has said in that regard. It's our bundle of authorities at page 58.
I'm there.
At the foot of the page, paragraph 34, does your ladyship have that?
Yes, I do.
This is what Justice Cameron says. Given that the Commissioner took 4 bad reasons into account in reinstating the employee, but that other legitimate reasons existed that were capable of sustaining the outcome, can it be said that the employer's reinstatement was rationally connected to the information before the Commissioner or the reasons given for it, as Padger requires? In my view, it cannot. It can certainly not be said that the outcome was rationally connected to the Commissioner's reasons as a whole. For those reasons were preponderantly bad, and bad reasons cannot provide a rational connection to a sustainable outcome. Nor does Padger oblige us to pick and choose between the Commissioner's reasons to try to find sustenance for the decision despite the bad reasons. Once the bad reasons played an appreciable or significant role in the outcome, it is, in my view, impossible to say that the reasons provide a rational connection to it. Then he refers to what was said in Patel versus Witbank Town Council, where Tyndall J said the following: they set aside a decision which had been substantially influenced by a bad reason. He asked, Tyndall asked, what is the effect upon the refusal of holding that, while it has not been shown that grounds 1, 2, 4, and 5 are assailable, it has been shown that ground 3 is a bad ground for a refusal. Now, it seems to me, if I'm correct in holding that ground 3 put forward by the council is bad, the result is that the whole decision goes by the board. Well, this is not a ground of no importance. It's a ground which substantially influenced the council in its decision. And Justice Cameron comments, the same applies when it is not possible to distinguish between the reasons that substantially influenced the decision and those that did not. For these reasons, the Commissioner's determination should have been set aside. So one bad reason, which is material, is enough. And if you can't work out which is material or which is not material, then one bad reason is good enough. That's the principle. So we say that if any one of the bad reasons which I'm going to identify was material, then the minister's decision has to be set aside. And the reasons are the traditional administrative law decisions. It doesn't matter whether this is an administrative act or an executive act, they all apply, will be set aside because it was irrational, or because irrelevant considerations were considered, because it was a result of the error of law, or because it was for an ulterior purpose, or because it wasn't authorized by the act, or because it was based on a mistake of fact. Your ladyship is familiar with all of those. All of those apply whether it's admin action or executive action. It doesn't really matter. And so now, what are the 9? The 9 mistakes that the minister made, the 9 errors. The first error the minister made, I'm not in any sequence, but I'm listing 9, is that he wrongly thought that the board is supposed to advocate for nuclear. He wrongly thought that the task of the board is to advocate for nuclear. And you see this at page 262 of the record. Does your lordship still have that? Your ladyship still have that page available?
Yes, I do. It's still open.
Very good. Would your ladyship would go to paragraph 10 again? He says, if you resist nuclear and you're a board member, I fire you simple. You can't be in a board of something you're not advocating for. He thinks, or he thought, that it was the job of the board to advocate for nuclear power. It's not at all. It's the job of the board to stand apart from that debate and to say, is this going to be safe or is this not going to be safe? It is no part of the regulator's function to be for or against nuclear. Its sole function is safety. And so the minister's decision to fire was influenced by an obviously mistaken understanding of the functions of the regulator, thinking they are to be the advocates for nuclear power. They're not. That's the first error. The second error is that the minister wrongly thought that a member can be fired simply for opposing nuclear. And I've shown your lady, he thought if they oppose nuclear, then I'm entitled to fire them. That's enough. And he said that in that same statement, which I've referred to you. You referred your lady again at page 262. Energy and Resources Minister Minister Mantashe says that those who resist nuclear power while serving on the board of the National Nuclear Regulator will be fired. If you
sorry, Mr. Badlander, could that be right? Because the minister knew that Mr. Becker was a member of the KAA that was so opposed to the nuclear.
Yes, but he appointed him. Yes.
Yes.
Yes. Well, that's a strange thing that he did, because his attitude
can that be a ground for? Could be said to be a ground for dismissing him from the board or from discharging him from the board?
It certainly can't be a valid ground for discharging him, because he knew about it when he appointed Mr. Becker. But he says in terms, that's my position. If you oppose nuclear power, you will be fired. If you resist nuclear and you're a board member, I fire you. Simple. That's what he says. So it is, as your ladyship is perhaps suggesting, inexplicable in the light of the fact that Mr. Becker's position was always known. You have to ask, why did he appoint him in the first place? But whatever the reason for that may have been, his attitude is a clear attitude that if you oppose, you get fired. Simple. That's his word. And we say that is a mistake of law, because you can't fire somebody just for opposing nuclear energy. That's an irrelevant consideration. It's not misconduct to oppose nuclear energy. And we say this is a fatal misdirection, because he takes an absolute position regardless of the facts. If you resist nuclear and you are a board member, I fire you. Simple. That's his absolute position. And we say that is irrational. It's not authorized by the Act. It's an ulterior purpose. It's unlawful. I need to show your ladyship what the minister says about this statement, because it's quite interesting. When he's called upon to answer this, he says the following, and it is at page 365. Paragraph 234. Yes, now he's referring to these statements which I've just been showing your ladyship, and he says the following. He says, while I admit these statements are unfortunate, my decision had already been taken, etc. Why are they unfortunate? He doesn't say I didn't mean them. He says they're unfortunate. Why they're unfortunate is because he spoke his mind and they were recorded. He spoke his mind and he spoke the truth at a time when his hand wasn't being held by his lawyers. And he spoke out. That's what's unfortunate about them, but it's not unfortunate, it's very fortunate. Because he disclosed what his real reasoning was, and your ladyship now knows the truth. He thinks that the moment somebody is opposed to nuclear, you can fire them. Simple. The answer is that's unlawful. Simple. So, my lady, that's the second reason. Second error. The third error that the minister made is that he dealt with desirability and safety as if they're the same thing. And could I ask your ladyship to look at our heads of page 77, because we summarize our submissions in that regard there. And this really, paragraph 77.
Okay. There.
And this really also addresses the issue which your ladyship raised. Paragraph 77, the minister attempts to justify his decision by arguing that Mr. Becker's publicly expressing his views on the desirability of nuclear energy is evidence of his conflict of interest. But it cannot be such, where his role on the board concerns safety and his views are about desirability. There is no conflict when regard is had to the object of the regulator on the board. Publicly expressing views about desirability, which may otherwise be held, is not evidence that Mr. Becker will act for the conflict interests when he participates in the board's decision-making, which we know is about safety. And so but the minister has run the two together. His position is that because Mr. Becker is imposed to nuclear power, he will decide that any nuclear power installation is unsafe.
Mr. Butler, I'm not concerned about what Mr. Becker is advocating for. But given the fact that you said the board should be independent and the person serving on the board should remain neutral, is it open to Mr. Becker to be a busybody? One day he's sitting at the boardroom with the other directors, regulating the nuclear energy. The next day he's out there criticizing the nuclear energy, or else disclosing the decision that was taken at the board meeting the previous day. Is it open for him to be a busybody, to be everywhere when he's supposed to be neutral?
Your ladyship might say that he's being a busybody, but he's doing what he's entitled to do. He's entitled to his views. Your ladyship may think it's not a good idea for him to do that. Some people may think it's not a good idea, and some people may think that it's that his views are wrong.
The reason why I think so is because he's supposed to be the face of the board and not be everywhere.
No, he's not the face of the board. He's one of any number of members of the board. He doesn't speak on behalf of the board, and he doesn't. He
doesn't. I do understand that the chairperson is the spokesperson for the board, but he represents the board. Members of the public will see him as the representative of the board, not on the board this time around.
Well, ladies, if they do that, they're wrong. If they do that, that's wrong. It's as simple as that. And he's entitled to his views. He's entitled to articulate and canvass his views. And the point is this: whether it's prudent or wise is one thing. It's a different question whether it's misconduct. The test is misconduct. The test isn't whether it's a good idea or it's prudent or it's sensible. Your ladyship may take a different view as to what is a good idea or a bad idea. But the question is it misconduct? And we say there's no misconduct in expressing your views. Expressing your views on a matter which the board doesn't have to decide. And now this brings me back to the question of Mr. Mapoto.
Yes.
Mr. Mapoto is a member of the board.
Matopo.
But sometimes it's given as Matopo, but I think it's actually Mapoto.
Is it Mapoto or Matopo?
I think I refer to Matopo, but it's actually Mapoto, milady.
Where are you referring to right now?
Can I ask your ladyship to go to page 205 of the record?
205.
Yeah. It's an annexure to the founding affidavit, PB 18.1.
I see.
Does your ladyship have that?
Yeah.
Your ladyship will see this is an article from the Sunday Times, November 2019. You'll see the names there: Zizamele Mbambo, Katsi Mapoto, and Bessie Mahopo. So I got it wrong. It's Mapoto, not Matopo.
Okay.
And this is an article published in the Sunday Times in which Mr. Mapoto plus two others argue that the energy resource plan must include nuclear. That's what this argues. Your ladyship will see the heading to the article.
Yeah.
New energy resource plan rightly includes nuclear as a complementary source. So there's Mr. Mapoto publicly expressing a pro-nuclear view. And if your ladyship will go on 4 pages, page 209, EB 18.2.
Yeah.
Your ladyship will see there's a transcript of a radio interview with Mr. Mapoto on the 15th of June 2020.
Yeah.
And there's Mr. Mapoto making the same argument that nuclear energy is a necessary element and we must develop nuclear energy in South Africa. He's entirely entitled to those views. We make no complaint about it. But similarly, Mr. Becker is entitled to his view that the energy mix should not include nuclear.
But this was before the board was appointed. The board that Mr. Becker was serving on was appointed.
It's before Mr. Becker was appointed.
Yeah.
But this is Mr. Mapoto's views, and he expresses them publicly.
Same applies with Mr. Becker's views. He's against the nuclear, but he was appointed, and also Mr. Mapoto is for the nuclear, and also he was appointed. I would imagine the minister wanted a diverse board.
Yes.
When he made such appointment.
Yes, that's precisely, my lady. And some will be for and some will be against, and that's fine. It's very healthy, and they're entitled to express their views on this.
Yeah.
But and just as Mr. Mapoto does, so Mr. Becker has. And
But
the
now,
minister,
how part of it as to how do you express those views and when?
yes. Well, this is Mr. Becker expresses his views in newspapers and on radio and in speeches. We know that Mr. Mapoto expresses his views in newspapers, on radio. We don't know what speeches he makes. But it's you can't say with respect, well, newspaper and radio are fine, but other methods are not fine. That would not be misconduct.
But you're comparing the incomparables because Mr. Mapoto made those a year or two before the board was appointed. But Mr. Becker made them just days after he was appointed.
Well, as far as we know, he was a member of the board all along. We'll check that.
Mr. Mapoto? Okay.
Mr. Mapoto. We'll check that. We'll check that. But again, that's not the explanation offered by the minister. The minister doesn't say, oh, well, as far as Mr. Mapoto is concerned, he now doesn't speak on nuclear because now he's a member of the board. His job is to deal with nuclear. He's in the department. And there's no suggestion that Mr. Mapoto has now been silenced by being a member of the board. But we'll check when he became a member. And we say that that the minister is, but the underlying problem is the minister mixing up desirability with safety. You're entitled to have a view on desirability, and there's no reason why you can't express your view on desirability. What you mustn't commit yourself on in advance is the safety of any particular proposal which comes to the board. And that hasn't been done because there hasn't yet been a proposal to the board. Mr. Becker never did that. So that's the third error, the mixing up, the confusing of desirability and safety. The fourth error is that the minister wrongly thought that he can discharge a member because he thinks the minister will be biased. And that's all over the answering affidavit. The minister keeps saying when the time comes, he will be biased because of his attitude. But that's not misconduct. You can't. It's actual misconduct which is prohibited.
It's anticipatory. If that
it's anticipatory, and there's no prohibition of you can't have anticipatory misconduct. That's a new thing in our law. And can I just Dana Jr. has helped me with the question of the date of Mr. Mapoto's appointment. The if you go to page 288 of the record,
288.
288,
There.
and then my learned junior is very quick and clever. One day when I'm a grown-up, I'll be quick and clever like him. At the last line of page 288,
Mm-hmm.
you'll see that it deals with the terms of appointments of the NNR board. They're appointed for 3 years, we know that. And Mr. Mapoto is the last one.
Yeah.
1 February to 31 January 2023. In other words, he
Which
was
February,
appointed.
because there's no year there.
Doesn't say that, but it has to be 2020 because they're all 3-year appointments.
Okay.
So we know that he was appointed. And if you just turn over the page,
Mm-hmm.
you'll see, go to the next page, you'll see that there are all these people appointed in 2020 for 3 years. Everybody's appointed for 3 years.
2020, okay.
So if he's appointed on the 1st of February, it must be from 2020 until the 31st of January. In other words, he was already on the board when he made that, when he wrote that 2020, when he gave the radio interview.
Okay.
So that's with respect to answer to your ladyship's question. So I've referred to the question of anticipatory misconduct. There's no such thing in our law, and Mr. De Beer will address that. Then the fifth mistake that the minister made was that he wrongly equated the obligations of a board member with the obligations of a director of a company. He said, "You have not acted like a company director must act. Therefore, you have not acted like a board member must act." He wrongly equated the obligations of a board member with the obligations of a director of a company.
Mm.
But we say that's a fundamental misdirection for 2 reasons.
Mm-hmm.
The first reason is that the regulator is not a company. It's a statutory body. It has a completely different nature from a company. So the equation is simply wrong in law to say one is the other. And we say, secondly, this is not just a question of form, because the duties of these 2 directors are different. The duty of a company director is to act in the interests of the company at all times.
So where is he supposed to benchmark the duties of the regulator director with?
The duty of the regular member of the board is to act in the public interest in accordance with the Act. So it's quite different. One is the company director acts in the interest of the company, and the other is the board director acts in the interest of the public in accordance with the Act. And if there was a conflict between the interests of the board itself and the public interest, then the member must act in the public interest, not in the interests of the board. He's not married to the interests of the board. He's married to the public interest, which is appointed to serve as a member of the regulator under the Act. He must
But
focus
once he's appointed in that position, is he not supposed to abide by the provisions of the Act?
Yes, he must. He must abide by the provisions of the Act, and he must act in the interests of the board. I beg your pardon, he must act in the public interest.
Where is it saying in the Act?
The Act says what the function of the board is, and the function of the board is to determine safety. And that's what he must do. He mustn't do something because, well, this will be good for the board, so I'm going to do it because it'll be good for the board.
I want to be referred to something like the terms of reference of the board members.
Well, what the member, I'll have a look for that, milady.
Yeah.
But
As to how they should carry themselves whilst members of the board.
I don't think there's anything directly stated in the board in the Act, but we will have a look at that and see whether we can find anything.
There are regulations or terms of reference to that effect.
There's nothing. There aren't any regulations. There are various documents which people sign, but those, with respect, don't resolve the problem. We say that this is what the board must do. It goes to section 82A. The board, which means the members of the board, must ensure that the objects of the regulator referred to in section 5 are carried out. That's their job. It's not their job to represent the interests of the board. Their job is to make sure that the board does its job in accordance with the Act. And that's a public interest responsibility. And so we say that the analogy with a company is simply misplaced. Then can I come to the sixth reason?
I think I saw somewhere, I don't know whether it was the minister's heads or the NNR's heads, where they set out the sources of information that the director should abide by. They listed the King 2 report and some other sources that the directors should act in accordance with.
Yeah,
So do you agree with those sources as well?
No, we don't. We say that all of that must be subject to the overall function of the statutory duty of board members. You can't by means of signing a document commit yourself to doing something which is inconsistent with the Act. The Act requires you to ensure that the board does its job properly in terms of the Act. And anything, that's the overriding consideration for anything that you do. Okay. If what you do is not inconsistent with that, then you should be able to do it. So we say that that's this fifth one. Then the sixth one is that the minister wrongly thought it is misconduct for a board member to disclose his views on desirability. The minister wrongly thought that it is misconduct for a board member to disclose his views on desirability. The minister now seems to accept, milady, that it is permissible for a board member to hold views which are opposed to nuclear energy. But what is prohibited, the minister now says, is to publicly express that view and to do so energetically, because that shows, he says, that you're biased. So you can have the views, you can hold the views, as long as you keep them secret. You can be biased, what the minister calls biased.
Is it keeping them secret, or is it acting neutrally as a member of the board?
No, the minister says you must
remember that as a director, you're supposed to be neutral. You are a regulatory body. You represent the regulatory body. So if members of the public see you advocating for a certain discipline, is it going to bode well for the board?
Well, that's not that with respect is not what the minister is saying. The minister says you can hold these views, but you cannot make them public. And we say that is perverse, because if the problem is bias, then if we want to know if people are biased, we don't want them to keep their secrets, their bias secret, or their views secret. It would be perverse to say you mustn't tell anybody your views. You can hold them and you can act on them, but don't tell anybody. That's completely inconsistent with what the Constitution requires of people who hold public office.
Yeah.
We'd require transparency and accountability. You can't hold a view and say, but I'm not going to tell you, because then you'll think I'm biased, because I would be biased. You've got to, disclosing your views can't possibly be misconduct. Disclosing your views is acting transparently and accountability. And again, it comes back to the Mr. Mapoto. Mr. Mapoto can express his views. If a person who supports nuclear can express his views, why can't a person who opposes nuclear express his views? That's a fundamental misdirection by the minister to say that you can't disclose them. Mr. Mapoto speaks on the radio and the newspapers, and why not? The same applies with due respect to Mr. Becker. Then
was Mr. Mapoto not an official of the department?
Yes, he was an official of the department. Yeah. He also wears two caps, just like Mr. Becker. He's an official of the department and he's a member of the board. Mr. Becker is a member of the KAA and he's a member of the board. They both wear two caps, and they express their views as to desirability. and quite rightly so, because it's a matter of public debate, which is very important. Then the seventh of the 9 is that the minister wrongly thought that the board is a representative of the shareholder. And if one goes to page 51, minister wrongly thought that the board is what he calls a representative of the shareholder. If one goes to page 50, one will see that statement. Page 51, I beg your pardon.
Where he was interviewed at the conference.
No, this was the Newsroom Africa interview, radio interview.
Okay. One, yes.
51, and your ladyship will see there's A, and then there's 2 paragraphs, and then there's Q. The interviewer says, are you within your rights to be able to do that? He argues you're not legally authorized to suspending from performing his duties. Answer, no, the board is a representative of the shareholder. Now, that's a fundamental misunderstanding of the relationship between the government and the board. Firstly, there is no shareholder, it's a statutory body. Secondly, a shareholder, of course, has control over what its company does, and is entitled to direct it and say, you must act in accordance with what we say. The government's not entitled to do that. And so what Mr. Becker said, can I show you what Mr. Becker said about that, and what the minister's answer was? If your ladyship will go to page, I'm still on the same page, over the page 52.
Yep.
Paragraph 142.3. The minister has misconstrued and misunderstood the nature of the regulator. It is not a representative of the shareholder. Sorry, my lady.
Yeah.
It's the minister's this is what the allegation made by Mr. Becker. The minister has misconstrued and misunderstood the nature of the regulator. It is not a representative of the shareholder, the government, or himself. And the minister does not answer that. He doesn't say, I do understand. He doesn't say, this is what I meant by shareholder, it means something different. The minister provides no answer. I'm not going to give you, can I just give your ladyship the reference? I'm not going to take your ladyship there.
Okay.
It's your ladyship will find it at answering affidavit, page 361, paragraphs 361, paragraphs 204 to 207.
Okay.
And you will see that the minister does not contradict the statement that he misconstrued and misunderstood the nature of the regulator. The allegation is made, you misconstrued and misunderstood the nature of the regulator. The minister does not contradict that. And that's enough reason for setting aside the decision. The minister got it wrong. He thought this is like a state-owned enterprise, where the shareholder minister can say, you must do what I tell you, because I'm the minister and we're the shareholder. And he's wrong. The board is independent. There's no shareholder, because it's an independent statutory body. That on its own is enough to poison the decision. And because it covers his whole attitude about he's in control. Then the eighth error that the minister made was the minister seemed to think that Mr. Becker has been leading marches. And your ladyship will see that at page 50, paragraph 141, and sorry, page 51.
Okay.
Then where the minister says communities have a right to send somebody else, but you see, look at this guy. They're talking about Mr. Becker. Look at this guy. We go to a board meeting, we take decisions. Tomorrow you lead a march against that decision.
Which paragraph is that?
It's at the top of page 51, my lady.
No, communities have a right.
Communities have a right to send somebody else. But you see, look at this guy.
Okay.
That's Mr. Becker. We go to a board meeting, we take decisions tomorrow. Tomorrow, you lead a march against that decision. How does it look for a board member leading the march against that decision, which is the decision of his board, in the board? But Mr. Becker never led any march against any decision of the board. Mr. Becker says, I've never done that. And the minister doesn't dispute that. Can I just give your ladyship the references?
Was he not just making an example, Mr. Balenda?
He says, look at this guy.
Mm.
Doesn't say, let me give you an example. He's referring to Mr. Becker. Look at this guy. We go to a board meeting, we take decisions. Tomorrow you lead a march against that decision. How does it look for a board member leading that march against that decision, which is his decision in the board? And can I give your ladyship the references? It's Mr. Beck, it's the founding affidavit.
Yeah.
Paragraph 142.4.
2.4, yes.
That's page 52. And again, it's not answering affidavit. Paragraph 204 to 206. Page 361.
361.
361.
Okay.
If I can just read you what Mr. Becker says. Mr. Becker says, fourth, the minister got the facts wrong. I have never led a march against any decision of the board. Mr. Mantashe doesn't answer that. He doesn't say, oh, I was quoting a hypothetical example. Doesn't say I was just referring to the theory. He just doesn't answer it. So your ladyship gives what would have been perhaps a good answer, but Mr. Mantashe doesn't give that answer because it doesn't actually appear from what he's saying. And that brings me to the last of the 9 reasons, and it is an important one, and I need to take your ladyship through that carefully.
Okay.
Because it relates very directly to a reason which was given by the minister. Can I take your ladyship to page 66, PB1, page 66?
66.
Yes.
The discharge letter or notice?
Discharge letter, that's right, my lady.
Okay, I'm there.
Your ladyship will see at the footer, page 66, one of the third reason given by the minister for his decision. He says, you hosted meetings with civil society organizations, either in your capacity as a member on or of the NNR board, and gave the impression that you were acting on behalf of the NNR board with no authority to do so. That's his reason for firing him.
Okay.
Mr. Becker says that's not true. That's not what happened. And if I can take your ladyship firstly to page 23.
Page 23.
Page 23, founding affidavit.
Yeah. There.
This is what Mr. Becker says. He says on 22 July 2021, paragraph 42.
Yeah.
At the top of the page. I had a 2-hour virtual meeting with civil society organizations. I did not do this as a representative of the board, and I did not purport to do it as a representative of the board. Various issues were raised around nuclear safety, and I noted and collated them so as to provide them to the regulator as per the email exchange with Mr. Munsami. And then if your ladyship will go to page 47. Page 47, paragraph 133.
Yes.
Does your ladyship have that?
Yeah.
Minister says, under the heading factual errors, paragraph 133, the minister simply ignored my repeated explanation that I met civil society organizations as their representative on the board. Instead, without any evidence or information must be before him, he took the view that I gave the impression that I was acting on behalf of the NNR board. This is incorrect, as I never did so. Meeting civil society as the representative of effective communities on the board was part of my duties as a director. It cannot constitute misconduct and justify my discharge. Now, the minister does not say where's the evidence that Mr. Becker misrepresented his position and claimed to speak on behalf of the board. There's no evidence to support that. And what makes it worse is that there are 2 supporting affidavits which were made by people who were at that meeting. Your ladyship will find the first one at page 255.
Before you go there, I'm still at page 47.
Yes.
What should I make of that last sentence at paragraph 133? meeting civil society as the representative of affected communities on the board was part of my duties as a director.
Yes. He's a
What should
representative.
I make of that sentence?
That shows that he understands what he's doing. He is representing affected communities on the board. So he must meet them. That's what his job is there. He's there nominated by affected communities, and he's there to represent their interests.
But
so he's
at
their
that
representative
stage,
on the board.
at that stage, what is it that he needed to report to his constituency?
He wasn't reporting to his constituency. He went to his
What is it? I mean, in accordance with his duties as a director, what is it that was already discussed in that capacity that he needed to share with his constituency?
He was sharing nothing, milady. What he was doing is he was going to his constituency and saying, what issues would you like me to raise with the board? That's his job. He goes there, he listens to them, and then
that is not borne out by the article from Energize.
No, with respect, it is, milady. There's nothing in that article which says that he was going and sharing some secret information. There's no evidence that he ever did anything like that. None. He went to his constituency. This is pinned to a particular meeting. They say, at this meeting, this is what you did. And he says, no, I didn't. I went there to say to my constituency, what are the things you want me to raise on the board? Because I am your representative on the board. I'm not the representative.
I would imagine that was the reason he went there, but
yes,
that is not borne out by the article.
With respect, my lady, I must disagree. That he says this is what he did, and is not contradicted by any evidence. The article speaks about his views on which I think is at an earlier stage, speaks about his views about desirability. It goes before all of this. All goes before this. He has his strong views on desirability, but here he's coming to them and he's saying, what would you like me to raise? Let me take your ladyship, if I can, to page 255.
Okay. Five. Mr. Badlander, I've seen that we beyond the 2 times. Are you still going to be long, or should we adjourn and come back? Or what are the other people's feeling?
I will be a while. We're supposed, in terms of our agreed timetable, to have until 12.
Okay.
If your ladyship could,
I'm fine. If you want to proceed without any adjournment, I'm fine with that. But there are other people that we must take into account.
Yes, I'm happy to proceed, my lady. In the interest of progress, I'd be grateful if we could.
Okay then, Mr. Bockstrom, are you fine with that?
Yeah, we're fine with that, lady.
Okay, thank you. You can go to the bathroom, but we won't see you, and you can take your your gadget with because you're not busy with anything right now, Mr. Jamie.
Thank you, my lady.
Yes, Justice.
I'm saying if you want to go and relieve yourself, you are welcome to go with your computer or your whatever gadget you're using.
Oh, I see. No.
Yeah.
Thank you.
We'll proceed with Mr. Badlander and
Thank you, my lady.
Okay, thanks.
As the court pleases.
Then can I take your, thank you, my lady. Take your ladyship to page
255. You said
255.
255. Yeah.
Now, this is an affidavit by Mr. Magwaza, who was at that meeting. This is what he says at paragraph 5.
Yeah.
During that meeting, Mr. Becker did not represent himself as speaking on behalf of the board of the regulator or being its representative, but he made it clear that as our representative on the board, he wanted to hear the concerns of communities potentially affected by nuclear activities in order to raise them with the NNR. Paragraph 7.
Yeah.
At no point during that meeting, paragraph 7, no point during that meeting, nor at any other time, was I under the impression that Mr. Becker spoke on behalf of the board or that he claimed to be its representative. Then if your ladyship will go to page 258, there's another affidavit by Mr. Kukumu from the BEFA. Page 258, he says the following, if your lady, sorry, lady.
Mr. Kukumo?
Yeah, at page 258,
Yes.
paragraph 7.
Mhm.
I confirm that in an online civil society discussion on 22 July 2021, Mr. Becker did not represent himself as speaking on behalf of the board of the regulator or being its representative in any form or fashion. Rather, Mr. Becker was at pains to make clear that as a representative on the board, he would endeavour to raise matters of concern to the communities affected by nuclear activities and civil society as discussed in the meeting via the channels open to him as a director. So that's what he was doing. He was going there to get that information and the paragraph 6, I'm asked to refer your ladyship to. I've always found Mr. Becker to be considered and balanced in his approaches with regards to his role on the board. Despite pressure from fellow activists, he has been consistent in not divulging any details of board discussions and at all times has made clear that his duty as board member prevails. So that's what the witnesses say. None of that is disputed. Nothing. It's Mr. Mantashe ignores it. So he doesn't answer any of this, yet he says you can't, he says in his reasons, if I come back to them now, he says you hosted meetings with civil society organizations and gave the impression that you're acting on behalf of the NR board with no authority to do so. That's his reason. The evidence is that that's not true. There is not one single tiny bit of evidence that he did what the minister alleges. And that's enough to sink the decision, lady. This is a material reason, because it's one that he gave. It's based on incorrect information. Whoever told him that didn't tell him the truth. And Mr. Becker, and the evidence, there are 3 witnesses which tell your ladyship that this is not what happened. And none of that evidence is contradicted. And so we say that's a fundamental material error. It goes to the heart of it. It's one of the causes of complaint of misconduct, and that's the end of the matter. And so we make the submission, my lady, that we come back to what was said by the SCA in the Rustenburg Platinum case. If any one of the reasons is bad and is material, that's the end of the matter, the decision. Here's the clearest possible thing. The minister clings blindly to this allegation of misrepresenting his position as speaking on behalf of the board. There's no evidence. Not only is there no evidence, there's evidence which shows that it's not true. So we say that it is fundamentally that's the answer. That's our closing submission of what the matters I'm going to deal with, my lady. We say there are nine material mistakes which the minister made. They all give rise to grounds of review. Some of them are not even answered. And some of them he actually admits. He effectively admits that he misunderstood this business about the shareholder. He admits that. Or he doesn't admit it, but he doesn't say anything to dispute it. He doesn't dispute that he got it wrong on the question of leading marches. When Mr. Becker says, you got it wrong, I didn't lead any marches, he doesn't say, oh, I was talking about hypothetically. He just doesn't answer it. And so one can go through all of them. I'm not going to repeat everything I've said.
Yeah,
there are multiple.
I've captured everything.
Yeah, I can see that your ladyship is writing energetically.
Yes.
And finally, my lady, all I want to say on the 9th ground is that there is no relationship between the Energize article and the community meeting. The Energize article was held was published on the 30th of June, and he met the civil society on the 21st or 22nd of June. There's some unclarity. July, I beg your pardon. The article was written on the 30th of June, and he met civil society on the 21st or 22nd of July, and so there's no connection between the two, we submit. My lady, may I hand over to my learned friend, Mr. De Beer, for the other, and then I am going to come back very briefly and say something about remedy.
Certainly. Thank you, Mr. Badlander.
Thank you, my lady.
De Beer?
Thank you, my lady. As Mr. Badlander indicated, I'll be dealing with 2 matters. One is the basis on which the minister's decision is reviewable, and the second is this question of an anticipatory, a discharge for anticipated misconduct, which we say is impermissible.
Yeah.
So turning to the first matter, we've address at length in our heads of argument as to why we say this specific power is administrative action for the purposes of the PAJA and therefore subject to the strictures of PAJA.
Yeah.
And I don't intend repeating all of what we said there. I just want to highlight a few matters that we say are important for the proper consideration of this case.
Yeah.
The first thing I want to say, though, is, and we have said in our heads of argument, is that in most cases where one is looking at the exercise of public power, it doesn't really matter whether we're in a PAJA realm or a principle of legality realm. If I can take your ladyship just briefly to our heads of arguments at page 21.
Yep.
It's in a footnote. We've quoted it's footnote 62 at the bottom. And it's the Minister of Home Affairs and Public Protector judgment of it's Justice Plaskett at the SCA. I think he may have been acting at the time, but he's permanently appointed there now. And what he says there is that in respect to the principle of legality, not every ground of review has been defined by the courts with the precision one finds in the PAJA. That said, however, broad grounds relating or going to lawfulness, procedural fairness, and reasonableness of official decisions have been recognized.
Yeah.
Now, of course, I mean, I teach admin law in my part-time, and my students are always very concerned about this. There are slight nuances and differences, but we know that generally questions of lawfulness, questions of rationality, arbitrariness, abuse of discretion, those are all covered equally under the PAJA and the principle of legality.
Yeah.
Really the only two are questions of reasonableness, which is something more than rationality, and what I'm going to call procedural fairness in a broad and expanded sense. What I will submit is that when dealing with the principle of legality, and let's assume that this is not administrative action for now, where a decision is being taken to discharge someone or to fire someone for adverse findings, that attracts the sort of audi altrum patrum principles under natural justice. And that's made clear in the Mutar judgment, which I will take your ladyship to. So the minister's arguments, I'll start with his arguments about why he says that this discharge power is executive action and not administrative action. His first argument is to say that his power to appoint board members is largely uncircumscribed, and therefore the power to discharge board members must be largely uncircumscribed. And there's 2 points to this. The first is that the minister doesn't just appoint directors to the board. He has to go through a process. He has to invite nominations from the public. A panel which includes representatives of parliament, so a separate branch of government, creates a shortlist of not more than 20 candidates. And then the minister appoints a director from that shortlist. So he doesn't have a free hand, as it were. There's a processual constraint there. The second constraint is that the power, a person appointed, it's in section 8.6 of the Act, they must be suitably qualified. And I'll return to it later, but the question of who's suitably qualified is not just a value judgment to be made by the minister, but it requires an objective basis to make that decision. But I'll get to that in a moment. The point I want to make, though, is that whatever the question is of the appointment power, the Act is very clear about in what circumstances the discharge power can be exercised. And we know that because it only gives you 3 grounds to discharge someone. So we say that points towards it being administrative action. The second one is his argument that members of the board must retain his competence. Now, Mr. Budland has dealt with this issue. He dealt with the issue of section 49 of the Act, which gives the minister the override, and how that only deals with certain matters that the minister must make a decision, not the central power. But our point is, and I emphasize it again, that we know that this is supposed to be an independent board. This is not an arms corps or a transnet who's appointed by the shareholder representative of government, with the board being appointed by that. We know that the board is a regulator. It's a statutory body with a very specific purpose, and we know why we want that body to be independent. So we say that the 2 grounds really that are advanced by the minister for why this power is executive action as opposed to administrative action don't really answer the question with respect. And we say that the Mutar judgment is actually quite useful And we would commend your ladyship to have a close look at the judgment. I had a close look at it, and I was very interested to see how Justice Kampepe handled these issues.
Okay.
And it's one of these classic Kampepe judgments.
Is it at page 13 of your bundle?
Yes, I think it starts at page 13, my lady. I'm going to be taking you to certain passages in it. And just to note, the expanded argument here is from page 17, paragraph 36 onwards in our heads of argument. So I'll go through the 5 factors that we say point to this being administrative action, but the first 3 I'll go through quickly. So the first one is that in the Mutau matter, and your ladyship will know, in Mutau, the Constitutional Court held that the power to discharge the directors of Arms Corps was executive action, not administrative action. So that was the dispute there, and Justice Kampepe, that's how the court found, and the majority of the court found. But she dealt with various factors, and again, these are summarized in the heads more fully, but also with reference to the Masetla matter. But we say that the same factors actually point the other way in this case. So the first factor, and we don't need to go there right now, but in Mutau, Justice Kampepe emphasizes that the minister has a supervisory control over the directors of Arms Corps. And we know that because Arms Corps is it's the SOE that's been set up to, produce arms and advance the defense policy of the country. But we know that the board and regular are different because their job, as the minister says, and as the chair says, is not to pursue government's policy on the desirability of nuclear activities and nuclear energy, but to ensure that it's safe. And it also goes back to the international obligation that Mr. Budlander took you to, that the regulator needs to be independent of the bodies that are pursuing these activities. And the minister's department, as he says openly and candidly, they have a very positive view of pursuing nuclear energy. So we say the first factor is that in this instance, the minister does not have supervisory control over the directors of the board. That's not his job here. I've dealt with the second factor already, which is this question of the Arms Corps being an adjunct of the minister's powers to formulate defense policy. Here, it's not about pursuing or formulating the policy regarding desirability. It's to give effect to, one could call it a policy, but the policy of safety, which Parliament has already taken and incorporated into the Act and given it to this independent regulator to do. The third factor is that in the Mutau matter, it was you couldn't just remove the board, any directors of the board because they came in with a funny t-shirt one day, or they shaved their head, or dyed their hair purple. You could only remove them as the minister if there was good cause. And the Constitutional Court defines that as a substantial or legally sufficient reason for a choice made or action. That's in paragraph 54. We don't need to go there. But here we know that there are 3 specific grounds when directors can be removed. And it's similar to judges. Judges can only be removed in limited grounds. It's similar to the Chapter 9 institutions. It's not just a question of good cause, as the Constitutional Court says, a substantial or legally sufficient reason for a choice made or action taken, but there has to there have to be facts to demonstrate one of the 3 requirements before the power may be exercised. I just want to really emphasize this point, and that's the 4th factor. And can we go to page 23 of our authorities bundle, to paragraph 50? 23, paragraph 50. So this is now where Justice Kampepe is dealing with whether or not the discharge power is administrative action or not. And she points out there that for Arms Corps, the minister only needed to demonstrate good cause to justify the termination of services.
There.
But then she says she does not have to satisfy a list of jurisdictional requirements before she can take the decision or demonstrate that a particular ground, such as incapacity or misconduct, exists. And of course, we know here the Minister of Energy has to satisfy a jurisdictional requirement and show that a particular ground exists before he can exercise the power. Now, The minister, in the minister's heads of argument, we don't need to go there, but just to make a reference, Your Ladyship, it's at paragraph 30.1 on page 14.
Just a second.
So apologies, my lady. I have a habit of speaking quickly.
Okay. I'm with you now.
I appreciate it, my lady. I appreciate the nudge. What the minister says there is that the question of whether there's misconduct is subject to what he calls a value judgment. So the minister is going to have to make a value judgment about whether or not there's misconduct. And I just want to make 2 points on the law about this question of a value judgment. So the first is that we know that in the constitutional order, where there's a jurisdictional fact to exercise a power, it's not about the subjective understanding of the decision maker of whether or not the fact existed that counts. In the old days, you had the difference between a reason to believe clause and an is satisfied clause, and in some instances, a subjective understanding would be good enough. But in the Walele judgment, it's at paragraph 60, and we do cite it, and it's not in our authorities bundle, but it is in the authorities bundle of the, I think it's the board. It's a very well-known dicta of Justice Jafta, who was an acting judge at the time. He says there, I can just read it to you. In the past, the city was a decision maker. Ipsa dixit could have been adequate, but that is no longer the position of our law. More is now required if the decision maker's opinion is challenged on the basis that the subjective precondition, the jurisdictional fact, did not exist. The decision maker must now show that the subjective opinion it relied on for exercising the power was based on reasonable grounds. And we know that, so it's an objective inquiry. And then, my lady, a judgment we have cited, which is not in our authorities bundle, and it's in none of the authorities bundle, unfortunately, deals specifically with this question of a value judgment. And I'm going to screen share the paragraph of the judgment. It's Democratic Alliance versus the President. And it's the matter where the National Director of Public Prosecutions, Advocate Similane, his appointment was challenged by the Democratic Alliance. It's a case that deals with a lot of issues, including rationality review. But what Justice Yakub, who wrote the judgment, deals with is, apologies, so I can find it, is this question about whether there's a value judgment and what the court's role is in interrogating the value judgment and review. So in that matter, the question was whether or not Similane was fit and proper to be appointed the National Director of Public Prosecutions. And the Supreme Court of Appeal had held that, well, this is a jurisdictional fact. It must be determined on an objective basis. It's not enough for the president to say, well, I thought that he was fit and proper. So Justice Yakub says in paragraph 23, it is correct that the determination whether a candidate does fulfill the fit and proper requirement stipulated by the Act involves a value judgment. But it does not follow from this that the decision and evaluation lie within the sole and subjective preserve of the president. Value judgments are involved in virtually every decision any member of the executive might make where objective requirements are stipulated. It is true that there may be differences of opinion in relation to whether or not objective criteria have been established, but this does not mean that the decision becomes one of subjective determination immune from objective scrutiny. Just emphasize the point, because whether or not the minister could lawfully exercise his power to discharge Mr. Becker.
Was that from 2013, volume 1, SA 248CC?
Yes, my lady, it's the one that's cited in our heads of argument. I just want to make, yes, it's Democratic Alliance versus the President, 2013-1, SA 248CC. Okay. So
proceed.
We submit that, well, there's 2 points I want to make here. In the broader context, that this points to the power being administrative action as opposed to executive action. But two, just to emphasize, it's not about what the minister thinks, whether Mr. Becker committed misconduct or will commit misconduct, which I'm going to get to in a moment, but whether or not there were objective grounds on which the minister could base that judgment. And Mr. Badland has explained why in our submission, those objective grounds do not exist. The final factor, it's in our authorities bundle at page 22, still in Mortal. My lady, are you with me?
Which page is that?
Page 22.
Okay. I'm with you.
What Justice Kampepe deals with there is this question about this factor about when we're trying to determine which realm of review we're in. Are we going to subject the power to the higher level of scrutiny under administrative law review? Remember, I started my address by saying, you know, they're pretty much the same, the two realms, but there are subtle differences, including for reasonableness is the biggest one. And what she says is that in paragraph 43 at the top of the page, it may be that this level of scrutiny is not appropriate given that the power bears on particularly sensitive subject matter or policy matters for which the court should show the executive a greater level of deference. Now, in that case, it made sense. In that case, you had Arms Corps, which was the body, it's the SOE that has a shareholder, the representative is the minister, that pursues the defense policy of the country. In this case, the National Nuclear Regulator's role is not to pursue nuclear energy. It's not the Nuclear Energy Board or the Nuclear Energy SOC Limited. It's the regulator. And the only point we make on this is that where the board is going to be making decisions about actions that the minister's department himself is pursuing, it's eminently appropriate for the decision of the minister to discharge a director of the board to be subject to higher scrutiny. Because it's not a question of the directors acting on behalf of the minister, it's the directors being appointed, and we know it's perfectly acceptable in our constitutional order for judges to be appointed by the executive, for various people, the public protector, the auditor general. Usually there's parliament involved as well, or the JSC. But where you're removing someone from that independent office, it's more appropriate that that is subjected to a higher level of scrutiny by the courts. We also make the point, and that's why we say it's administrative action. Lady, in our heads of arguments at page 21, I think we might actually be there on the heads.
Mr. Diebe, I don't want to disrupt you because of time.
No. We just quote, it's a recent dicta of Justice Unterhalter, who was acting at the Supreme Court of Appeal.
Which page is that, sorry?
Page 21 of our heads of argument, paragraph 43.2.
Yeah.
It's Chairperson Eastern Cape Gambling Board versus Bukani Gaming. Mr. Jamie and I represented the gambling board there together, so that's why I'm aware of the judgment. It's not yet reported, but he'll also be aware of it. What Justice Unterhalter dealt with there was this question of deference. Now, deference is this watchword in our democracy, this argument about courts must defer to the decision-making processes of administrative bodies. But what Justice Unterhalter deals with there is he wants to try and interrogate what it really means. And he says that when we conjure up the idea of deference, I like how he says whether it's demon or savior in public law, it may be apt to mislead. The ubiquity of its invocation is not always commensurate with its utility. What matters is not any a priori position as to whether a deferential construction of a power is warranted. Rather, the question is to determine the nature and scope of the power, and the court's duty is simply to give effect to its best understanding of what it has found the power to be. And we submit what distinguishes this case, particularly from the Mutau judgment, or the Mutau case, is that the power is not removed for any good cause. The power is closely circumscribed in Section 9. And more broadly, you're not dealing with an adjunct or an arm of government that's pursuing a certain government policy. You're dealing with an independent regulator, which is still a public body, of course, but it's not part of the department. It's not an arm of the minister's department here. So we say that in this instance, deference is not as appropriate as it would be in the case like Mutab, dealing with the matter. And we say there's not much difference, because most of the grounds of review pleaded, the lawfulness issue, the bad faith, irrationality, ulterior motive, mistakes of fact, all of those have been recognized by the Supreme Court of Appeal and the Constitutional Court as grounds of review under both regimes. It's really the question of whether procedural fairness in an expanded sense would be applicable. And I again commend the court to the Mutau judgment. It's at page 28 of our bundle, and it's paragraph 82 and 83. And may I ask your ladyship to turn to those pages?
Page 28?
Page 27, apologies.
Okay.
And it's paragraph 82 and 83. Now, in Mutau, the Companies Act was applicable, and I think it's section 71 of the Companies Act, requires that if you're going to fire a director, if the board is going to fire a director, they have to give the director notice of a meeting where that's going to happen, and an opportunity to make representations. So Justice Kampepe said, well, that had to be complied with here. So, and that's fine, because the Companies Act applied because it was an SOE, which is a company as defined. But then she dealt with the question, well, what happens if this is executive action and there was no section 71 of the Companies Act? Would the former directors be entitled to procedural fairness? And now we know there are judgments which say it's the Law Society of South Africa versus the president, even Allbutt, which is cited here, say that there's a difference between procedural fairness and procedural rationality, and one is available and one isn't. But what Justice Kampepe says here, and it's in paragraph 83 from the second sentence, which I think is very important. Again, it wasn't obiter remark because it wasn't directly relevant to the issue because of the application of the Companies Act. But what she says is this, is that our law has a long tradition, which is endorsed by this court in Muhammad, of strongly entrenching audi altrum partem, here the other side, which is your classic natural justice principle. And then she carries on. It attains particular force when prejudicial allegations are leveled against an individual. It is for this reason that dismissal from public service has been recognized as a decision that attracts the requirements of procedural fairness. Mm-hmm. So our submission is that if the court does not agree with us and says, well, this is not administrative action, mm-hmm. in this particular instance of an exercise of, let's say, an executive power, because prejudicial allegations are being leveled against Mr. Becker, it required audi altrum partem in natural justice. Mm-hmm. And the minister and the heads of argument cites the case law that says it's not applicable in the principle of legality. But in fact, in this matter, the minister must have known this because he purported to give Mr. Becker some kind of a process because he asked for it.
I was going to ask you that because the process started in January. So I was going to ask you as to what do you make of that process?
Well, our complaint about that process that Mr. Badlander has dealt with is that it wasn't a real process, because it starts in January when the matter becomes settled and he asks for representations. Yes. But before that, he's already made comments saying, Mr. Becker's gone and getting rid of Mr. Becker. And that's not proper procedure.
That's not audi altrum partem. It was tainted by those comments that he made publicly.
It's a predetermined decision. It's saying, I'm asking you for representations, but I'm not even going to, well, we don't know if you read them or not. We don't know that. But it doesn't matter what you say to me because I've already made my decision. And of course, then what's the point of having the process?
So what makes it not to be procedural then?
Because the procedure is unfair, because I'm making representations, but you've already made up your mind. And because you've already made up your mind, no matter what I say, no matter what my explanation is, you're going to make the decision anyway. And then we're just going through this as a checkbox exercise, which is not what procedural fairness is about. Procedural fairness is supposed to be an opportunity for a decision maker to say, I'm thinking maybe I might make a decision. I want to hear what the facts are. I want to hear your side so I can make an informed decision. That's one of the values of why we have procedural fairness.
But the minister didn't make a decision before Mr. Becker submitted his submissions that were requested for.
As Mr. Butland has taken the court too, we say that radio interview is evidence that he'd already made up his mind. He's already made up his mind. He may have not formally made a decision. He didn't say, here's my decision, give me representations. He'd already made up his mind. And he was going through the motions. He was, we'll give him representation so you can't challenge me on a procedural fairness basis. But that's not good enough. That's not what our law requires of procedural fairness. So for those reasons, we say, one, this is administrative action. PUDGA applies. If it doesn't, it's still the exercise of public power. It's still reviewable under the principle of legality. And of course, and not of course, but just to emphasize that in this type of case, the natural justice ad partem would apply.
Okay.
So that's my first topic. The second topic is not as long, but it's just
anticipatory misconduct.
Anticipatory discharge, or a discharge in anticipation of misconduct. Now, lady, there's three propositions I want to make up front that inform all of my arguments here. Now I'm going to return to them at the end. The first proposition is that there's no evidence of Mr. Becker actually having committed the misconduct complained of. There's no evidence of him participating in a board decision-making process where he brought irrelevant considerations into the process. And there's no evidence of him having some bias in a decision-making process, as the minister says in the heads of argument now. And the reason is because he was suspended and then he was discharged before any of those decisions were made by the board. The second proposition is that there's no evidence to demonstrate as a matter of fact how Mr. Becker would or would not act in those processes. And the third proposition is that there's no facts or evidence on which an inference can properly be drawn to the effect that he would actually commit misconduct. So,
but as I said earlier on, it really it depends as to how do you define misconduct.
Yes, my lady. That's a very useful question. I was about to turn to how we define misconduct.
Okay.
Now, we accept, and I think this is normal, that the Constitution speaks about removing an Auditor General for misconduct. It doesn't then say misconduct means X. Misconduct may be a wide variety of matters. We accept that. But there's one important thing that misconduct has to be, and that's conduct.
It has to be inferred.
The term. It has to be something that's actually happened. So misconduct has to be conduct. And just basic principles of our law. If I I have an insidious intention of murdering someone, but I never follow through with it, there's no conduct. There's no actus reus, as the Latin, the Romans used to say. But I had this insidious intention. I just never followed through with it. Of course, that's not a crime. It requires conduct. And what's quite useful is that both the minister and the board give us definitions of misconduct, which all relate to acts. So if I can ask the court to go to the minister's answering affidavit. It's at page 324 of the record.
324. There.
Paragraph 49, the minister quotes a definition from the Institute of Directors for South Africa. And I'm not saying we agree with this definition, it's just an example. But the point is, it says it's any action by a director, ... And later on, whether or not the action was willful, intentional, or unintentional affects the degree of sanction, ... So misconduct is not something that may happen, it's something that's already happened. In the chair, the board and the chair's heads of arguments, let's just find my reference quickly. At page 25 of their heads.
Of the board's heads?
Yes, of the board's heads.
Paragraph?
Paragraph 66 at page 25 of the board's heads.
Okay.
They quote the legal Merriam-Webster legal dictionary definition. Now, of course, we don't, when we interpret statutes and when we interpret contracts, we don't always look at the dictionary, but sometimes we do. And again, just as an example, again, it's intentional or wanton, wrongful, but usually not criminal behavior. Something that's happened already. It's not something that might happen, that may eventuate, that can be construed as misconduct. My lady, are you with me?
Yes, I'm with you. I'm looking at that Merriam-Webster legal dictionary definition.
It's quite a lengthy definition, but
Yeah.
what your ladyship will see is that it's always about behavior, something happening in the real world. It's not something that may happen that's misconduct.
It's violation of standard of conduct by a government official or
Yes.
wrongful behavior and so on.
Yes. So what I'm addressing is this argument that the minister, this contention of the ministers, and I think it is in his reasons. If I can just, sorry, I must just find my record quickly. It's at the famous page 66, which I think we're going to be returning to a lot.
Mm. Which paragraph in page 66? The C paragraph.
16B. I think 16B is where the minister articulates this.
Okay.
Are you with me, my lady?
Just give me a second. And then?
So what the minister says, speaks about the public opinions being vocalized by Mr. Becker. Then he says there can be little doubt on how you would vote, were you still a member of the board, when the question of the lifespan extension of Kuberg Station comes before the board. There is little doubt on how you would vote. There's no evidence. There's no evidence to demonstrate how Mr. Becker would or would not vote. His public statements are not conclusive evidence of how he would behave in the future. Mr. Becker was never, I don't want to be crass, but he was never given the opportunity to commit misconduct or to conduct himself appropriately. He was fired before he could do so. And our submission is the minister there was no basis in evidence, nothing before the minister can actually allow him to reach the conclusion that there can be little doubts about how Mr. Becker would or would not act. We don't have to go there, my lady, but just it's interesting. The chair actually accepts in the heads of argument, it's paragraph 38 at page 18, that the statements he made are not conclusive evidence of how he would vote. They then say later, yes, but if he was participating in the board, he would vote a certain way. But with respect, that's correct. No one knows how Mr. Becker would have voted or acted in those decisions because he never had the opportunity to do so. Maybe just to go back to what Mr. Budlander emphasized, the other members of the board have also expressed public opinions concerning the desirability of nuclear energy. And there's one matter that Mr. Budlander didn't take your ladyship to. It isn't a replying affidavit, but I don't think it's disputed by anyone. Certainly no one's come in the sort of tongue-twish line and asked for leave to file a further affidavit. But it's the annual report that the regulator gives to Parliament. The annual report from May this year. Take your ladyship there. It's Annexure RA1 at page 692 of the record.
There.
So this is now the executive statement that went with the the annual performance plan that the regulator gives to Parliament. I just want to get the right date. It is in the affidavit. It's the 6th of May 2022 is when it was filed with Parliament. And it's signed by the chair, Dr. Motshudi. And what the chair says at the bottom of the first column, outward looking, the pending decision for the approval of a plan to procure 2,500 megawatts by the Minister of Mineral Resources and Energy of August 2022 remains of interest to the NNR. And that's, of course, the 2,500 megawatts of nuclear energy. And there's all fine there. It's of interest to them. Of course it is. That's their job. We got to check out what decisions are being made and make sure it's safe. But then the chair continues. However, the resistance by civil society compels, the chair says, the regulator to further external stakeholder engagements, and this is what I want to emphasize, to make the public more aware of the vital role of nuclear power in the country's clean energy technology and in the energy mix. This is an official report from the regulator, which is the board, as Mr. Badlander explained, to Parliament saying we need to have stakeholder outreach to promote the vital role of nuclear energy in our energy mix. The only point I want to make is what's good for the goose is good for the gander. If other members of the board are allowed to express public views, and not just in newspapers, in an official report, expressing a positive view of nuclear energy, Mr. Becker is allowed to express his views as well. And I would imagine this executive statement comes from somewhere, from the resolutions that were taken by the board. I don't think the chairperson can just do an executive statement like this without any source. Well, lady, I accept that and I agree. If it's coming from the board, that means the board, who the minister said time and time again, and the board in its answering affidavit, no, we are just neutral. We maintain neutrality on the desirability. But here the board is not maintaining neutrality on desirability, but is actually expressing a view in favor of nuclear energy. And as I say, they need to go out and conscientize the people about, they need to have stakeholder engagements about the desirability, something to that effect. But my lady, that's precisely my point. Their role, according to them, according to everyone here, is not to be having engagements about desirability, to be promoting desirability, to be promoting, quote, the vital role of nuclear power. Their role is to ensure if nuclear power is being pursued, it's done so in a safe manner. And this is, if that's the function of the board, this on the argument that the minister and the chair make here about why Mr. Becker committed misconduct, so has the rest of the board. But I don't think, I want to correct myself, I don't think it's desirability, it's energy technology and the role of the nuclear power. They're not saying anything about the desirability. They chose their words correctly. My lady, with respect, I have to strongly disagree. The paragraph starts with reference to the decision for approval of a plan to procure additional energy. The board is absolutely taking a view on the desirability here. The board is not saying we're going to go out and promote safety and promote stakeholder engagement on the safety of nuclear energy. The board is saying this in the context where they're referring to a decision of the minister to take more. And our point would be this. I don't want to say it's the decision of the minister because we don't know what was discussed at the board level for the executive statement to be made like this. We don't know, but we don't know what was discussed. With respect, my lady, we don't need to know because it's clear. The point I want I can't say this comes from the minister. No, coming from the board. Apologies, I don't mean from the minister, my lady. It's not about the minister. It's about the board taking a view on desirability. And my point is this: the argument about the anticipatory misconduct for Mr. Becker is you've taken a view on desirability. There's no doubt about how you would act when decisions are made about the licensing. Therefore, you've committed misconduct. And the same applies here. The board has taken a view on desirability. The same, if one uses their argument, there's no doubt about how you would act, and therefore you've committed misconduct. And the point is they haven't committed misconduct, and neither has Mr. Becker.
Just wrap up, Mr. Shaw.
That's my final point, my lady. My point is that there's no evidence because of Mr. Becker actually having committed misconduct. There's no evidence to demonstrate as a matter of fact how he would act, and there's no facts on which an inference can be drawn to that effect.
Okay.
You can't discharge someone for misconduct that may or may not happen. That's not what the power intends.
Thank you, Mr. De Beer. Mr. Badlander, do you still want to come back?
Lady, may I just, I'm sorry to intrude on my colleague's time, but may I just take 5 minutes to say something about remedy?
Okay.
Lady, there are two matters I need to deal with. Firstly, the minister clearly recognizes that there is a problem, a fundamental procedural problem in his decision.
Mm-hmm.
And so what the minister says is that if the court finds that there was a procedural defect, then the court shouldn't reinstate Mr. Becker anyway.
Mm.
Because the minister says he had a good reason to dismiss Mr. Becker, and because he doesn't have confidence in Mr. Becker, and Mr. Becker doesn't have a good relationship with the board.
Yeah.
But this is an argument that procedural fairness doesn't really matter if the minister had valid reasons for the decision.
Mm.
That's an argument which we submit would mean that you could never bring a case and succeed in the case on procedural requirements, because what you have to do is go and look at the merits as to whether there was a good reason for the decision. If there was, then procedural unfairness doesn't matter. It would mean that the constitutional principle of procedural fairness would be a dead letter. It would have no effect. And we say the argument is with respect unfounded. If the decision was procedurally unfair, it ought to be set aside, and it can't be saved by the fact that the minister thinks he had good reasons anyway.
Mm.
Secondly, we say that, and this also similarly, it can't be saved by saying, well, I don't have confidence in Mr. Becker, or Mr. Becker doesn't have a good relationship with the board. That's not the question. The question is whether a valid procedure was followed, and if a valid procedure wasn't followed, the decision must fall. Secondly, otherwise it is a license for unlawfulness in all processes. We just ignore the process because we'll say, what I want to raise is this, that Mr. Becker, as we know, was appointed for a 3-year period.
Yes.
Now, if your ladyship finds that his discharge must be set aside,
Mm.
then the usual rule, the default rule, is that it's set aside retrospectively from the date it's been invalid from the date when it was made, the decision.
Yeah. Mm.
And so it would go back to February. But the problem with that would be that then that would mean that Mr. Becker has in law continued to be a member of the board since he was discharged in February.
Yeah.
Because the February decision was set aside.
Mm.
And the result would be that his mid-year term, his 3-year term, has been running in all these 8 or 9 months until your ladyship gives the decision. Although he was fired, now as a matter of law, he was in office and his 3-year term runs. And we say so the result would be that Mr. Becker wouldn't have a 3-year term. He'd have a term which was cut short by the period from the time when he was discharged until your ladyship made her decision. And that obviously wouldn't be just and equitable. If he's entitled to a 3-year term, he should get a 3-year term.
But they said this court is not competent to grant a decision if it finds in favor of Mr. Becker that his term be extended beyond the term of the current board.
Yes, we make a different submission on reflection. We say that what your ladyship should find, if your ladyship is with us, is that the discharge operates only prospectively, that the decision operates prospectively.
Okay.
And so the result of that is that he has been out of office for the last 8 or 9 months, and now he's 3 years, and that interrupted his 3 years, and so now it continues. And so he will get his full 3 years because he gets it for the few months he had after he was appointed, and then it's interrupted, and then it resumes after your ladyship's order takes effect. And that's what is permitted by section 172, 1B1 of the Constitution. Because what the section says is that, I can just get there. It says that the court may make any order that is just and equitable, including an order suspending the declaration of invalidity for any periods and on any conditions, or an order limiting I beg your pardon, an order limiting the retrospective effect of the declaration of invalidity. So your ladyship could say, I declare it invalid, the decision invalid from today. It takes effect today, and the result will be that Mr. Becker has served a few months before he was suspended, then it was interrupted for 9 months, and now he continues to serve.
Okay.
And the effect of that is he will serve his full 3 years without your ladyship having to change the statutory period. Your ladyship will just say that 9 months is excluded. Thank you, my lady. Those are our submissions.
Thank you, Mr. Butler. Thank you so much. Counsel for the Minister.
Thank you, my lady. Lady, we intend to deal with a few different topics, and just as a headline, there's 7 issues. The first, just to make some introductory comments. The second point we'll deal with is to highlight what the case is not about, and we submit that there's several issues that are raised by our learned friends, which, with respect to our red herrings. The third is to turn specifically again to the minister's reasons. The fourth, very importantly, is to look at the conduct of Mr. Becker. And this is something that we submit has not been dealt with particularly by our learned friends. It seems to be something that they have rather shied away from, and we understand why that is. We then look at the bases of review and the level of scrutiny.
Where's the girl with camera? Oops.
The procedural arguments, and relief. But to start with those introductory comments, and perhaps it's apt to remind ourselves that in these matters of legal analysis, it always seems to me that they're perhaps 2 great sins. And the first of those is complicating the simple, and the second is simplifying the complex. And with respect, while this matter certainly has its complexities, and it's replete with far-reaching allegations of mala fides and abuse of power, at its core, we submit as a more prosaic question about the applicant's conduct, which needs to be the center of this case. And that's his conduct while he was a director of the National Nuclear Regulator. And more specifically, we say that there needs to be a cognizable review basis shown by the applicant to interfere with the minister's determination that Mr. Becker's conduct amounted to misconduct, and that as a result, his continued role at the regulator is untenable. To contextualize an assessment of Mr. Becker's conduct and why it amounted to misconduct, we submit that we need to start, again, very sensibly, with the Act, and to look at what conduct was expected of him. In this regard, we ask if we can turn to Section 8 of the Act, and my junior is going to put that up. Sorry, my lady, I actually suddenly realized as I'm sitting here that when I ran to the bathroom earlier, I took off my gown, and I've forgotten to put it back on. So I really do apologize. I mean, no disrespect by that, but if I can rather ungraciously just disappear for a moment. There we go. I apologize. Right, so if we can then look at Section 8 of the Act, and that's been put up on your screen, and we've had pointed out that 8.4a, there are different types of representatives that are appointed, one for communities. Reference has been made to 8.6, which shows that the person must be suitably qualified. But what we submit is more important here is to look at the conduct that's expected after the appointment, and for that we need to start at 8.1. And what 8.1 highlights is that the regulator is governed and controlled by a board of directors.
Yeah.
So as a director, you have a direct stake. That's your interest, your key interest should be the proper governance of the regulator and control over its functions. If we then carry on and we look at Section 8.2, that then indicates that how this governance and control function is achieved, and there are 2 roles there in A and B. The first one is ensuring the objects of the act of the regulator. Those are the ones in Section 5, and the second is then a broader general control function over the NNR's functions, and those are the functions in Section 7. And then if we turn to 8.3, we see there again that the board represents the regulator. So as a member of the board, your interests are to ensure governance, and to understand that you are a representative of the board. These statutory provisions we submit significant for two foundational reasons, and we submit that Mr. Budlander suggested that we had misunderstood the duty, Mr. Becker's duties to the board and his public duties, but we submit that they are both. There is, first of all, a duty to the board.
I would imagine, Mr. Bockstrom, you'll enlighten me on this question, because I asked Mr. Budlander whether Mr. Becker was not representing the board.
Yes.
When he made those comments in that meeting.
Yeah,
because 8.3 says the board represents the regulator. I asked whether he was not the face of the board. He said no, he was not representing the board at that stage.
Later, we will get specifically to the meeting, and we will submit that quite properly. The minister found that there was at least a confusion created by Mr. Becker that he was representing the board, and then that was entirely inappropriate and misconduct. But what I'm focusing on that is perhaps just an antecedent question, just to understand what his conduct was and what his duties were. And the first is a duty to the board, that when you accept a position as a director of the regulator, your interests are those of the board, its governance, and the performance of its functions. And you can finally dissect your roles and actions as a director as much as you want, someone on the board or a representative of the board. But the constant in all of these matters must remain that you accept a duty to act in the interests of the N and at your lodestar, your guiding light is to act in the interests of the regulator. The concomitant is that you cannot conduct yourself contrary to the regulator's interests or processes, and you can't use your position to pursue or promote other personal or political interests. So as a baseline, your duty to the NNR, and not just as it is, and to avoid conflicts against the interests of the NNR, just like any other director of any other company. The second foundational point that we'd point to, though, is that unlike directors of other companies, Mr. Becker's obligations in respect of the regulator go deeper, they're more profound. And that's because he is not only duty bound to the regulator, but he's also accepted a position of public trust. He's accepted a public function of ensuring governance of a public body centrally involved in ensuring public safety. And again, if we look at section 8.2a, as we looked at earlier, we see that there's this twin role of the regulator. The one is ensuring the objects of the regulator, and what we see there is that the regulator then is not just a control body. It is more than that. It is a body that actually performs functions, and as Mr. Butler quite rightly pointed out, its key function is issuing authorizations, and in doing so, in issuing those authorizations, Mr. Becker and all the other members of the board are exercising a public function. The central decisional reference in all of those decisions must be safety, and that is the mandate of the board. And any decision must be confined to those to the parameters of the Act. And in particular, if we can then look at Section 5 of the Act, which deals with the objects of the regulator, and Mr. Budlander has already referred to these. We can just, if we can look at them again, though, what becomes important is that 5A it talks about proactive steps to provide for protection. 5B, C, and D are about nuclear authorizations and the enforcement of those, and those are all the key determination in those we see over and over again is safety. Exercise 5B says exercise regulatory control related to safety over various activities through the granting of authorizations, and we see that safety then is your key decisional reference. So when you accept a position as a director, these are your twin intertwined fiduciary responsibilities to the board and to, without being too grand about it, constitutionalism, a public role to exercise your public powers properly. Part of this public duty is one owed to all applicants for nuclear authorizations. And we might highlight here, including ESCOM. when you are exercising your program. That means that when you, for instance, consider any nuclear authorization, it must be based solely on an engineering safety case. If your ability to exercise that power, to make that determination, is compromised or infected by other considerations, you're failing in your trust as a holder of public power. And with respect, we submit the great irony at the heart of this matter. Mr. Becker seems to insist that when the minister exercised his powers to dismiss him as a director, the minister was constrained by the requirements of lawfulness and fairness, etc. And we have no problem with that. The minister is happy to be bound by the constitutional limits on power. But what Mr. Becker seems to fail to understand is that the same applied to him when he took on his role on the board. He too accepted a public obligation to make his decisions lawfully and fairly to all. And as we said, this obligation of fairness, if we take the example of Eskom and Koeberg, included an obligation to Eskom to consider Eskom's applications fairly when it applies for the extension of the lifespan of Koeberg. The problem that obviously arises there is that Mr. Becker cannot do so, because he cannot consider it based with an open mind. Because what we see is that he has clearly expressed an a priori assumption that all right-minded people must have some sort of principial objection to the extension of the lifespan of Koeberg, that there's something fundamentally that cannot be allowed in that. And as we will show when we look at his conduct, what we see coming over and over again is this idea that Mr. Becker repeatedly has, that his political views on desirability or non-desirability, at least, of nuclear energy, his objections to the extension of the lifespan at Koeberg, these infect his decision-making. He can't escape them. He seems, in fact, to think that it is good that he brings these matters to his determinations by the board. And we submit that that is wrong. And so when and we'll look at the articles later, talks about that decisions of the board must have a moral component, a social component, an intergenerational ethical component. We submit that what is quite clear.
Just a second, Mr. Bookstrom. I'm just thinking, was it not going to be proper for Mr. Becker to bring his views inside the board so that the safety standards of the extension could be reviewed or could be considered?
Yes.
Well, is it for him to go outside and make public pronouncement on his views without taking them to the board, at least to be heard?
We submit, of course not, and we submit that it's not a matter of just not being a busybody. What we see here that is more important is that what he is effectively admitting to over and over again is that his political views are going to shape his views on safety and predetermine a result. Now, it's one thing to say that, well, because I think that nuclear energy is such a dangerous thing, that I'm going to really hold the board to the line on issues of safety. But that is not what he is doing. What he has done over and over is he has gone out. He has indicated quite clearly he cannot decide issues about Koeberg. He cannot decide issues about the opening further nuclear power stations because he has a principled objection, and he seems to think that he can bring that up as part of his determinations before the board. And we'd also point out that Mr. Becker also, as a community representative, has a duty to all communities accepted by nuclear power. That might include those of us who think that if Koeberg is safe, we quite like the idea of remaining in place, because that's better than the idea of our children learning by candlelight in the near future. He also has the duty to respect the policy of the democratically elected government, which wishes to include nuclear energy where it is safe. He can exercise that mandate, the safety mandate, with vigor, and we have no problem with that. But what he cannot do is to allow his political views to create to program the outcome of his of decisions that will serve before him in future. And so then if we just turn to what this case is not about, and we see that a key argument by Mr. Becker is to try and flip this argument rather cunningly and to suggest that Oh, it's in fact the minister who is entangled. His these ideas about political views on nuclear energy, the desirability question broadly, and questions of safety. And we're told that this is really actually a key error in the minister's decision. We submit that's not correct at all. We take particular note, and we would agree with Mr. De Beer in his presentation, that he pointed out that the board is not making decisions as a policy adjunct. These are technical decisions based on safety. We submit that the minister understood this. The minister understood the difference between safety and desirability. And the minister says that he has always understood this. And that's precisely why he appointed Mr. Becker in the first place. He didn't see that Mr. Becker holding contrary views about desirability was somehow a block to him ever serving on the regulator. But what the minister did, I believe, and we submit that quite rightly so, is that Mr. Becker would understand that after his appointment, he couldn't continue going around trumpeting his views about the non-desirability of nuclear energy. When he is sitting on a board making determinations of safety, he cannot carry on like that. But more than that, we submit that his statements indicated that he was really the one who entangled his political views and his role on the NNR. And his conduct, in the minister's estimation, shows that his political views would, as we say, program his views on safety. Now, in disentangling the political views about nuclear energy in Koeberg and then the safety mandates on the other hand, we submit that if we do disentangle, we see that what this case is really not about. And the first issue that we'd point out is that this is not a case in which this court is asked in any way to scrutinize the legitimate source of governmental policy that nuclear energy should form part of the so-called energy mix in South Africa. And the lady asked for a source of statements that were made by people in the department. That is in Annexure SGM 1 to the answering affidavit of the minister at page 373. We don't need to go there. It is called the Integrated Resource Plan of 2019 of the department. And we see there's what is known as Decision 8. And there is a policy-based decision of the government of the day that nuclear energy must form part of the energy mix. And that with respect must be accepted, and it's something that is not before this court. This court is also not a case about whether the extension of the lifespan of Koeberg after 2024 is a good idea or a bad idea. Mr. Becker has shown his view that he would not be capable of making that decision. That's a problem for him, but the question is not whether he is actually right or wrong in his determinations in that regard. Third point we'd make is that the case is not about whether people who are appointed to the board can have political views about the use of energy before their appointment. In fact, Section 8.6 provides that people we see must be suitably qualified. That means that they must know something. We'd submit that anybody who is appointed to the board and is suitably qualified would probably have some opinions about nuclear energy. So the fact that he knew something, the fact that he had beliefs or that he had strongly held views didn't exclude him from being a member of the board. And we see that the minister again explains that he always understood that Mr. Becker had these views, but he didn't think that necessarily excluded him from serving. Mr. Budlander says, well, this is a strange thing that the minister did, as if it's something that cannot be explained. And well, it can, of course it can. There's nothing strange about the minister's behavior. The minister understood and believed that people could have views, but that you couldn't bring those to the board and use them to start shaping and programming your decisions on safety. And we submit that, in particular, we'd just like to refer you to when Mr. Budlander said that this was a strange thing, and then he referred this court to page 365 of the record, where he there is a reference to the 7th of May interview on which a great deal of store is placed by our learned friends, and what the minister meant by that. And they keep on saying that the minister's statements are unfortunate, if we could just go back a paragraph in that, what the minister says is that the comments were made in a wide-ranging address in the heat of political conference in response to the applicant's criticism of me. My phrasing may have been indelicate, but I note that I did not intend to suggest that members of the NNR would be removed for holding personal views on the desirability of nuclear energy, which were different from those of the government. As noted, I appreciate that members of the board can have divergent private opinions in this regard. All that I intended to indicate was that if board members used their positions on the board to deliberately frustrate the government's plans, they would face discharge.
Which paragraph is that?
Sorry, that's page 365 of the record, paragraph 233, okay. 233 of the answering papers. So what the minister quite clearly states there is that he doesn't have a problem with you having private views, but if you start using those views, those political views, to program your determination on safety, well, then I will fire you. And there is nothing wrong with that. In fact, the minister is quite right to do so, because somebody who starts using their political views to shape a determination on safety, it would be acting ultra vires. They are basing it on the determination which is not before the board. The board is not designed to deal with those sorts of issues. It does not deal with, in Mr. Becker's words that he later uses, moral issues or societal issues or intergenerational ethical purposes.
I would imagine, Mr. Bockstrom, that Mr. Becker is not precluded from airing his views at the board level. But also it would depend whether he comes up with motivation for his views.
What he says at the board level, and we would agree with that, is different. But what we will point to is that in one of his dealings with the board, what we see again is the fact that he confuses his role, that he thinks that he is allowed to include what we would say are improper determinations to make a safety decision. And when this is pointed out to him, instead of looking and accepting that, he doubles down. He said he effectively starts suggesting that it's entirely inappropriate to tell him that he can't take those improper considerations into account. So then, Justin, the matter is not about holding his views. It's also, we would submit, the case is not at all about whether members on the board, whether the same action should have been taken as members of pro-nuclear views. It's a false analogy, we'd say. As we pointed out, the government is entirely entitled to have views on the desirability of nuclear energy. What would create an analogy if people who said that they generally support the idea of nuclear indicated that they were so pro-nuclear that, in fact, that would chisel away at their determinations on safety matters. Then that would, of course, be inappropriate. None of them have said anything like that. And that distinguishes them from Mr. Becker. The people who Mr. Mopotso, who's referred to, explains government policy. He's the chief director of nuclear safety. It's hardly surprising that he agrees with government policy or that he expresses government policy and be acting improperly if he didn't. He never suggests in any way that this will program his determinations of safety. And as we will show, Mr. Becker's conduct is quite different. His conduct shows that improper determinations, political determinations about the desirability question are programming his view on safety. The case we submit is also not one about dissent or shutting down a critical voice. In fact, lady, we submit that on this regard, Mr. Becker scores something of an own goal. He acknowledges that he intended to use his position, and in the heads of argument, it's stated in the applicant's heads of argument, to raise challenging questions about the use of nuclear energy. Well, my lady, that's precisely the problem. That's precisely the sort of thing that he should not have been doing on the board. That's not what the National Nuclear Regulator is about. It is about safety. It's not a place to raise challenging questions about the use of nuclear energy. If you want to raise those sorts of questions, you need to do it elsewhere. If you bring that into the board and bringing that into your determinations on the board, you are acting unlawfully. And Mr. Becker doesn't seem to have understood that. So it's not about silencing his voice. It's just about holding him as a vessel who holds public power to exercise that public power based on the statutory parameters, the statutory determinants. The case is also not one about free speech. Mr. Becker seems to think that there's something, well, Mr. Budlin said perverse or peculiar about saying that he couldn't express his political views while he was a member of the regulator, and that it's some sort of hypocrisy to suggest that he should just keep them to himself. But there's nothing strange about that at all. And as I would submit, as a judge, you'd be familiar with this, that when you take on a position, a public position, in which certain matters might serve before you, it's entirely inappropriate to go running your mouth off, trumpeting your political views, which will at least create a reasonable apprehension in the minds of the public that these issues are going to shape your decisions. Of course, you're entitled to your personal views. When you take on public office, when you take on a duty to make decisions in the interests of the public, you lose your ability to go and to effectively trumpet your views and create confusion about how that will affect your decision making. But what we submit here is that in any event, that all distracts from the real issue. The real issue is not even about him having views, holding views, or even expressing them publicly. The question is really that his conduct, Mr. Becker's conduct, shows that he could not disentangle his political views from his determinations on safety. We then saw an argument that was raised by Mr. Budlander today that in an attempt to extract, I suppose, what they think is the minister's real reasons, and it is now pointed out that the minister suggests that he saw the board as shareholder representatives, and we were referred to a particular passage in the interview of the 7th of May. What the minister was asked about there was a power to suspend. So page 51 is that the extract of page 51 of the bundle of the record. We see that there's a question asked, are you within your rights to do that? He argues that you are not legally authorized to suspend him from performing his duties. That's the matter that was before court at that stage, whether Mr. Becker could be suspended or not. Mr. Becker challenged whether the minister had a suspension power, and the minister then responds to that question. We submit that the minister did not indicate a view that the board was somehow beholden to him or his representatives. On the contrary, the minister's entire answering affidavit begins by an extensive analysis to show that he welcomed people who had different views about nuclear energy on the board, because that would be they might hold the board to determinations on safety. But what he did not welcome and what he did not expect and he could not tolerate, quite rightly, was when people started using their powers for inappropriate reasons. If we then turn to the minister's reasons, and we would agree that the minister's reasons must be based on those in Annexure PB1 to the founding affidavit, page 61. That's the 25th of February letter of the minister stating his reasons. And we submit that it's quite clear from this that the minister made it clear that Mr. Becker was not being punished for holding contrary views to the state on nuclear energy and its desirability. What the minister does instead is it starts, and if we can start at page 63, and we see that what the minister does in paragraph 8 is he points about subsequent to your appointment. So this is what he's dealing with, and what he deals subsequent to your appointment as a director, you proceeded to conduct yourself in a manner that was of concern to the NNR. So it's not about him holding views or even expressing views. What it is, subsequent to his appointment, there was this conduct, which is problematic. And if we can see that that is then taken further in paragraph 15 on page 65, which we submit is important to understanding the minister's reasons, which have stayed the same. And we see that 15A on page 65, while you are appointed as a director, you represent all communities and not just specific groups of sectors. Your conduct should therefore reflect the totality of all these communities. And then it's to highlight very importantly that the Minister points out that you confirm that the KA is opposed to any new nuclear builds being established, as well as the extension of the life of Kuberg, and that you hold the same views. If this is so, how then can you make an objective determination when presented with objective scientific evidence in respect to the extension of the life of Kuberg? Any decision you make in this regard will be prejudiced, as you have already indicated your views. And we submit that that is the crucial part of the Minister's determination. And the Minister was absolutely right with respect to point that out to Mr. Becker. He was appointed to the board to make safety determinations. Instead, his conduct shows that he cannot make decisions based on safety, because instead he has these pre-programmed views about nuclear energy, about Kuberg, about new nuclear builds. But if we turn over, we see the Minister continues. He says, proper governance entails that every board member, irrespective of their personal views, and in terms of what provisions are appointed, must be able to bring an independent mind to bear in an unbiased, fair, and even-handed manner when making decisions. He accepts their neutrality, he accepts independence. That you are not able to do so is demonstrated by what is set out in paragraph 13 of your representations dated 21 February 2002. Now, to see what the Minister is referring to there, we need to flip to page 200 of the record, and that's the submissions. And what Mr. Becker, or said on behalf of Mr. Becker by Mr. Becker in his submissions, is that the KA is indeed opposed to any new nuclear plants in South Africa, but its position is nuanced. He says, does not necessarily oppose the use of nuclear power in all contexts. KA champions the safest possible uses of nuclear power. And then what he says is, it is correct that KAA opposes the extension of the life of Kuberg, a view which is shared by recognized experts. I remain a member of the KAA, as I was when I was appointed with the NNR board. The fact that I hold these views does not prevent me making a constructive and objective contribution to matters with regard to nuclear safety. And what the Minister points out is that this is a crucial issue, which is an application is going to be made by Eskom to extend the life of Kuberg. In your own submissions, you have shown that your position is that Kuberg cannot be extended. The lifespan of Kuberg cannot be extended. And this comes up over and over again, and we'll show you other examples where Mr. Becker does exactly the same thing. He cannot make these safety determinations. And if we then go back to the Minister's reasons, we then see that he continues at paragraph 16, again, raising this issue about a conflict of interest and asking Mr. Becker almost rhetorically, how could you possibly be expected to make the decisions that will come before the board? How do you, because of your conduct after your appointment, over and over showing that you cannot make a determination based on safety, you always allow your political views to slip in. And those political views are fundamentally that Kuberg cannot be extended, new nuclear builds are undesirable. How then can you possibly still bring your mind to bear on issues before the board? This board that is tasked to decide whether nuclear installation should be authorized or not. And we submit that it doesn't, with respect, help Mr. Becker to say that he would have exercised his mandate properly and he would have based his views on safety. This isn't borne out by his actual conduct, which shows that the Minister is entirely correct. And we also point out that there's a suggestion that the Minister's reasons have somehow changed. And we submit that that's not right at all. The Minister's reasons have always remained the same, that Mr. Becker cannot make the decisions that he is tasked to make based on the decisional reference in the Act. And if we look at that the Minister's reasons have always been, as has been pointed out, that Mr. Becker cannot make the decisions that would be made before him. If we cross-refer to paragraph 15 of the answering affidavit of the Minister at page 313, so that we see exactly the same thing. the minister says, the golden thread running through my reasons is that the applicant expressed views in whatever capacity they were made, evidence that he had allowed himself to be caught in a conflict of interest. His single-minded commitment to promote his own political views led to the ineluctable conclusion that he could not remain true to his neutral role as a director of the NNR, as well as his legal and contractual obligations to the NNR. In my view, the applicant's role in allowing this conflict of interest to fester amounted to misconduct, justifying his discharge. So the minister's reasons stated in his letter of the 24th of February and in his answering affidavits are exactly the same. Then against this, if we can then turn to, well, what is all of this conduct that we're talking about? And we submit that this is something that has been vastly overlooked in the discussion that has been had before you this morning. And it needs to start with the so-called Energize article. It's a magazine article in the magazine called Energize, and it starts at page 74 of the record annex of PB3. And we see that the article is particularly about hearings that the NNR the regulator is going to have about an application for the Taspin site, the Eastern Cape site for a new nuclear build. And the comments of Mr. Becker then start at page 77, and we see that he started at the foot of that page. It's disappointing to see money and time being spent on pursuing nuclear power for the Taspin site after the government had stated that there was no money to fund a new nuclear build. So sort of talking about money being what he suggests is something that should be taken into account. The existing plant, but then he turns his attention to Kuiberg, and he starts saying that, well, this should really be our main focus, is that the states of Kuiberg and the fact that it could be in an unsafe condition. And then after the break in the text on that page, we see that Becker believes that the revived interest in the Taspin site is just a distraction from more pressing issues. We should be worrying about the safety of the existing plant at Kuiberg, especially as it approaches the end of its lifespan. So here, Mr. Becker, while he's on the board, is talking about a process before the board about the Taspin new nuclear build, and he has already in public framed that matter, which will serve before his own board, as a distraction. We submit that is something that we would submit is hard to understand as being akin to what we would see as a responsible member of the board. And then over the page on 79, we see that he continues about the decision to extend Kuiberg. And here he starts stating his very clear view, one that cannot be shaken, as we will see as we move along, that Kuiberg can't be extended. So even though that's a matter that's going to have to serve before him, Eskom's going to make a safety case about why it thinks the Kuiberg can be extended. Mr. Becker goes on clearly in public and saying Eskom cannot extend the lifespan of Kuiberg because it's simply unsafe. He says it is like an old car. It's unwise to spend money refurbishing the plant before finding out what has been done, what would have to be done to obtain a license to extend its life. And then he starts talking about cost implications that's going to have for Eskom. Again, not something that this court should be considered about, or that the board would ever be considered about, whether the cost implications to Eskom. That's not an issue about safety. So here we have then a very clear indication of what Mr. Becker intends doing. Mr. Becker doesn't take credit for writing this article, but we see on page 80 at the end of the article that there is a contact. And the contact in respect to this article is Peter Becker, Kuiberg Alert Alliance. So he's apparently here, even though he is already on the board at this stage, still thinks it's appropriate to make these statements attacking the board on which he sits as a member of the Kuiberg Alert Alliance. Now, this then is taken up by in Mr. Becker's submissions of the 12th of January at page 169 of the record. And if we can briefly refer to that, and so these are his submissions that he then makes in response to the allegations that are made against him by the board, and what he really says in there is that, well, these statements made in the article weren't defamatory, and we see that there's then at 192 that is taken up by the minister. That's the minister's letter of the 15th of February, where he starts indicating conduct that he believes is problematic. And what the minister points out to Mr. Becker there at page 192 is the minister points out at paragraph 5b, the statement, apart from the aspersions leveled at Eskom SEO Limited, Kuberg's operators, suggest or imply that both the regulator and government have not taken seriously the regulatory and oversight obligations with regard to Kuberg. This is likely to cause both entities reputational harm. Now, so the minister very clearly points out to Mr. Becker in his letter of the 15th of February why the Energize article is problematic. Mr. Becker, what you are doing is you are saying that the regulator are not doing their job taking their job seriously. In this respect, how can that possibly be disputed? Mr. Becker has suggested that the board has dropped the ball on the extension of the lifespan of Kuberg, and that it is using the taste-pin process as some sort of diversion. The minister puts that to him and says, Mr. Becker, deal with this. Mr. Becker attempts to deal with that in his further submissions at pages 198 to 199, paragraphs 5 to 8 of his further supplementary submissions of the 21st of February. And what we see is that he says, based on information in the public domain, I queried whether the management of Kuberg overrode the decision of the plant manager. I'm entitled to raise such queries in public. He believes so because he thinks it's part of his freedom of expression. My position on the board does not preclude me from raising concerns in relation to the affairs of other organs of state, including Eskom. Well, the problem isn't that you are, as the minister has pointed out, the minister is not that you're attacking Eskom. The problem is that you're attacking your own board in public about matters that are currently before it. I submit that that is clearly conflicting with his duties to the board and with his public duties. If we then turn to the minister's answering paper, the minister notes at page 333, paragraph 71, and the minister again notes, the article is noteworthy not only because of strong condemnation of new nuclear builds, but also because the applicant expresses his views on the safety of Kuberg. This anticipates issues which will serve before the board and indicates his view in uncompromising terms. This impossibly compromises him from participating in any future decision of this type. So we submit that he has pinned his colors to the mast. The Energize article is one which is deeply problematic for somebody as a member of the NNR to put out against the board on which he sits. The second piece of conduct which is referred to, which would wish to highlight, is an email that Mr. Becker sent to the chairman of the board on the 27th of July 2001, and that is included at page 99 of the record. And we would. And we don't need to go to that in detail, milady, but what we see is that Mr. Becker raises this question about the extension of the lifespan of Kuberg, and he expresses this opinion that it seems clear to me, it seems clear that if the current license for Kuberg expiring in 2024, the replacement of the steam generators in 2022 is not economically viable if the life of the plant is not extended. And effectively, he expresses the view that on what he calls a balance of convenience, the board should not hear or not consider any matters about upgrades to Kuberg until 2024, that they all should all wrap together as one, and this is because of really a financial consideration. Now, the problem with this is that it was pointed out to Mr. Becker why his considerations that he was raising were so wrong. And what we see, and we see that at page 101 of the record, and actually PB 6.2, And that's an email from Dr. Ndar, the chair of the board. And what we see quite clearly is that the chairman points out that the determinations made by the board are not based on cost. They're made on nuclear safety. If our assessment confirms safety, we do not have any reason to reject an application. If the NNR were to reject an application based on cost implications, we would be acting outside of our mandate. And that's, of course, correct. And what is pointed out to Mr. Becker is you are inviting this board to act ultra vires. You are inviting us to include considerations in making our decisions which are not the ones which are defined by statute. Our statutory tramlines which determine our decisions are safety, and you are inviting us to bring in other considerations. And why that is so problematic is not, if Mr. Becker had at this point backed off and said, well, thank you very much, Doctor, that I now understand more clearly what should be taken into account, perhaps then we could still forgive the fact that this had been raised, in this manner before the board. But what is telling is how he doubles down, and this is what I pointed to earlier, how he doubles down on his criticism of the board in this situation. Instead of accepting that, well, okay, I thought that this would be something that should be interesting to the board. In fact, it's something that it shouldn't be. We see that what he says in his submissions of 12th of January, page 175, paragraph 66, and it's quite a striking paragraph. This is an appropriate concern for the board for a board member to raise. It is disingenuous or naive to suggest that ostensibly independent regulators do not face improper pressure from political and corporate actors where enormous sums of money are at stake, and that they should be alert to the potential for such pressure to be brought to bear upon them to improperly influence their decisions. And similarly, instead of looking and going, well, yeah, okay, these are, I went beyond the lines, what he does is he goes further even and starts raising without end. And of course, we all know in South Africa that corruption is an issue that we need to be aware of. But his immediate knee-jerk reaction is to start accusing other people on the board of a possibility that they are being effectively been selling off their votes to the highest bidder. And we submit that that's something that is utterly astounding. And in his the minister again raises this with Mr. Becker, which is on his 15th of February submissions. And Mr. Becker, in response to that, comes up with 199 to 200 of the record dealing with the email. And he's again, it is notorious that boards of SOEs and leadership of various organizations may have been corrupted or captured, because it's my statutory and fiduciary duty to the NNR is precisely to raise concerns through appropriate processes, including private correspondence with the chairman. My tone in the email is respectful and collegial. I raised concerns and queries and asked for guidance. Whether or not I was correct in relation to the various issues traversed in the correspondence is irrelevant. We submit no, Mr. Becker, with respect, it's not irrelevant, because what was pointed out to you by the chairperson in the considerations was the narrow mandates of the NNR to make decisions based on safety. Instead of accepting that guidance, you went on the attack, and that's something that we submit that is utterly unbecoming. Public statements, the further public statements, and we see that Mr. Budlander suggests that the minister was somehow swayed inappropriately by suggesting that Mr. Becker was leading marches. But if we look at the minister's 15th of February reasons, where he starts pointing out to what conduct he is considering that he's holding against Mr. Becker, reference is made to a Daily Maverick article. That Daily Maverick article is referred to in passing by Mr. Becker, but he never really tries to deal with it. And the reason for that is we submit quite obvious, because, well, it's a bit of a zinger. And that article is contained at, and we'd ask the court to refer to this at SGM 8, at page 432. And we see here that this is an article about a protest that has been held. So this is the article, the 16th of December, 2021, and there's this about the operating life of Koeberg, and that starts off: the operating life of Koeberg nuclear power station by 20 years is not one that should be made by engineers alone, but rather that it should involve consultation with members of the public. This is the view of Peter Becker, spokesperson for the Koeberg Alert Alliance, an anti-nuclear activist group. This has a moral component, a society component, an intergenerational ethics component. This is not for a bunch of engineers to decide alone. And this is a comment which has raised particular attention. We submit that rightly so. Because the determination is one of safety. It is an engineering determination. Mr. Becker here is still showing that as late as December, after everything that has happened, he still doesn't understand what he was appointed to and why he was appointed to the regulator. He doesn't understand what his job was. He still thinks he is allowed to take other factors into consideration besides safety. He still thinks it's a moral component, a society component, an intergenerational ethics component. No, it is a safety determination. Mr. Becker, you still don't understand that. That is precisely why you were removed, and correctly removed. And it's quite clear that that it is impossible for him to disentangle those views, his ethical views, his moral views, from his determination of issues of safety. And we see there that there was a march, there was a protest. Mr. Becker was at the head of it, and Becker was amongst 50 protesters who gathered on Bloberg Strand Beach on Thursday to protest against the extension of nuclear power stations' operating life and raise awareness about its operational issues. Yes, he was at a protest. There's no doubt about that. There was a petition. What did the petition say? That's on page 434. The petition asked Mr. De Ruyter, the CEO of Eskom, to acknowledge that Koeberg nuclear power station will never be safe as a modern nuclear power station decides shut down in 2024 as originally planned. So effectively, again, we see that this petition that Mr. Becker is clearly part of refuses to consider the possibility that Koeberg could be extended. And we see that he continues along those lines. So again, we submit that Mr. Becker has clearly shown he cannot disentangle political views about desirability from safety issues, and that his determination of certain decisions which will serve before the board are pre-programmed. Then there's the meeting with civil society, creating the impression that he was acting on behalf of the board. And we submit that the facts in this regard are relatively simple. On the 19th of July, Mr. Becker tells Mr. Mantashe of the regulator that he'll be meeting with civil society as a representative on the board. That's at page 94, to the extent that we need to see that. Page 95, we see Mr. Mantashe supports the idea, but knows that going forward, that there needs to be a process, and tells Mr. Becker what he's to do is to collate a list of issues which will then be dealt with by the board. And then at page 96, we see that there's a response by Mr. Becker on the 22nd of July, which is after the meeting. And maybe we'd ask you perhaps just to refer to this response, because it is rather telling about Mr. Becker and his roles at these meetings. And because what he starts off with in the second paragraph, we have a list of issues.
Is that page 96?
That's page 96, PB 5.3. So that's an email from Mr. Becker back to Mr. Mantashe, and he goes to he's talking about this meeting that he's called, and he says, we have a list of issues. Mr. Mantashe says to him, go and collate an issue, a list of issues that are raised with you. He comes back and says, well, we have a list of issues. But he doesn't say what that list of issues is, and he doesn't say who was at the meeting. In fact, it takes a while longer to learn any of that. And in fact, even in his papers, Mr. Becker still doesn't refer to that. Where we see is that in the minister's answering papers, he has to point out that this is at page 422, and actually SGM 5. So it's 422 to the answering paper of the minister, that we then see, in fact, what Mr. Becker eventually comes back on the 30th of July, And he starts talking about that well, he had this meeting, a Zoom meeting. It was with 35 activists from organizations concerned with issues of radiation and nuclear safety. They included several organizations who had nominated myself to the minister for the position on the board as their representative. So what he's done is he's not meeting with civil society. He's gone back to a group of people who support his political views to create a list of issues. And we submit that this, in this regard, the minister is quite right to point out that this is untenable. And what Mr. Becker's answer to all of this, when this is raised with him, is to say to the minister, well, you have to understand that my role was there, and he creates this very fine distinction. I was there as a representative on the board and not as a representative of the board. And the minister understands this distinction that Mr. Becker is attempting to make, but dismisses it. He calls it out for what it is, an incredible nonsense. And we see that that's quite clearly stated by the minister in his answering affidavit at page 349, paragraph 134. I note the applicant's attempts to distinguish his presence at meetings as a representative on the board and not as a member of the board. This argument was also raised in his submissions to me, and I took account of it. In my view, this fine distinction between the applicant's roles is less than compelling. The applicant cannot speak for the board unless mandated to do so. The applicant's engagements create the impression that he is acting on behalf of the NNR board. And so that's what the minister says there. And again, what is perhaps quite astounding, breathtaking, its audacity, is what Mr. Becker then comes back at with the minister in reply to these to the minister's understanding. The minister says, I understood the distinction you made, I just didn't buy it. And what Mr. Becker comes back and he says, the minister, page 682, 92 to 93, the minister repeats the mistake he made by taking the views that I represented at the meeting, by taking the view that I represented at the meeting of civil society that I was acting on the board's representative. I repeat that I did not purport to be a representative of the board, but rather civil society representative on the board. The minister's repeated refusal to consider or apparently appreciate this patent difference and its implications for decisions, including now his opposing affidavits, further documents his failure to consider relevant considerations, his consideration of irrelevant factors, and that he had a closed mind and predetermined outcome in dismissing me. This vitiates his decision. This is one of a number of, we submit, fairly outrageous attacks on the minister's credibility and the minister's bona fides in this case. And what it shows is that the minister quite clearly says, Mr. Becker, I understand the distinction you're trying to make. It's just not one that is particularly credible. Mr. Becker, again, doubles down on this and says that because the minister appears to disagree with him, well, all that can show is that the minister must be biased, that the minister, and that vitiates the minister, that the minister has a closed decision. And no, with respect, it doesn't. What it shows is that the minister simply didn't buy the argument that Mr. Becker was attempting to sell at that point. And that what the minister quite correctly found is that it was inappropriate for Mr. Becker to be acting as a representative of the board at that meeting. So, Malady, what we submit that we see as a cumulative thing from this conduct is that Mr. Becker who has created this confusion, collapsed the distinction between his role as a member of the board to decide issues based on safety alone and his political views. If we're going to just turn very briefly, I know that we're running to the end of my allotted time, but if I can just run to some of the points just about the bases of review and scrutiny. And Malady, we submit that, as we pointed out, that the Kojima case suggested that you can't avoid deciding whether this matter is administrative action or executive power. It does make a difference in this case as well because of the issue about the extent that there is a process challenge to the minister's decision. Procedural fairness, as in the Masetla case, which is quoted in our heads, means that procedural fairness does not apply. The standard is rather one of procedural rationality. Malady, if you want to know that just a the difference between procedural fairness and procedural rationality is dealt with in the Albert case. It's ALBUTT. And it's not a reference that we've included in our heads, but I think it is referred to in the applicant's heads, the case 2010-3 SA 293, the Constitutional Court, paragraph 51. And effectively, what the court shows is that you have a wide discretion in selecting means to do something, that the court can look at whether the process you actually have chosen is rational. It is not, however, tantamount to a procedural fairness determination. So as far as whether this is executive or administrative action in this case, we've dealt with that in our heads of argument, and we submit that what the Masetla and Matau cases show is that that there really is a bundle of factors that must be taken into account in cases like this, and that it's that we would submit that there's can't be a paint by numbers determination, but we point to the countervailing considerations which we suggest make the minister's decision to remove Mr. Becker executive in nature as opposed to administrative. The more important point we'd submit as on the level of scrutiny that the court needs to apply, would submit really relates to this question of whether misconduct is an objective jurisdictional fact. And there really does seem to be a suggestion by the applicants that this court has the determination to make its own determination of whether misconduct was established as an objective fact, whereas we'd submit that misconduct is a determination that is left to the minister in terms of section 9(1)(c) of the Act. It is the minister who must make that determination based on a value judgment, and this court's power is merely to test that on traditional review bases, particularly where we would think rationality. So, and that would submit makes a big difference in the level of scrutiny which this court will apply. The court is a review court. You're not acting as an appeal court. It will submit it would be inappropriate for you to and it's not about conjuring an argument of deference. It's not about trying to say that the minister's approach can't be questioned. It's merely looking at the bases on which it can be questioned. And we'd submit that in this regard, clearly the Act gives the power to the minister to make a determination on misconduct, and that must be respected. And if it is going to be challenged, it must be on, for instance, rationality grounds. And on rationality grounds, there's already been reference to the case about the appointment of Mr. Similani as the NDPP back in 2013, and the Constitutional Court's judgment in that case. And we would just highlight that what the Constitutional Court pointed out there is that if this court limits itself to questioning the rationality of the minister's decision, the court then isn't considering whether it would have made the same decision. It is rather, as Judge Yakub stated in that case, the aim of the evaluation of the relationship is not to determine whether some means will achieve the purpose better than others, but only whether the means employed are rationally related to the purpose for which the power was conferred. Once there is a rational relationship, an executive decision of this kind, which we are here concerned, is constitutional. So rationality, we know, is something that is very seldom found. It involves this court finding that there would simply no rational connection between the information before the minister, between the purposes of his power and the action that he actually took. And we submit that there's nothing that has been shown to rise to that level. Then the further point that we'd point out to, which was raised by Mr. Mitchell in his argument, was really this idea of an anticipatory dismissal, that there's some sort of speculation that how the minister will how Mr. Becker will act in the future, and we submit that this is entirely incorrect. First of all, the suggestion that we'd have to wait for Mr. Becker and see how he actually votes in the future is, with respect, hard to stomach. I'm always reminded in circumstances like this of one of my favorite lyrics from a Bob Dylan song in Subterranean Homesick Blues, where he says, "You don't need a weatherman to know which way the wind blows." We really do not have to wait until Mr. Becker votes to know how he will vote. He has clearly telegraphed this. This is something which we have seen, but that's not really even the full issue. The full issue is that he has shown he cannot disentangle his political views, his critical voice about nuclear energy. He thinks that that's something he should bring to the board. And that clearly is something he shouldn't bring to the board. He really fails to appreciate that he had a positive duty to avoid a conflict. He failed to do this. He instead courted a conflict of interests and tried to portray it as a strength. And with respect, as far as the various documents showing that he could not court a conflict, we can look at, and we have in our, we've just Milady referred to them briefly in our answering affidavits at page 325 and forward. There's an individual performance agreement, a board charter, code of conduct, a media policy. All of those show that he, what the conduct that was expected of him. But more importantly, and it's something that's raised in our heads of argument at page 39, paragraph 115, the Mantashe case. And what is highlighted there is that in these cases, you don't need to show an actual conflict, but a reasonable person would think that there is a sensible possibility of conflict. So we don't need to wait until you've done it. We can look and say that there's a reasonable person who would think that there is a sensible possibility of conflict, and we submit that we are certainly within that type of situation here. Reference is also made just to a definition that was raised in an OECD document that is included in our bundle of authorities at page 98. That's in a second. And we would highlight down. We see that what is stated in that document, conflicts of interest in the public sector are particularly important because if they are not recognized and controlled appropriately, they can undermine the fundamental integrity of officials, decisions, agency, and governments. Integrity is used in the public sector to refer to the proper use of funds, resources, assets, and powers for official purposes for which they are intended to be used. In this sense, the opposite of integrity is corruption or abuse. Conflict of interest is both a straightforward and complex matter. In principle, it's easy to define. In the public sector, conflict of interest arises when a public official has a private capacity interest which could improperly influence the performance of their official duties and responsibilities. And we submit that that is exactly, and we would support that definition of a conflict of interest, and we would submit that the idea that that it is quite appropriate to act against somebody who has shown that their private law interests will improperly infect their public law duties. And this, we had submitted, is something that is also seen in cases that deal with bias in decision-making, where somebody can't disentangle their a priori views from the determination that's made before them. And we refer to cases from Safu to Burnett on that reasonable apprehension of bias. We don't need to show anything. We don't need to show particular evidence with respect. What we need to show is a reasonable apprehension that Mr. Becker could not make the decisions because his public conduct and his conduct before the board made it clear that he could not disentangle the desirability from safety. Just on the cases that deal with bias of judges, we would just highlight that is a slightly different test, and we would refer the court particularly to the Masuku judgment of the Constitutional Court, quite a more recent judgment, 2022 4 SA1. And what is highlighted there is that when you're dealing with judges, that they have a constitutional duty to act without bias. It's wound up in their oath of office. And that the court there also highlights that this is based on the recognition that legal training and experience prepares judges for the often difficult task of fairly determining where the truth may lie in a wealth of contradictory evidence. And the same isn't true of somebody like Mr. Becker. Mr. Becker doesn't deserve the same sort of protection against a finding that he is biased. In fact, it is quite clear we submit that that his conduct indicates bias. And that we would also highlight the case of Pinochet, and I won't take your ladyship to it, but at page 142 of the bundle, we see that what is quite clear there is that a non-pecuniary benefit, and that's a judgment of the English House of Lords, but it has been referred to with the agreement in SAFU case, and it's that you don't need to show that Mr. Becker had a pecuniary interest. If he had a private interest in the outcome of a determination, he becomes a judge in his own cause. It's something that he simply shouldn't be involved in. As far as the procedural fairness argument goes, maybe there is the suggestion that the minister spoke inappropriately in an interview of the 3rd of February 2022, and we would actually ask the court to again to turn back to what the minister actually stated there. But before we do that, Malene, perhaps if I can just ask you just to refer to paragraph 205 of the minister's answering papers, page 361, where the minister explains the context in which his decision, which these comments were made, and we submit that in fact shows that it was indeed that based on the decision that he had made already on the 18th of January regarding suspension. I deny, and the minister says, I deny that I prejudged the applicant's case and that the decision taken to discharge the applicant was procedurally unfair when the statement was made. In order for me to make my decision I took on the 18th of January, I had to have consideration of all the information before me at the time. Based on the allegations that the NNR had to identify if possible grounds for dismissal were present and took a prima facie view on the actions of the applicant. However, my mind was not closed to the possibility that the applicant's representations could sway me. So when the minister is speaking on the 3rd of February, it is against the basis of what has just happened on the 18th of January. And the suspension and the fact that he has suspended Mr. Becker and that Mr. Becker is challenging that suspension. And we submit that if we again look at the comments that the minister made in that context, that there is with respect nothing that is problematic about them. In fact, we submit that the argument somewhat boomerangs on the applicant to say that the minister has been hiding his true motives the whole time, because we see that, as Mr. Budlander said, the minister is here speaking his mind without guidance from lawyers. And what the minister says there is effectively, we'd submit, although maybe not with the same level of legal nicety, but it's the same thing that comes up in his reasons. All I'm saying, I'm giving Mr. Becker an opportunity to do what inaudible, working against nuclear, he must do that. He can't be in a board of something you are working against, but you will be judged when it goes to court. And he's saying that but it is simple. If you're a nuclear activist, you cannot sit on the board of nuclear. And that's quite correct. Again, it's a statement that's made in an interview without legal niceties, but the minister is entirely correct in that. You can't sit on the board of the National Nuclear Regulator to promote your anti-nuclear agenda. That is not what the board is there for, and if you do it, you are acting inappropriately. And that when the minister later comes on the 7th of May to that the statements that again that the applicants attempt to make so much of, we submit that there's simply nothing wrong with that. If you resist nuclear and you're a board member, I will fire you. Simple. Quite correct. We would submit that the minister must fire people who are using their position on the board to resist nuclear power. That is not what the board is there for. And if they are inappropriately melding those considerations into the determination, they are acting ultra vires, and they should be their position should be removed. So ultimately, Milady would submit that what is clear from the applicant's conduct in this case is that he's been using his board effectively as an opportunity to promote his anti-nuclear views. The minister made a determination that that was inappropriate, unlawful, amounted to misconduct, and would submit that the minister's determination that is entirely and cannot be questioned. It was an abuse for Mr. Becker to think that he could come onto the board and use it as a platform to promote his critical views of nuclear energy. That was not what he was there for. When it was pointed out to him that that was not what he was there for, he didn't accept it. He still continues to this day believing that he is entitled to do so. So in those circumstances, we submit that the application should simply be dismissed. And And Milady, however, if this court is of the mind to find that there was some tripwire that the minister managed to trigger in his process, we'd submit that this is a case where this court would be quite justified to exercise its powers in terms of 172 of the Constitution. And what we know there from Bengunyama, other cases, that the court must declare what is unlawful to be unlawful, but that the court has a wide discretion to grant further relief flowing from that. And we'd submit that in this case, if it is found that the minister made some mistake, and we certainly don't concede that the minister made any mistake, but if there is any finding that the minister, as we say, triggered some sort of tripwire, then that must be declared, and that would have to be accepted. But that it is quite another matter to say that Mr. Becker must be sent back and put back in his position. And we submit that that's not something which this court ought to do in the circumstances of this case, particularly where it has been raised that Mr. Becker is a disruptive influence. That's not the minister raising a new issue. The minister is not raising that as a new reason justifying his decision. The minister is entitled to raise this as an issue for the court to consider when it is considering the question of relief. And that's the court is not going to send Mr. Becker back knowing that he is somebody who can't appreciate the distinction between his political views and views on safety, knowing that he is somebody who quite freely seems to insult his other members of the board and the board itself, even going as far as, without any justification, accusing them of some sort of corruption. We submit that in those sorts of circumstances, this is not a person who this court will for light reasons, inflict back upon the board, particularly if his participation is likely to compromise the decision-making, the credibility of decision-making of the board. We'd also note, Milady, that the inappropriateness of sending the applicant back to the position on the board is also highlighted by his repeated attacks on the credibility, the bona fides of the minister, and particularly in his replying papers. And Milady, we already pointed out the fact that how he doubles down on attacks on the minister's credibility. There's one which is quite worthy of note. At page 363, answering the paragraphs, it's in the paragraphs 219 to 220 of the minister's answering affidavit. The minister points out that, so there's an allegation by Mr. Becker that the minister's decision was timed to coincide with a steam generator project in November 2021. The minister points out, no, that's wrong, that had nothing to do with the timing of his decision, and that he in any event understands that the approvals of plant modifications are day-to-day operational decisions made by the staff of the NNR and not the board, and that the applicants wouldn't have been involved in that matter anyway. So this whole idea that is raised in the applicant's papers that the timing of his suspension was particularly acute because it was designed to remove him from considering the steam generator issue. The minister points out, no, well, that's entirely wrong. That's not something that was right. That's not something that would have been before you anyway. And what we see is that the applicant again comes out swinging. And what he states in paragraph 682 of the papers, the minister is wrong. Sorry, it's over the page at paragraph 97, 683 of the replying paper. I reject the allegation made by the minister inappropriately and without any proper foundation that I am seeking to mislead or sensationalize the court. The facts all point to the minister's bad faith and ulterior purposes in discharging me as a director. The minister points out, you make an allegation that my timing was made for a particular reason. I'm showing you why that's not correct. Mr. Becker doesn't try and address the minister's argument on that timing issue. Instead, what he goes to, again, this knee-jerk reaction to, I've explained myself, the fact that you don't agree with me shows bad faith, ulterior purpose, and that you that and an attack on the minister's bona fides. So we submit that those sorts of those sorts of allegations of bad faith, those repeated allegations of bad faith without any justification, are precisely what the Constitutional Court warned against in the Hibiscus Coast municipality case, where it was pointed out that by Justice Madlanga that you don't make these sort of allegations lightly. If you're going to make allegations against people's credibility, even though they may be in public office, you do so based on evidence, and you don't merely sort of suggest that every time somebody disagrees with you, it's because they're utterly incompetent, or that they must be motivated by some sort of malice towards you. So, lady, in those circumstances, we submit application dismissed. If it is not to be dismissed, we'd submit that the court should merely declare whatever unlawfulness it may find, but that Mr. Becker should not be sent back to the board. And certainly, my lady, we submit that this court does not have a power to, with respect, extend the 3-year period of Mr. Becker's appointment, but we will leave that as well for the NNR to deal with. Lady, those are sort of galloped through my submissions. Those are the submissions that I have to make. Unless any questions, probably everyone would appreciate a break by this stage, I would think.
Certainly, we're tired by now, all of us, I would imagine. We've gone beyond the time that was set out by Mr. Jamie and Mr. Badland, most unfortunately. I would like us to stick to time. Is it possible to break up until 2 o'clock or latest 2:15?
Justice Montami, could I first protest my innocence? Unlike my learned friends, Mr. Butler and Mr. Borgstrom, I have been guilty of no trespassing with regard to time. So I will keep to my time.
Okay.
In fact, I expect to be no more than half an hour.
Okay.
Could I request we begin at 2:15? Justice?
2:15. 2:15, we
As it
adjourn
was.
up until 2:15. Thank you.
Thank you. Thank you. Good afternoon, Judge.
Afternoon, Mr. Jamie.
May I proceed?
Certainly, if everybody is present.
I think both my colleagues are present.
Okay.
Mr. Borgstrom and Mr.
If everybody's on, you may proceed, Mr. Jamie.
As a court. Justice, I have essentially 4 aspects that I wish to deal with. I'm going to try not to repeat what my learned friend for the Minister has said. Our positions, as you will be aware from the answering affidavits and from the heads of argument, largely overlap. And I'm going to try to avoid covering ground that he's covered. So, in essence, the 4 aspects I would like to deal with is first the relevant governance principles and provisions that are relevant to Mr. Becker's, the applicant's membership and the discharge of his functions as a board member. That's the first aspect. The second is his conduct, which we submit on the basis of the facts that you will find in the papers demonstrate that he has failed to discharge or properly discharge those functions. The third, Justice, is the question of the proper understanding and conclusions that the court should reach as to whether Mr. Becker has committed misconduct as provided for in Section 91C of the Act. And then the last aspect or issue is the question of remedy. Those are the 4 aspects. So if I could then begin with the first. Just by way of introduction, we know that Mr. Becker seeks an order reviewing and setting aside the Minister's decision on 25 February of this year to discharge him as a non-executive director of the board. Then in addition, in terms of the amendment to the notice of motion, he seeks an order in terms of Section 172(1)(b) Roman 1, Justice, that the retrospectivity of that order be restricted and only begin running from the date of judgment, if the court is so minded to give a judgment in favour of Mr. Becker. We also know that although no relief is sought against the regulator or the board, for whom I act and the Stansfield acts, the board is elected to oppose the matter, and it does so primarily for 2 reasons, Justice. The first being that the board and the chair, who cited separately, consider that Mr. Becker is irredeemably conflicted in his role as director of the board by virtue of his conduct, and I emphasize that conduct, since being appointed as a member. And I'll return to why we emphasize the word conduct. The second reason why my client is elected to oppose as opposed to abide is that pursuant to forming that view and obtaining legal advice, which you know they did in terms of the McRobert opinion, the board was not supine, Justice. The board decided, because there was an absence of mechanisms, as the board understood it, for it itself to take action against Mr. Becker, it accordingly referred the matter to the Minister. And for the Minister, as you know, the board referred the matter, referred the opinion, and left it to the Minister to decide what to do. And the Minister initially suspended Mr. Becker and thereafter discharged him. And the board doesn't want to see. The board takes its corporate and its statutory duties seriously. It doesn't want to be seen or be accused of being supine and hiding behind the Minister. So the board believes that Mr. Becker is not, has committed misconduct, as I say, and is not suitable or eligible, rather, not suitable, eligible any longer to be a member of the board. And it believes that it must publicly say so as a responsible corporate and statutory citizen. And that's what it's doing in these proceedings. That by way of introduction, Justice. Then if I could get to the, and sorry, there's the third aspect, and this focuses on the question, my emphasis on the word conduct. And And I've said that the board's view, I've submitted rather, the board's view is Mr. Becker, by his conduct, has demonstrated that he is not fit and proper and eligible to continue being a member of the board. Now, as with Mr. Borgstrom, I want to emphasize what this case is not about. This case is not just about Mr. Becker's beliefs and his views on nuclear and whether nuclear is a good idea or a bad idea. Now, the case has been framed in that way by our learned friends for him, for Mr. Becker. And they say that the minister's discharge of him is an attempt to silence a vocal and independent critic on the board, etc., and to get rid of the dissenting voice. And now, they say that, but then in the next breath, they complain and they say, well, the minister always knew that Mr. Becker was a vocal opponent of nuclear, and thus he can't use that as a reason to now get rid of Mr. Becker. Now, of course, you know that there's a dispute on the papers. It's not particularly relevant to this question because the chair of the board says in his answering affidavit that he and the board were not aware of Mr. Becker's strong anti-nuclear position, and you will know factually the board had no part to play in the appointment of Mr. Becker. It's a process that took place. The minister invites applications, the minister considers them, and it's not alleged by Mr. Becker that the board had any part to play in that. But the court doesn't need to resolve that dispute. Mr. Becker comes back in reply and says, well, I met members of the board, etc. It's not really relevant. The point being, Justice, that the board was not responsible for Mr. Becker's appointment. But the complaint that, well, the minister knew what Mr. Becker's position was, he was strongly anti-nuclear, and if that was going to be the reason to get rid of him, why appoint him in the first place, it's a self-serving circular argument because no one, including the minister, suggests that the minister discharged him because of his views. So we can accept the minister knew that he was anti-nuclear. And he was a member of the Kuberg Alert Alliance that was vocally anti-nuclear and particularly anti the extension, well, the situation of the nuclear plant at Kuberg and certainly its extension of its designed lifespan. So it can be accepted the minister knew that before the minister appointed him. But therein lies the point about the argument being self-circular. That is not the reason that the minister discharged him. The minister has said as much. And the board accepts that one can be pro-nuclear or anti-nuclear and you can serve on the board. And that is not the complaint. It's not the board's complaint. It's not the minister's complaint. It's the question of his conduct after being appointed. And can he, in his conduct, Justice, do one of two things? The first thing is to continue being a vehemently anti-nuclear or a member of a vehemently anti-nuclear body and express those views in public. Now, that is a debate the court may have to consider, considering some of the submissions that you've heard. We say that the true issue is even narrower than that. And this is the board's position. The board says, Justice Mantashe, that whatever the position may be on you holding nuclear or pro-nuclear or anti-nuclear views and expressing them even as a member or even after you're appointed as a board member, supposedly while wearing your KAA hat, as Mr. Becker's counsel suggests he may have done when he made certain comments. That does not entitle you to actually attack the very body on whose board you sit and to question its integrity and its discharge of its statutory obligations in public. And that is what we say Mr. Becker has done. And therein lies his misconduct, and therein lies the conflict of interest, which renders him incapable of continuing to be a member of the board. And I'm going to take you to why we say that. But we say the issue is as narrow as that. So you don't have to concern yourself with this broader debate and the way the case has been framed. Well, can you, can't you, and should you keep your views to yourself, even if you're anti-nuclear or pro-nuclear, whichever the position is. And this debate of Mr. Mantashe and what his position was and has the minister, those are all sideshows. They're not the essential issue. Mr. Mantashe never expressed himself in public on the crucial issue which the board is about and which this case is about, and that is safety concerns. That is the distinction between Mr. Becker's position, Mr. Matopa's position. Mr. Becker has expressed himself expressly in public on the future safety of the operations of Quebec. And that is the very issue which will come before him if he remains a member of the board. And therein lies the board's view that he has committed misconduct and is not suitable to be a member, continue to be a member of the board. So with that by way of introduction, can I then get to what we submit justice are so this is now my first point, the governing provisions. The first, and you will know that's referred to in, I think you referred to it, in a question to one of my colleagues, I think Mr. Budlander, that one of the parties, I believe it is the board, that sets this out in its papers. And there are a number of governing, and sorry, before I get there, can I, because the beginning point is to take you, Justice Mantashe, to the appointment letter of Mr. Becker, which you find at, it's PB 2.1 at page 68 of the papers. And this is the minister's letter to Mr. Becker dated 10 June 2021. And the letter says, at the bottom of page 68, Justice Mantashe, your appointment shall be for a 3-year term with effect from the date of the signature of the letter, this letter, and shall be subject to inter alia the provisions of the Act, the Public Finance Management Act as amended, and all other applicable legislative and governance prescripts. So that was expressly made part of Mr. Becker's appointment. Now those governance prescripts, you've heard my learned friends on the governing statutes. I'm not going to repeat that. So I'm going to the other governance prescripts, which we submit warrant a bit more attention. Could I begin, Justice, by dealing with the individual performance agreement, which is common cause Mr. Becker signed after being inducted? I'm sorry?
Certainly, may proceed.
As a
Individual performance agreement.
The individual performance agreement, which is common cause he signed, I believe, after his induction. And that you found, Justice, at page, it begins at page 5, it's TM4 to the board's answering affidavit. And you find it at page 522, it begins. And I'd like to take you to clause 2.1 at page 525. And I think you alluded to this as well in one of your questions, Justice. Under the heading 525, yes, clause 2.1. This agreement must be interpreted and applied in a manner that gives effect. Sorry, do you have it, Justice?
Yeah, I do have it.
That gives effect to the contents of the Companies Act, the Public Finance Management Act, and the King IV Report on Corporate Governance in South Africa.
Yeah.
I think that you alluded to the reference to the King
Yes.
Report on Corporate Governance, yes.
Yeah.
Then 512, Justice, at 527. And you will consider these provisions. So this is an agreement that Mr. Becker himself signed. And there seemed to us, when listening to Mr. Butler and for Mr. Becker, that there seemed to be some backpedaling on the extent to which these provisions bound Mr. Becker, or some of them bound him, as opposed to the provisions of the statute. And we submit there is no conflict between the statute and these provisions. And Mr. Becker, by his appointment, I've just referred you to the letter of appointment, but in this case, this IPA is actually signed by him. You'll bear that in mind.
Yeah.
So quite apart from anything else, he's agreed to be bound by this agreement. So 5.1, the board member must at all material times act in the best interests of the organization and avoid potential conflicts of interest. We submit there's nothing magic about that, Justice. That's the sort of provision you'd expect to find in any agreement where you are appointed as a member of a board. You must avoid, it's a basic principle, you must avoid conflicts of interest. If you sit in any fiduciary capacity, you must separate your own interests or interests of a third party from the interests of the body that you are now appointed to serve on. And then 5.4, the board member commits to achieving the vision, mission, goals, objectives, and strategic intent detailed in the SOE. That would be a reference to the regulator, board-approved corporate plan, strategic plan, and annual performance plan, whichever is applicable. Then 5.12, protecting and promoting the SOE's business interests. And 5.13, important in the context of this case, Justice, preserving the SOE's reputation and goodwill at all times during the period of this agreement. And once again, that is nothing magical. There's nothing extraordinary or onerous about requiring you, when you're appointed to the board of a body, to commit to protecting its reputation and goodwill at all times during the period of your tenure as a member of the board. There's nothing strange about that. Then 5.18, Justice, you find at 5.30. The director will at all times exercise independent judgment, reasonable care, skill, and diligence, and always strive to add continuous value to the activities and discussions of the board and its various board committees. Again, nothing exceptional about that. The next relevant document, Justice, is the board charter, which you find as TM5, the very next page, at 531. I would like to refer the call to clause 2.1 and 534. Where it's recorded that the purpose of the charter is to set out the board's role and responsibilities, as well as the requirements for its composition and meeting procedures. And then clause 517, Justice. Sorry, not 517, 5.17 at 537. The board shall adhere to the conflict of interest rules, and then that's broken up into the following. A board member is not disqualified by virtue of his office from contracting with the regulator. And then full disclosure of the nature of a board member's interests, whether directly or indirectly, on any matter before the board is required. Then sub 3, a board member may not vote nor be counted in the quorum on any matter in which he or she has an interest. Additionally, he or she shall be recused from any meeting when such matters are discussed. Then sub 4, board members are prohibited from voting and participation in any proceedings, nor may he or she be present at a meeting where such discussions are held if he or she has any interest which precludes him or her from performing his or her functions as a member of the board in a fair, unbiased, and proper manner. And inherent in that is the corollary of that. You obviously can be recused if that is the position, but the primary obligation is you must not act, Justice, we submit, in a manner that is not fair, not unbiased, and that is improper. That's the positive obligation, which is reflected here as a negative, being the consequence if you fail to meet one of those 3 standards. But we emphasize the positive aspect of that obligation. Then, Justice, at 538, clause 714, under responsibilities of the board, there's a specific, could I first take you to 711, which is relevant? The NNR Board of Directors must ensure that the NNR effectively carries out its mandate as set out in the Act and the PFMA by collectively directing the regulator's affairs whilst meeting the appropriate interests of the executive authority and relevant stakeholders. Now, that is a provision in the Charter which Mr. Becker agreed to be bound by. There's no application before this court. You've heard no argument, Justice, on why this would not apply to Mr. Becker. You've heard some argument as to, well, he's not required, as ordinary employees are, to be loyal to the government of the day. Well, that is an argument which is perhaps overstated by our learned friend for Mr. Becker, because it's one thing to say you don't need to adhere to all government policies, but certainly inasmuch as, and everyone seems to accept, it's the prerogative of government and Cabinet to decide what the nature of the energy mix in this country is going to be and whether nuclear should be part of it. Government and Cabinet could decide, Justice, that we are opposed to nuclear, as some countries have decided. And then there won't be nuclear, and then Kuberg will be closed. But unless and until government decides that, or Cabinet decides that, we know what the present position and policy is. That is part of the nuclear mix. And that must be respected by inter alia members of the board, as it must be respected by other employees of government. Mr. Becker may not be an employee of government in the stricto sensu sense of the word, but we submit it's a question of nuance and degree. I don't need to take it further than that because I'm entitled and the board is entitled to rely on this provision, which Mr. Becker has agreed to be bound by and which is not challenged pertinently otherwise in these proceedings. And that requires him to meet the appropriate interests of the executive authority, i.e. the minister and the government, Justice, and relevant stakeholders. And relevant stakeholders may well include Eskom, but again, I don't need to take that further. But certainly it includes the public and affected communities. So that's the first point we make. The second point is with reference to 714 of the responsibilities of the board, and there you will see again an express obligation as in 711 that I've just dealt with. And that is the board and all individual directors must ensure that the principles set out in the code of conduct are observed in all the activities of the board. Now I'm going to come to the code of conduct in a moment. And you'll recall from the affidavits, Justice, that it's contended when we refer, and I think the minister refers to the code of conduct as well, and it's certainly referred to in the McRobert opinion. And the riposte to that by Mr. Becker as well, that only binds employees. It doesn't bind directors. Well, that's not a get out of jail card free for Mr. Becker, because this charter, which does bind him, says in express terms that he as a director must ensure that the principles in the code of conduct are observed in all the activities of the board, i.e. including activities that he participates in. So we submit that that is the connection between Mr. Becker's position, albeit not that of an employee in the ordinary sense, and the obligations in the code of conduct. Then could I take the court to the code of conduct, Justice? And you find that at page 500, and it begins at page 544. It's annexure TMX. TM6. TM6 at 544, Justice. Okay. And the first provision I want to take you to is the definition of conflict of interest, which you find on page 550 under definitions, 4.1 definitions, and then conflict of interest. A situation that exists when employees, and we say, with reference to what I've just read to you in the charter, directors or board members, loyalties or actions are divided between the regulator's interests and their personal interests, or those of a third party. Example, service provider, supplier, or persons with whom the regulator has business dealings. So that is the definition in the Code of Conduct, Justice, of the conflict of interest, where the employees / board members' loyalties or actions are divided between the interests of the regulator and their personal interests or those of a third party. Read KAA for purposes of this exercise. The next aspect of the Code of Conduct I want to refer to, Justice, is 631.
Sorry, Mr. Jamie, you're saying the applicant falls under this Code of Conduct?
Because of the reference in the Charter, Justice. Remember, to all members of the board, I just referred you to it.
So a point was taken that a director is not an employee of the board.
I know, that's why I addressed the previous submission to you, Justice. If you go to clause 714 at page 538 of the charter.
Yeah.
Which does. It's not disputed that the charter
Okay.
applies to Mr. Becker as a director.
Mm.
And that provision in 714, do you have it, Justice, at
Yeah, I
538?
do have it. The board
It's
and
it.
all individual directors must ensure that the principles set out in the code are observed in all the activities of the board.
Of the board.
Yeah.
Not of the regulator, Justice, of the board.
Mm.
And that we submit just on a plain reading, but certainly on a purposive reading, includes actions or activities of directors of the board.
Okay.
So on the basis of that, we submit that, but there's a further submission, which I'll get to in a moment. But we submit that the code of conduct plainly, despite its apparent reference only to employees, is because of that reference in the charter applicable also to board members, but there's a more fundamental reason why it is applicable to board members as well, Justice, and that is because of its content. The Code of Conduct and Ethics, as the name suggests, is a template for how employees of the regulator are expected to conduct themselves. And it includes...
Excuse me, are the members of the board also required to sign the code of conduct, this code of conduct?
No, I don't think they signed the Code of Conduct. I don't think anyone signs the Code of Conduct, as far as I know, Justice.
Sorry, the acknowledgement. I'm looking at clause 3 at 550.
Sorry, 550.
550, top of the page, heading scope. This code is applicable to all employees of the NNR.
Oh, I see.
Employees will be required to sign the acknowledgement and undertaking form contained in the appendix. I would imagine this is an annexure to the code of conduct.
You're quite correct, Justice. It is to be found in 564 of the papers. I can't tell you whether or not Mr. Becker or board members are required to sign this, because I don't think it's dealt with on the papers. He's not an employee, so we don't rely upon him having signed this as being the basis for it applying to him. We submit that it applies to him, Justice, for two reasons. The one is clause 714 of the charter, which requires the code of conduct to be observed in all activities of the board, as opposed to the regulator. We submit, as I've submitted to you, activities of the board can only be conducted via directors, and henceforth the individual members of the board are bound by the code of conduct as much as employees are.
Okay.
Whether or not they sign the appendix that you found at 564. But the more fundamental reason, Justice, is that the code deals with matters which one can expect any responsible organization will require from its employees and those who are associated with it. And it would be incongruous in the extreme to have a board that is not, and its members who are not bound by a code of conduct and ethics, but they are responsible for enforcing the self-same code of conduct and ethics on their employees. That would be an incongruous situation. And for instance, you find at 551 of this code of conduct prohibited grounds that persons are not able, that employees may not act against or may not display, include the things one could expect. Race, gender, sex, pregnancy, etc. Any other ground where discrimination causes or perpetuates systemic disadvantage, undermines human dignity, etc. Now, it could never be suggested that these are not applicable in the same manner to board members. That would be a very strange situation to adopt, or a strange situation to advance. But I'll leave it there. I'm not going to take that further. We submit it does apply for those reasons.
Okay.
And then the last governance provision or governance document I want to refer to, and it's also referred to in the letters to Mr. Becker, where his conduct is raised and discussed by the board and ultimately by the Minister Justice, is the media policy that you find at 571. You find it at 571.
Yep.
Sorry, you found it at, it begins before. No, the policy actually begins slightly before then. It begins at 565. It's TM7. The relevant page I want to, the relevant provision I want to take you to, Justice, is 6.1 at 571. The chairperson of the board of the regulator's board of directors may, in consultation with the board, issue statements on pertinent issues arising from the board's responsibility arising from the board's responsibilities. And then the next page, top of page 572, employees designated by the CEO are entitled to make statements concerning current operations within their particular areas of responsibility, but not regarding circumstances that could potentially affect the corporate image and reputation of the regulator. So you will see the first provision deals with the members of the board, and the second deals with the employees. And then there's the second paragraph in 572, except for the above, in other words, covering both categories. We submit a proper reading of this provision, covering both directors and employees. Except for the above, no interviews may be granted to the media, including the expression of personal points of view, opinions, or insinuations of any kind, without the involvement or authorization of the CEO or his or her designee. And we submit what that means, Justice, in plain English, is that personal opinions, points of view, etc., that pertain to the very work of the regulator cannot simply willy-nilly, whether you're an employee or a member of the board, be issued in the public domain without having clarified that is, without having cleared it as provided here in the policy with the CEO or his or her designee.
Does that not refer to the business of the board? Does it refer to personal matters or organizational matters of the members of the board?
It wouldn't refer to personal matters of the members, Justice, but if it pertains to the work of the board and the regulator, the work of the regulator,
Yeah, of
and
the regulator.
and the operations of the board, yes, we submit it does. But not to a personal, so no, it obviously wouldn't apply to personal views on an unrelated matter by either employees or board members. We submit that is the governance background to the matter, and the court will have regard to that in considering the case. So that's the first aspect I wanted to address, Justice. The second aspect is Mr. Becker's conduct since being appointed. Now, this has been traversed on my learned friend, Mr. Borgstrom. I'm going to attempt not to cover the same ground, so I'm going to emphasize perhaps slightly different aspects. As he did, I'll begin with the Energize article. You will know, Justice, as I've pointed out in the letter of appointment, Mr. Becker was appointed with effect from the date of the letter, which is 10 June.
10 June, yes.
He was only inducted as a board member, i.e. the formal training, etc., happened on the 8th of July. We submit nothing turns on that because, as the letter itself says, the date of appointment is the date of the letter. And in his affidavit, supplementary affidavit, one of the affidavits, he says that he received the letter on the 14th of June. Nothing turns on that because the letter is dated 10 June. Nothing turns on 8 July because he was already appointed in June. So the June date is important because on the 30th of June, Justice, is when the Energize article is published. You've energized until Bob. I said energize. I'm being corrected that I said energize. It doesn't matter. The Energize article, Justice, you find inter alia, I've referenced it at 583 of the papers. Well, sorry, it begins at it's TM9, to the chair's answering affidavit. It begins at 580, and if one goes to 583, Mr. Borgstrom's already referred to these passages, and as I said, I just want to emphasize aspects of it. So you will see at the bottom of 583, there's reference to it's disappointing to see money and time being spent on pursuing nuclear power. For Taspint, after the government has said there's no money, etc. And then halfway down that the next page at 584, there is remarks attributed to Becker, Mr. Becker, about the existing Quebec plant is more of a concern, where reactor 1 was down since January due to an increasing leak rate of a steam generator within the containment building, says Becker. Plant manager was suspended on 4 June, etc., etc. So that one can accept that's a reference to Eskom, the operator of Quebec Power Station Justice, not to the regulator. Then at the bottom of that page, Mr. Becker is reported as having said that the revived interest in the Taspint side is just a distraction from more pressing issues. And then he says what those are. We should be worrying about the safety of the existing plant at Quebec, especially as it approaches the end of its design lifetime, he says. Now, can I just pause there, Justice? Everyone is in agreement that this case, or rather the core function of the regulator and thus the board who oversees its activities, is nuclear safety. We know that from Section 8(1) of the Act, which, we know it from the objects of the Act, Section 5, which you've been taken to. And then we know that one of the core functions of the regulator is to issue nuclear, in terms of Section 7(1)(a), grant to amend nuclear authorizations. That's its core business, the granting or amendment of nuclear authorizations. The rest, if you run through Section 7(1) are, with respect, ancillary or subsidiary functions of the regulator. And then we know that in terms of Section 5 of the Act, as you've been told, safety lies at the heart of what the objects of the regulator are, and you find that inter alia in 5A and 5B. And there's no dispute about that. So with that in mind, Justice, we then see, and this is, as I've just submitted, between his appointment and his induction, before he's ever attended a meeting, his first meeting, I think, is the 29th of July. And in this article, this is what Mr. Becker says. That we should be worrying. Now, this is a board member speaking. We should be worrying about the safety of the existing plant at Quebec, especially as it approaches the end of its design lifetime. First reference, Justice. And then on the next page, 585, the following two crucial paragraphs appear, where he says, safety standards were different in the 1970s when Quebec was built, and modern reactor designs are required to have several additional, modern reactor designs are required to have several additional safety features. There are several issues that need to be addressed before the Quebec plant can be considered safe by modern standards, and that will come with a significant cost, says Becker. Much like an old car, there comes a time when it is just not worth repairing it to the point where it is as safe as a new car. It was unwise to spend money refurbishing the plant before finding out what would have to be done to obtain a license to extend its life. And then there's a reference to load shedding continuing. Now, those comments we submit were entirely inappropriate and improper for a board member to make in public. Doesn't matter whether he'd been inducted at this stage. This is the very stuff that will have to come before the board. The lifetime or the extension of the lifetime of Quebec. And in considering the safety case, and I'm going to refer you to further documents in due course. And sorry, I should have told you or telegraph justice, there are four aspects under this heading that I'm going to be dealing with. The Energize article is the first one. And I'll take you to the facts dealing with the others. But for a board member in public to be saying this about a matter that is due to come before the board, which he knows will come before the board, we submit as improper, and it is in breach of the governance prescripts I've read to you, or I've referred you to before. So this is his first, we submit, act of misconduct. He's saying in public that, as a fact, that there comes a time when it is just not worth repairing the plant to the point where it is as safe as a new car. And he makes the analogy to an old car. So he's telling justice, the world, members of the public, and Eskom, that effectively this plant that you want to extend the life of is never going to be as safe as a new plant. And that goes to the heart and soul of the matter. He's made up his mind, his views, and can I emphasize this? It's not just that he's made up his mind. The essential or the aggravating feature of his misconduct, and it is, we submit, an act of misconduct to make up his mind on this issue that's going to come before him as a member of the board and then state it publicly, because that causes, we submit, reputational issues to arise vis-a-vis the board. This is a board member who will have to decide this, and he's already saying what his views are. But what makes it worse, Justice, is he's saying as a fact, and he's sending it out into the world, that whatever you do in respect of this plant, it's never going to be as safe. And thus, and this is a fact. Just as with an old car, there comes a time where you can't repair it, you should get yourself a new car, or in this case, not get a new car, but stop driving altogether and get a new form of transport. Because that's what ultimately KAA and Mr. Becker want. They don't want nuclear plants in the country. They want sustainable alternatives, wind power. In fact, some of the articles you'll see later says that the money to be spent on Quebec should be spent on sustainable energy generation capacity. So we submit therein lies the misconduct. He's saying, as a matter of fact, to the world, before a safety case has ever been made to the board on behalf of Eskom, that what you're busy with will never be as safe, and it accordingly poses a risk. That goes to the heart of the regulator's business and the heart of what the board will have to consider before 2024 on the papers. And that's an act of misconduct. Not anticipatory misconduct, but actual misconduct, Justice. So that's point number one. Then, and we deal with this, we make submissions, we say in our heads of argument at para 21 that we summarize what he said. We say Mr. Becker does not deny having made these statements, which are in the public domain. They concern an application by Eskom, which is yet to be placed before the board. What Mr. Becker's statements did is to create the impression that he's principally opposed to the extension of the lifespan of Quebec before even having considered the application and its compliance with the relevant regulatory processes, which is what the regulator is concerned with. This is what informed the board's fear that Mr. Becker had a predetermined view which would taint his vote on the issue. And we submit there's nothing remarkable, strange, or bizarre about the board concluding that in the light of this article. The next piece of evidence that we want to refer to, Justice, is Annexure TM12, which you find at page 594 to 5. Again, an annexure to the chairperson's affidavit. And this is the email of Mr. Becker to the chair. It's dated 27 July 2021, before the first meeting. And it's where he asks for guidance, he says. In fact, that's the subject, request for guidance, incremental decisions. And effectively what he's saying is that The third paragraph, perhaps I should begin with. He says, in the recent TC meeting, 15 July, we heard of several steps that are being approved at Kuberg relating to the steam generator replacement process and other aspects of LTO, long-term operation. And then he says in the next paragraph, it seems clear that with the current license for Kuberg expiring in 2024, the replacement of the steam generators in 2022 and thereafter is not economically viable if the life of the plant is not extended after July 24. And then he asks a question, is the regulator at risk of in effect giving tacit approval for LTO by approving all these processes so close to the end of the current license? In other words, I have a concern that by approving these incremental steps, we are creating a situation where we are undermining the ability of the board/TC to make an unfettered decision whether or not to grant a license for the LTO. Now we accept, the board accepts, the chair accepts, Justice, that this was an internal email. So we have no quibble about this being an example of him talking to the world. That's not the complaint or the concern. The concern about this email is it demonstrates a fundamental misunderstanding on the part of Mr. Becker as to what the role of the board is. Because he's saying, well, in as much, so he's saying a few things. The first thing he says is, if is applying to the regulator for permission to undertake various items of work, including regeneration, replacement of steam generators. And by giving these approvals, is the board not painting itself into a corner where ultimately it'll have to say, well, we've given you all these other permissions, whether it's a legitimate expectation or whether so much money has now been spent, we can't now say no to the LTO. I mean, that's what he's asking. He says, that's my concern. Are we not creating a situation where we are undermining the ability of the board to make an unfettered decision whether or not to grant a license for the LTO? Now, the posing of that question, and let's accept Mr. Becker had not yet attended a board meeting, etc. Maybe this was inexperienced naivety talking Justice. But it demonstrates, we submit, a fundamental lack of understanding of the way in which the board operates. Because as explained by the chair, and you find this at Annexure PB 6.3 to the founding affidavit at page 104 of the papers, you find the chair, Mr. Mashudi's response to Mr. Becker. And that response is dated 1 August. Do you have it, Justice? Annexure PB 6.3 at 104. Sorry, Justice, do you have it?
Judge, you're on mute, Judge.
I don't know. Sorry. I'm saying I'm at page 104, PB 6.3. Is the Kuberg alert email dated 6 April 2022.
Yes, Justice. Well, the email on top is a later, I think, a forwarding email. But
Okay.
between Mr.
There's another
Mr.
one.
Becker, Mr. Becker and his attorney.
Mochudi.
Tapela Mashudi, 1 August is the email.
I see that one.
The one above that is a forwarding.
Okay.
So it's Mr. Mashudi, the chair's response to the email earlier that I read to you by Mr. Becker, where he asked for request for guidance. So this is the response on the 1st of August, a few days afterward. And essentially, the chair explains to me in great detail, Justice, this is a lengthy and detailed email, as you'll see. It goes from 104 to 105. And the chair says some of the concerns you raised were either directly or indirectly addressed at the board meeting, but let me emphasize a few of them here. My understanding of licensing is that it is, by definition, a process and so is nuclear safety. To allow manufacturing of long lead times, incremental approvals can be performed even before the design and construction safety case have been approved. These are all done at the applicant's risk because final authorization can still be denied following construction and commissioning. Another aspect to emphasize is that there is no incremental approval of LTO. In other words, lifetime operation extensions, which is, remember, Justice, Kubik was designed in the 70s, built in the 70s by the French, with a 40-year lifespan. That's due to come to an end in 2024. And Eskom, is now attempting to put itself in a position where it will be able to apply to the regulator for a 20-year extension of that, for another 20 years, in accordance with government policy.
Yeah.
That's the factual scenario or the factual background to this case. Now, in the light of that, the chair is explaining the position to Mr. Becker after he's asked the question. The chair says, I'm not going to read this entire thing, but just a few paragraphs. The second paragraph, modifications, maintenance, etc. are part and parcel of nuclear operations and in line with the principle of continuous improvement and periodic safety reviews. And then the next paragraph, as early as 2010 already, Eskom identified key components that would be needed to support their case for LTO. So in other words, their intention to want to extend Kubik's lifespan is not something that arose recently. It's been in the making for more than 10 years, Justice. And they've been thinking about it, as one could expect. This is the only nuclear power station in Africa, I believe. In fact, it is. And the only one in this country. And obviously, they have a long timeline and horizon. And then he says, it is correct that if LTO is not approved, the investment in the new SGs, steam generators, is wasted. But that is not the regulator's domain. In the case for LTO, the plant must be demonstrated to be fit for purpose before life is extended. The operator is aware of that. That is why they are implementing the necessary modifications and performing required studies to support their, arguments for safe long-term operation. To say we have several steps to approve LTO is not correct either. The LTO safety case to support the application for LTO, for extension, Justice, must address various aspects, including demonstration of components' integrity for the intended period, aging management, etc. The approval of the safety case and recommendation to the board is the only step for approving LTO. So what the chair is explaining there is not a case of incremental approvals which finally leave you with no option but to grant the approval, as Mr. Becker seems to think, and as his request for guidance suggests. And thus he says, are we not painting ourselves into a corner? Now here the chair is going to great length to explain to him, no, that's not the case. It's not incremental. It's a one, when they present their safety case in 2024, whenever they present it. And when
he was trying to give a background in that an investigation has been conducted as well.
Not only a background, Justice, with respect, he's explaining the process. He's saying, no, it's no question of incremental. You're not building yourself here into an impregnable position, Eskom. They must do those, or they can apply for those incremental things, but they do it at risk. When they put up their safety case ultimately, and they ask for the extension, that's when they're going to be judged. And obviously they must be judged on the case they put up. And if that case is not good enough to satisfy the regulator, i.e. the board, that it's safe to extend the lifetime of Kubik, then it won't be extended, regardless of the amount of money you've spent, and regardless of the previous approvals we may have given you. That's the essential thing that's being conveyed here. So your concern...
Mr. Jamie, let me warn you, also our license here can't be extended beyond 4 o'clock.
I'm going to try, I know I'm now...
Yeah.
Yes.
Yeah, I do enjoy your argument, but also we have to look at the time.
I'm glad, Justice.
Yeah.
But I'll try to go faster.
Okay.
And then just I would ask the court to have regard. I'm not going to read it in light of the time, Justice. The same points are made in the last two paragraphs, substantive paragraphs on page 105, with it. The same thing is said. there's no question of building yourself into an impregnable position. The third piece of evidence, justice, or factual material we want to refer to is TM 16 to the chair's affidavit, answering affidavit, which you find at 621. And that, justice, is the you will recall this, that a journalist, and you see that at the top of page 621, on 18 August, writes to Gina Munsami, an official of the regulator, and she asks, she's working on, or she asks him, is there any truth, or what's the position with regard to, they understand that the Eskom life extension application has been received by the regulator, and has any subsequent approval been made? And that's asked in the context of a statement issued by the KAA, which you find at the bottom of that page 621. Now, in that statement, Justice, the KAA says,
are you referring to the statement of the KAA? Mr. Jamie, I can't hear you. What's happening now? Can't hear you.
I'm not on mute, Judge. Can you hear me now?
Okay, I can hear you now.
I'm terribly sorry. The KAA statement says that recent media, KAA notes recent media stories that claim Jacobs Engineering Group has secured a contract to extend the life. And then it goes on to say that the fact the contract has been announced before the regulator has indicated it has even received the life extension is deeply concerning. The regulator has the mandate to protect the public, but to allow Eskom to ignore the process and make this announcement as if the extension is a done deal calls into question the independence of the regulator. Now that, as you can imagine, Justice, was perceived by the regulator as being
when was the statement issued? What was the date of the statement?
The statement, Justice, I can't tell you whether it was issued, but it was certainly released to the media. And it was done by August the 18th when the reporter Francesca Villette from INL sent it to Gina Munsami to say, I'm working on a story, she does say, I'm mailing with regard to the below press release issued over the Kuberg site. So I can't tell you the date of the issue, but it's before 18 August, on or before 18 August. And so there they say, this calls into question KA, of which Mr. Becker is the spokesperson, that this statement in relation to Jacobs Engineering calls into question the independence of the regulator. The next page is then the imbalance of power between Eskom and the regulator is also a concern. Total annual budget, etc. They say the fact that the regulator receives about 75% of its revenue from applications and authorization fees, and the bulk of that is from Eskom, only adds to this concern. Without those fees, the regulator would not even be able to pay staff salaries.
Mr.
Now, these
Jamie,
are very...
Can I ask that we just stand down for just 1 minute? There's something that I need to take care of.
Of course, Justice.
Ishmael, how much longer are you likely to be?
15 minutes, 10, 15. I'll try to be 10, Jeff. Are you getting irritated with me?
I think the problem is that your points are too good, Ishmael.
Okay.
All I'm saying, yeah. Okay.
Just hear me out. Up to you. Jeff, I'll try to be done in 10. Okay.
Thanks, Ishmael. Very grateful. Sorry we've put you under that pressure. Partly my fault.
Mr. Jamie, I'm back.
As the court pleases justice, I'm going to try to make this as quick as possible. I was on at page
On the
621.
statement.
Yeah, the statement. I accept the court will look at this. I'd refer to the fact that the statement alludes to the fact that without the fees from Eskom, the regulator wouldn't even be able to pay its salaries. We submit that those statements, i.e. the calling into question of the independence of the regulator, and then this implied suggestion that the regulator is improperly influenced by Eskom because it gets so much of its income from Eskom, is highly improper. We accept unequivocally that this is not directly attributable to Mr. Becker in as much as his name is not here. But what is signally clear, Justice, is that Mr. Becker does not distance himself from this. He's never publicly distanced himself from this. This is a statement by the body that he is the spokesperson or a prominent member of. He's also a member of the board. This speaks directly to the independence of the board and the regulator on whose board he serves, and he has not distanced himself from this. And that's the point we make. And then the statement says there are several questions that the regulator should urgently argue. And the second bullet one is, does the regulator intend to hold any public participation for the major decision of whether or not it will be safe to continue to operate the Kubo plant beyond its intended life? And then the next one, has Eskom already been told behind closed doors that their license application will be granted? That is totally improper. For a member of the board of an organization that issues this press statement, Justice, in the midst, not at some random time in the past, but in the midst of all of this, this comes when he is, as far as I understand, suspended or about to be suspended, but not yet dismissed. He only gets dismissed in February the following year. For him not to distance himself from this is, we submit, inexcusable. It demonstrates his conduct and, in fact, misconduct. And then the last question is a pointed one. When it comes to making a decision, will the regulator apply the same rigorous safety requirements as the French, who designed Kubo apply to nuclear plants in France? Now, how else are members of the public who read the statement, Justice, supposed to understand it? This obviously impugns the efficacy, integrity, competence, and compliance with the statutory obligations of my clients. How else can it be read? And here it is in the public. And he does not distance himself from this, but yet he wants to be put back on this board. We submit it's an intolerable position. The last piece of factual material I want to refer you to, Justice, is TM19, which you find at 633, and that is an article in the Daily Maverick, and the date you find at 635, it's 16 December 2021. By this point on my calculation, Mr. Becker has been suspended by the minister, but he's yet to be discharged. And here, this article does quote Mr. Becker. So, the article begins, Eskom is on the verge of beginning its 20 billion project to extend the operating life of Kuberg by 20 years. And civil society organizations held a protest to question its safety and to call for public participation in decision-making processes. Now, you will know, I'm not going to take you that under the time, Justice, but in response to Mr. Becker's queries about is there going to be a public participation process, he's told in terms there will be one. It's required there will be one for the LTO, but not for all the incremental so-called decisions. But on the LTO there will be, so he knows this already. But this is the context of the protest. And then Mr. Borgstrom referred you to 636, the moral component, etc. And this is not, and this comment is attributed to Mr. Becker himself. Again, he's called spokesperson for the KAA. That this decision, the life extension, is not for a bunch of engineers to decide alone. That is why the community needs to be consulted and the public needs to have their say, says Becker. If I can just pause there, Justice. There's an attempt in reply to suggest that this remark, a bunch of engineers, is a remark about Eskom. Now, with the greatest respect to Mr. Becker, that's demonstrably not true. It's not true. It cannot be true because what's being referred here, Justice, referred to here is not Eskom's application, it's the decision which will have to be made on the extension. And that's not a decision Eskom makes, that's the decision the board makes. And it's the board that will have to conduct a public participation process, not Eskom. So this could never be understood or explained away as a reference to Eskom's engineers. And the second part of the attempt to explain it away and minimize this is he says, well, in his reply, there's nothing disparaging about calling engineers engineers. With respect, we've all been around the block long enough to know that's nonsense. To say this is not for a bunch of engineers, but for the public, is of course being disparaging of the technical people involved. They're a bunch of engineers. Of course it is. I don't need to give you legal authority for that proposition. So it's disparaging, it's dismissive of the regulator's employees, and it's insulting of the board. And then this article goes on. This article is a serious indication, Justice, not of, can I emphasize this, as my learned friend Mr. De Beer, he's a very clever young man, but his argument was not attached to the facts. His argument was up there. When you bring his argument down to the facts, this is not a case of anticipatory misconduct. This is actual misconduct. This is misconduct which happened in December or whenever this protest happened. Because the petition, which is then handed out, in fact, let me read to you the top of page 637. At the protest, organizers encouraged attendees to sign an online petition. And then the petition calls on Under the Regulator, CEO of Eskom, to 1. Acknowledge that the Kuberg nuclear power station will never be as safe as modern nuclear power station designs. The very issue, Justice, the safety issue, that the regulator and the board will have to decide. Here's Mr. Becker shooting his mouth off in public, protesting with his T-shirt, as you see on page 639, I think it is, that this is unsafe. What message does this send to the public about the same body, the T-shirt is at page 640, that he sits on? They call upon Eskom to shut down the station in 2024 as originally planned, not run the station after 2024 while it lacks modern safety features such as a core catcher etc., etc. Not spend billions upgrading a station from the 1970s, and then the one I alluded to earlier, divert the funds allocated for extending the station to support community-owned renewable energy. The point, Justice, especially the reference to not run the station after 2024 while it lacks modern safety features, is precisely the sort of thing that needs to be assessed and decided upon by the board after Eskom presents its safety case at board level. It is totally improper for a member of the board to be part of a public protest where this petition, he is actively associated in this article with this petition, calling on members of the public to make these demands of Eskom. You cannot sit. This is misconduct on the part of the director of, albeit that he was under suspension. It doesn't make a difference. This is misconduct. And you've heard my learned friend, Justice, that these may not have been among the reasons given, and thus my learned friend, Mr. Butler, decided to not deal with it. Well, if you decide not to deal with it, he'll live with that election. But the point is, regardless of, and the law is not as clear on this question of, are you always confined to the reasons? I don't have the time to address that, but the one thing I will say, Justice, if one considers the authorities that are referred to, both constitutional court judgments referred to as authority for that proposition that you're confined to the reasons. They refer to, I just want to see where's that dealt with in my learned friend's heads. 22. My learned friend, Mr. Borkson, says the minister did consider the DM article, so I understood there might have been some, I know I might be getting this wrong, but I understood that there was some suggestion that...
Was that part of the reasons that were made at page 66? Is it page 66?
Let me just check, Justice. And I know I'm now going over the time. I apologize. 66 is the minister's
reasons.
193. And I'll just have a look, Justice. I'm told 193. Yeah, there's reference to that article, Justice, although the date seems to be different to my date. If you look at the minister's letter PB16 at 191, in fact, this is the letter of discharge. Sorry, this is before the actual, this is the second opportunity to make comments. And in this letter at paras E and F at 193, there's reference to the article referring to a bunch of engineers and the other comments attributed to KAA and Mr. Becker.
Which paragraph is that at 193?
193, para E, Justice.
Okay.
Halfway down the paragraph, most recently on 2 February 2022, in an article in the Daily Maverick, you are quoted as saying that decision should not be taken by a bunch of engineers,
Okay.
but that the public and other stakeholders should be involved. That appears to be the same article.
Okay.
The minister did have regard to that, it would seem.
So they misquoted the date. The minister misquoted the date here. That's what I'm saying.
As I understand it, Justice, but it certainly seems to be...
There was another Daily Maverick or other publication by Daily Maverick on the 2nd of February.
I don't know, Justice. I can't assist you there.
Okay.
I just know that the reference to a bunch of engineers... I don't think the reference to a bunch of engineers was repeated more than once. So we submit that on a conspectus, Justice, of the article, the DM article that you find at page 633, TM19 and onward, The comments attributed to the KAA and, in fact, Mr. Becker's active involvement in this protest, etc., is simply inimical and entirely not only inappropriate, but irreconcilable, sorry, that's the word, with his position as a director of the board. Those are the facts, Justice. Two more things I want to address very quickly. The one is misconduct. I'm going to run through these because I've run out of time. I'm sorry for taking up more time than I indicated. Misconduct,
the
Justice.
misconduct was not anticipatory. The misconduct was committed and completed. That's what we're saying.
I've made the factual submissions in that regard, Justice, that the misconduct, what I've just referred you to, is we submit evidence of misconduct. And it's not a question of anticipatory misconduct, it's actual misconduct. These comments were made in the public. So remember, Justice, we emphasize as the board the comments made in the public domain that impugn the integrity and compliance with the statutory obligations of the board. We submit the examples I've given you. The one is internal, and you'll recall that's the email, and I say that demonstrates the lack of understanding of Mr. Becker at that point. The other three are public. And what is clear is that despite the efforts that the chair goes to explain the position to him, he persists and doesn't distance himself from the KAA's persistence with this idea that the board in some other way has reached some sort of secret backdoor agreement with Eskom that they're going to allow Eskom to just go through the motions and this extension will be granted in due course. And they won't properly consider the Eskom safety case. That is the misconduct. That is why he can't be a member, and that is why the minister correctly discharged him. That's our case. Okay. Now I'm going to deal, Justice, just with the nature of the misconduct from a legal point of view, and then I'm going to deal with remedy. My learned friend, one of my learned friends for Mr. Becker said that it's not enough to have views. Misconduct requires conduct. We entirely agree. Obviously, it requires conduct that is manifested so others can observe it. The point we want to make, Justice, is that unlike, for instance, Section 194 of the Constitution, which regulates the removal of the public protector, which is in the news at the moment for all the wrong reasons, litigation, Section 194 of the Constitution requires a process which has to be complied with before the public protector can be removed. Interestingly, one of the grounds for removal there is also misconduct.
Yeah.
It's misconduct, incapacity, or incompetence, but before the public protector, or in fact, a Chapter 9 incumbent can be removed, there must be a finding to that effect by a committee of the National Assembly. Mm-hmm. And you'll be aware that there's been litigation, and the National Assembly, in fact, approved rules to regulate that process. So now there's a process which must be run before that committee can recommend to the National Assembly that a Chapter 9 incumbent be removed. Non-constat that year, Section 9(1)(c) simply says for misconduct. The minister may remove a member of the board for misconduct. It doesn't constrain that by saying the minister must go through a particular process with the judicial, quasi-judicial, etc. No committee must report to the minister before the minister may remove the director for misconduct. Mm-hmm. Hence, we agree with our friend Mr. Borgstrom. It is a value judgment. It is obviously bound by the requirements of rationality we submit. The court need not reach. We've heard the submissions of our own friend Mr. Borgstrom. We agree with him. But it doesn't really make a difference in our submission on the facts of this matter, whether it's administrative action or legality review. The facts of this case are clear enough, Justice. Mr. Becker's committed misconduct. The minister was quite correct in so concluding. The minister acted rationally on the facts that we've presented, that Mr. Borgstrom has presented. This court would not be entitled, as it would in an appeal, to say, looking at these facts, I, as the judge, concludes that you dealt with it wrongly. Your decision on the facts is wrong. Hence, I'm going to set it aside and substitute it with my decision, my view of the facts. You're not entitled to do that. That's an appeal. So you will ask, was this procedurally fair, we submit it was, for the reasons Mr. Borgstrom and I have dealt with in our heads and otherwise, and we submit it was a decision that is rationally defensible. I refer you to what we say in this regard also at para 65 of our heads. We don't have time. To go there, and sorry, I just want to take you to, I do actually want to take you very briefly to our heads of argument.
Okay.
There was
Just a second. Can I ask Ms. Johnson if the time can be extended from Teams? Ms. Johnson, can't you extend the time beyond 4 o'clock?
I'll try, beyond 4 o'clock, Judge?
Yeah, because I don't think we're going to finish at 4.
Okay, I'll try now, Judge.
Just try and extend it, please.
Okay.
Okay. Mr.
As the
Jamie?
court pleases, Judge, Justice. With regard to the argument that Mr. Budlinder advanced that everyone knew Mr. Becker's views and thus the minister can't be heard to complain about Mr. Becker's views, I've made our principal submission in that regard. It's one thing to have views, it's another thing to express yourself and call into question the very body that you serve on, their treatment of the very thing that you have to consider, i.e. safety. That's the extent of our complaint. We don't care whether Mr. Becker is pro-nuclear, anti-nuclear, etc. Our complaint is that he's expressed himself on the safety issue and suggested that the board and the regulator won't do its job. That's his misconduct. And I've made those submissions. Now, in support of that we have no difficulty with Mr. Becker having views, and any member of the board for that matter having views. Can I refer you to what we say, Justice, in para 67 of our heads of argument? We refer to a full bench decision in this division, Amata, where Justice Schloppe for the Judge President Schloppe, sorry, makes the point that it's not
page.
It's para 67 of our heads, Justice. I
Okay.
think it's page 26.
Okay.
My version of our heads may not be the final.
Oh, yeah,
of it.
I see.
Yeah. Hamata, full bench decision of this division says it's not biased per se to hold certain tentative views about a matter. It's human nature to have certain prima facie views. A line must be drawn over between mere predispositions or attitudes on the one and prejudgment of the issues to be decided on the other. Last sentence, no one can fairly decide a case before him if he has already prejudged it. And we submit, Justice, for the reasons we've given, that Mr. Becker has prejudged the case and put himself in the intolerable position that he finds himself in, and that constitutes misconduct sufficient to have him removed and for the minister to have concluded that he was no longer able to continue his role as a member of the board. The last aspect I want to address you on is remedy, Justice. Mr. Budlinder advanced an argument to you, if I understood him correctly, he didn't, I don't think, provide specific authority for the proposition, but he said, well, the argument, and this goes to an argument made by Mr. Borgstrom, the minister, not by us really, but I don't think that makes a difference with respect, because the court has an obligation, even sua motu, in fact, you must sua motu consider the requirements of 172, 172(1)(b), Justice. In other words, that's the provision of the Constitution that requires you, or rather permits the court, to make an order after the obligatory order you must make in terms of 172(1)(a), where you declare law or conduct that is inconsistent with the Constitution invalid. You then may make any order that is just and equitable. And we know there's a very broad jurisdiction, as the Constitutional Court has said. Now, I think my learned friend, Mr. Budlinder, submitted to you that if you found procedural unfairness here, then it followed that you must set aside and you must reinstate, you must declare that to be the case, unconstitutional, invalid, and then reinstate Mr. Becker.
Yes.
Now, if I misunderstood him, if that wasn't his submission, that there's an automatic reinstatement, then I apologize. But if it was his submission, then with the greatest respect to him, it's not correct. There isn't an automatic reinstatement. Justice, as you'd know. And if authority is required for that proposition, can we refer to the very case that our friends rely on, Matau, Constitutional Court judgment? In para 85, Compepe J says the following: to grant appropriate relief, she's now talking, as apparent from the footnote 122 about section 172, Justice, we must determine what is fair and just in the circumstances of a particular case. The various interests that might be affected by the remedy should be weighed up, etc. And then 86, the setting aside of the minister's decision and the reinstatement of the aggrieved parties on award of compensation would usually follow from a finding that a dismissal was procedurally defective and did not comply with the relevant legislative prescripts, but the very exceptional circumstances of this case mean it would not be just and equitable for the court to award such remedies here. A declaration, i.e. of invalidity, is sufficient to address the flaws in the minister's conduct and to draw her attention to the importance of complying with the Companies Act, etc. And then she gives the reasons for that, and she concludes, Justice, in paras 89 and 90 to the following effect. Finally, despite the procedural defects of a decision, the minister had substantively good and indeed compelling reasons for terminating the membership of General Matau and Ms. Mokoena, etc., etc. And then 90, it is evident that the relationship between the minister on the one hand, we read the board replaced for minister on the one hand, and General Matau and Ms. Mokoena on the other, has disintegrated irreparably. And that's the position here. The relationship between the board and Mr. Becker has deteriorated, has disintegrated irreparably because of his conduct. The imputations is made against the board. It would not be just and equitable in our submission to reinstate him, even if you do find that our learned friends are correct in their principal attack. You must then make an order in terms of 172(1)A, Justice. It does not follow at all that you are required to make an order in terms of 172(1)B, reinstating Mr. Becker, let alone reinstating him retrospectively. Our final submission is in relation to the retrospective or the qualification as provided from 172(1)B Roman 1, i.e. that the default position shouldn't apply. It shouldn't be as at the 25th of February, but it should be from the date of judgment. With the greatest respect to Mr. Becker, that's a very self-serving argument. There's no indication why that argument serves the public or any other interest beside Mr. Becker's narrow selfish interests. Why should it be reinstated and have his full term when everyone else will come to an end?
Is there no remuneration at the board in that portfolio?
If that is his complaint, which I won't attribute to him, because in fairness to him, that's not what he's pleaded in his affidavit.
Yes, I'm just asking, that's not what I gathered as well.
I don't know, but I'd like to think Mr. Becker isn't looking for some more emoluments, and that's not the reason, and I won't suggest that it is. So no, it doesn't appear to be that. But I don't know what emoluments they get for attending meetings. It's not in the papers, Justice. But that aside, there is no good reason given except that the fact that he won't serve his entire term. Well, why should he serve his entire term? Everyone else is going to come to an end. This decision was taken in good faith by the minister. If he's found for whatever reason to be procedurally at fault, we submit he isn't, but if he is, why should this be retrospective? There's no public benefit or any other benefit which is advanced while that order should be granted. So we submit that you will not exercise your power to grant such an order, but our more substantive and principial submission is that, in fact, we concur, even though we've not taken that position in the heads or our papers, but we submit we're entitled to, because it's for the court, suo motu, to decide what is an appropriate remedy in terms of subparagraph B of 172(1). It would not be appropriate in this case to order Mr. Becker's reinstatement for all the reasons set out in the papers and that we've advanced. Those are our submissions, Justice. We ask for castness. And if you believe that bar watch applies, then we rest as the court pleases. Thank you.
Thanks. I'm concerned about time now. Ms. Johnson said she tried to extend the time. I don't know whether it's going to be, we're going to succeed beyond 4 o'clock. I don't know. Mr. Badlander?
Milady, I'm not sure how to proceed because we've had 3 hours of argument. And to
that's why I said to Ms. Johnson she must try and extend the time,
Yes.
because you've got to respond to the argument of the council.
Yes, I appreciate that, Milady.
Mm.
Well, I suppose I must just start, and I don't know what happens if we don't get an.
Okay. Let me
So,
ask something from Ms. Johnson before you start. Ms. Johnson?
Hello,
Ms.
Judge.
Johnson, can you resend another link starting from now, expiring some other time that I don't know whether it's 6 or 8 in the evening? Is that doable?
I'll try, Judge.
Just send a
And then
new
you're going
to
to
everybody. So
then
once
everybody
this one-
exits now. Everybody
Yeah.
exits now, and I'll send out a new link.
Yeah, just send a new link
Okay.
now so that when 4 o'clock comes and cuts us, we are able to connect to the new link that we're going to send.
Okay, don't you all rather want to go off now, Judge, and I'll send a new link and immediately you go
And we
on?
start on the new link.
Yes, rather that, Judge.
Okay, let's rather do that because it's going to be cut.
Thank you, Judge.
Thank you.
So we'll now leave.
We're going to leave. Yeah, let's leave.
what the board thinks about this. Let me tell you what the board's in relation to the other. In that event, people may reasonably think that he's speaking on behalf of the board.
Yeah.
And that he's not entitled to do. But if Mr. Becker goes to a meeting of civil society and he says, I'm here because I am your representative on the board. So I'm coming here not to tell you what the board thinks. I'm coming here to ask you what you think so that I can tell the board. That's not representing the board, not purporting to represent the board or to speak on behalf of the board. On the contrary, is doing exactly the opposite, saying, you tell me what you think so that I can fulfill my function of representing your views on the board. And so there can be no misunderstanding about that. And the minister's apparent inability to understand it is, with respect, very difficult to understand. He tries to convert representing the speaking as the civil society representatives, speaking, I beg your pardon. He tries to mix up speaking as the representative of civil society on the board, which is legitimate, with speaking to the civil society on behalf of the board, which is not legitimate. All he was doing was the first, and your ladyship has seen those two affidavits, supporting affidavits, which I read to your ladyship, where the people over there said he told us he'd come to hear what we have to say so that he can communicate it to the board, and he took pains not to disclose any secrets of the board. So that's the minister's fundamental misunderstanding, which he can't escape. He keeps on going back to this. He's just wrong. It's as simple as that. Then the next question I would like to address is the point was made by, and then I think by Mr. Goldstone, that you can't sit on the board of the NNR to promote your anti-nuclear agenda. And that's true. We accept that. But you can sit on the board to insist on safety. And that's what Mr. Becker is doing. He's on the board and he's pursuing a safety agenda. And there's no evidence, none, nil, that he used his position on the board to resist nuclear power. There's none. On desirability grounds, there is no evidence at all that he used his position on the board to resist nuclear power. He's sitting there on the board to pursue and insist on safety, and that is not only entitled to do, that's what he's obliged to do as a member of the board. Of course, what would happen if, so that's the position on that issue. Then the next question is the Maverick article. We say properly understood. The Maverick article is not addressed at the NNR. It's addressed at Eskom, and your ladyship will see the petition and the statements that are made and so on are all about Eskom. And what it is about is saying this question of extension of the life of Koeberg is not a decision to be made by engineers. It's a decision to be made by a much broader range, because there are policy questions involved, and it includes public participation. He was making the case for public participation. Obviously, and he was saying this can't be left to Eskom. He wasn't attacking the board. He was saying it can't leave this to Eskom, who are the engineers, because it's not purely an engineering question. Then the next submission I need to make is to repeat the submission we made earlier, but I need to do it, that the board, that the minister deals with Mr. Becker differently from Mr. Mapoto. He says it's fine for Mr. Mapoto to wear two hats, one as a departmental employee and the other as a board member, and it's fine for him to promote a pro-nuclear agenda, and it's fine for him to speak publicly in newspapers and on radio about why a pro-nuclear agenda is a good thing.
But if I heard Mr. Jamie well, he said Mr. Matopo was articulating the position of the department.
Yes.
So it was the department's policy that he was writing about.
Yes, because he wears two hats. When he writes his articles in the newspaper and he speaks on the radio, he isn't speaking for a board member. He's speaking as the departmental employee, saying this is the policy of the department. And he's entitled to do that because he's an employee of the department. And he has another capacity, which is as a board member. But when he writes those articles, he doesn't speak as a board member. Exactly the same for Mr. Becker. He has two hats. He's a member of the KAA and he's a member of the board. When he issues his public statements on behalf of the KAA, he's wearing that hat, just like Mr. Mapoto is wearing his departmental hat when he issues statements, when he writes and when he speaks on the radio. In neither case are they disqualified from being board members because they have two different capacities. Of course, I accept they have to be careful to avoid crossover and avoid confusion. I accept that. But there's nothing in principle wrong, we submit, with Mr. Becker being a member of the KAA and speaking publicly on behalf of the KAA, as long as he doesn't then trespass into the territory of board. Then can I come to the next item, which is the vexed question of the Eskom extension, the Kubek extension, and that's page 99 of, there's a famous email from Mr. Becker to Dr. Matsudi at page 99. It's PB 6.1, page 99. And that's where he starts, where he talks about the problem of the anticipating a decision on the extension. And does your ladyship have it? Page 19, page 99.
Getting there. At page 99.
Page 99, the fourth paragraph. Now this is Mr. Becker, a board member, writing to Dr. Matsudi of the board, the chair. He says, fourth paragraph, he says, it seems clear that with the current license for Kubek expiring in 2024, the replacement of the steam generators in 2022 and thereafter is not economically viable if the life of the plant is not extended after July 2024. What he's saying is it's not worth spending all that money on replacing the steam generators just for 2 years if there's not going to be an extension. Now, there's nothing wrong with that statement. He says...
Let's put this email on context. What motivated the applicant to write this email to the chairperson?
Can I show you what he's saying, what motivates him, lady?
Yeah.
He says, therefore, he says, aren't we at risk of in effect giving tacit approval for the LTO, for the extension, by approving all these processes so close to the end of the license? What he's saying is, if we say to them, sure, you can go ahead and replace the steam generators, they're going to incur a substantial cost. And aren't we painting ourselves into a corner that when they come for the extension, they'll say, look, we've just spent all this money on this. How can that go down the tubes for just after 2 years? Aren't we creating a situation?
Did this issue come before the regulator for its consideration?
It hasn't yet come, but it's going to come. He says we know that what's going to come later is a request for the extension of the life. I mean, if we approve the steam generators now, the obvious argument that will be raised is, well, we've just spent an enormous amount of money on the steam generators. Are you really saying we can only use it for 2 years? And so he says there's a problem. And then he suggests a solution, a practical, constructive solution. He doesn't say don't approve the steam generators. He doesn't say don't approve the extension, which isn't before the board yet. This is what he says in the second last paragraph. He says, if this is a concern shared by others on the board, this is a very collegial approach. If this is a concern shared by others on the board, it could perhaps be addressed by grouping all the authorizations which are part of LTO into one decision and run a public participation process on that before granting any further incremental authorization. So he's saying, instead of dealing with it one egg at a time, or one piece at a time, let's put it all in the basket and look at it all together at the same time, and then we will make decisions which are rational and which are coherent. So now you may disagree with it. You may think that's not a good idea, but what he's doing is he's seeking to protect the board. He's seeking to protect the board from any undue pressure.
But how do you protect the board when this issue has not become an issue yet?
You protect the board, my lady, by the board saying, to Eskom, we see your application for steam generators. We think we need to deal with all of this as part of the extension of the life extension. Bring your life extension application at the same time, and we'll deal with all of it together. And then we won't find we've painted ourselves into a corner, and Eskom painted you into a corner by getting you to spend all this money, and then afterwards we might say, no, you can't have life extension.
But my problem is he's only engaging the chairperson of the regulator. What
Yes.
about the other members of the board? What was he not supposed to have put this before the full body of the
Well,
regulator?
that's what he's proposing. He says, if this is a concern shared by others, in other words, if this is a concern shared by others on the board, in other words, we should raise it with others on the board, here's a possible solution. So he's saying in a collegial way, we're going to find ourselves painted into a corner. This is a way we might solve it. If other people agree, then let's do it this way. Now, can I say, milady, you may think that his proposal is a good one or a bad one, a practical one or an impractical one. But the one thing you can't say is there's anything illegitimate about it. He's trying to protect the board.
There's nothing illegitimate about it, but is it not tantamount to influencing the decision of the chairperson, given the fact that he's the person who's responsible for the rulings that are made in the regulator?
Yes, he's trying
Why raise this with the chairperson only, whereas there's a full body of the board? Why does it go to the board?
Well, he was clearly had in mind that it would go to the board. He says to the chair, I think this is a problem. He says, if this is a concern shared by others on the board, in other words, we would have to put this to the board and see what the board thinks. Here's a possible way of solving it. It's a completely cooperative attempt. And we also on boards and committees, it's very common that a member of a committee or a board comes to the chair and says, look, I've got a problem. I think this needs to be placed before the board for a decision. That's a proper thing.
This email doesn't say so that it should be tabled for discussion at the next board meeting, perhaps.
Well, he says, with Milady, he says, if this is a concern shared by others on the board, we would only know whether it's a concern shared by others on the board if the others on the board were asked, what's your view on this? This is a problem you've got. And all he's saying is, if you agree with me, let's put this before the board and let's see whether they share the problem. And here's one solution, my proposed solution, which may be a good one or a bad one. But there's nothing with respect improper about a member of the board approaching the chair of the board to raise a problem and saying, if you agree with me, let's go and ask the other members of the board. So that's the, sorry, I interrupted your ladyship.
No, it's fine, you may proceed.
That's with respect to the what's going on there. And Mr. Becker, of course, is a new member of the board. He's going to the chair for guidance. He's going to him politely, courteously saying, I see a problem coming down the road. Don't you think we should deal with this? Let's raise it with the other members of the board. That's highly responsible. I think it would be more responsible.
When was the first board meeting held? It was in July, I do understand.
This, I'm not sure, it was in 29 July, I'm told. This is an email sent on the 27th of July.
Okay.
So there's a board meeting about to come. And he's saying, don't you think we should raise this with the other members of the board? So we say there's absolutely nothing sinister at all about that. And it's a highly responsible way to deal with the matter. Then the next, and can I just say yes, I won't go there. Right. In the interest of time, let me cut that short. So those are the main issues in response to, and can I just say that this has nothing to do with prejudging desirability or introducing desirability. It has to do with saying, let's make our decisions coherently. Then if I can come to the matters raised by my learned friend, Mr. Justice, learned friend, it's not Mr. Justice, my learned friend, Mr. Jamie. A lot of what he submitted were submissions about why the board believes that Mr. Becker committed misconduct. Yeah. It was all about the board thinks this and the board thinks that. With the greatest respect to Mr. Jamie and the board, what the board thinks is irrelevant. It's the minister who fired Mr. Becker, not the board. And it's the minister's reasons which your ladyship has to assess, not the board's reasons.
Ultimately, if this court decides to reinstate Mr. Becker is going back to the second respondent.
Yes, I'll come to that in a moment, if I may.
Mm.
But I do want to make the submission that if your ladyship has to decide whether the reasons for whether the discharge is valid, whether it was lawful, your ladyship will look only at the board's decisions, because I beg your pardon, your ladyship will look only at the minister's reasons, because it is the minister who discharged him, and it is the ministers whose reasons are relevant. And that's track law, and the Constitutional Court has said so in the Nurser case. You can't look at other extraneous reasons. You look at the reasons the minister gave, and that's the famous page 66 in PB1. So they are irrelevant unless they are in PB1, and that also relates to the Maverick letter, the Maverick article. The minister refers in his letter of the 16th of February, when he writes to Mr. Becker, give me reasons why I shouldn't fire you. And one of the things he does it on the 16th of February and at page 193, and he refers to the Maverick article. That's all correct. But when the minister gives his reasons, he walks away from the Maverick article. He doesn't refer to the Maverick article at all. And so he doesn't rely on the Maverick article as a reason for the decision. He raised it as a question. Mr. Becker answered it, and apparently the minister was satisfied because he didn't raise it in his reasons at page 66. And he can't now go back and say, oh, by the way, what about the Maverick article? He knew about the Maverick article. He didn't raise it as a ground in page 66, so it's irrelevant. Then
the title of the letter is Notice of Discharge of Mr. Peter Becker.
Yes.
Why can't this court take notice of that of those reasons at 193?
Because that wasn't a notice of discharge at 193.
Yes.
That heading is with respect misleading. It's a notice of contemplated discharge of Mr. Becker. At the end of the letter, it doesn't say, therefore, I discharge you. friend, Mr. Jamie, referred to the Motau case, and he's correct in referring to the Motau case and to what was said by Justice Kampepe.
It's paragraphs 85, 86, 89, and 90 that you referred to.
Yes, it's paragraphs 89 and 90. And perhaps I overspoke. I do not suggest, I did not intend to submit that if there is a procedural irregularity, the decision can never be permitted to stand. We have to accept that the board will, that the court will have to make a decision as to what the remedy is going to be. And I can't dispute that. And Motau was one of those exceptional cases where the court said, even though there was irregularity, I'm going to allow the decision to stand. The court did that, notwithstanding the fact that we know there's that old rule about the no difference rule. You can't say it was procedurally unfair, but it wouldn't have made a difference, so just let it stand. The courts have been saying for hundreds of years that's not the law. That's not an answer. You can't just say no difference. But in this case, Justice Kampepe said that and I seem to have the wrong, I'm sorry, I have the wrong, here it is. What Justice Kampepe said at paragraph 89, she said two things. She said, despite the procedural defects of her decision, the minister had substantively good and indeed compelling reasons for terminating the membership of General Motau and Ms. Mokoena. So now that's one thing she considers. She says they've got good reasons. Secondly, she says the relationship between the minister on the one hand and General Motau and Ms. Mokoena on the other has disintegrated irreparably, and I can't put them back together. Now that's very different from this case. In that case, General Motau was accountable directly to the minister. He was the head of an SOE. The minister was the nominee of the shareholder, and the shareholder had ultimate control over the company. And so General Motau had a direct line of responsibility to the minister, and the minister was entitled to say, I can't work with this person anymore. And one can understand that. This case is completely different because there is no direct line of responsibility between the board and the Minister of Mineral Resources. The board is independent. It's not like Arms Corps. It's an independent statutory body. It's not an SOE, which is owned by the state. Yeah. And so that second reason about the relationship between the minister and General Motau and Ms. Mokoena just simply doesn't apply in this case. And so we submit that if your ladyship finds the procedural irregularity, then your ladyship will set aside the decision. Finally now, my learned friend, Mr. Jamie, says, why should Mr. Becker be reinstated for his full term? Well, he should serve his full term because he was wrongly dismissed. And if he's wrongly dismissed, the just and equitable remedy is to put him in place for his full term. Doesn't need some special justification. It's not about money. There are better ways to make money than sitting on a board. It's an estate board. There
are no millions in the state board, eh?
No, there are no millions there. No, if that's your aim, go and look somewhere else. It's not about money. It's that he wants to serve his term. He's been appointed for 3 years, and he should serve his 3 years if the decision is unlawful. If it's not for us to show why he should serve his 3 terms. It's for Mr. Jamie to say why should he only serve, to show why he should serve only 2 years when he was appointed.
We don't know. Maybe they're paid 100,000 per day. That's their,
yes, maybe
their daily allowance.
I think the famous refrain to that, my lady, is "if only, if only." Mr. Becker's not in this for the money. I can assure your ladyship of that. But if he's appointed for a 3-year term, he should serve the 3 years, unless there's a very good reason why he shouldn't. And there's no good reason why he shouldn't. Lady, those are my submissions. Would I ask your ladyship's indulgence just to allow Mr. Becker, Mr. De Beer 5 minutes, Mr. De Beer 5 minutes to finish, and then we are truly done. Thank you.
Thank you, my lady. I will be quick. There's just 3 quick points to make. So the first is in response to something that Mr. Jamie said. First, I must accept the compliment. He says I'm very smart, and it's always nice to be called smart by a silk. But he also said that my arguments were divorced from the facts. And I just want to emphasize that my argument was pitched at paragraph 16b of the minister's reasons on page 66. And that's the reasoning that says because Mr. Becker has said certain things in the media, he will act in a certain way in future. And my submissions on that point was to say, well, how do you know that? You don't. You don't know how Mr. Becker will act. No one knows how Mr. Becker will act because he was never given that opportunity. The second point to make, also in response to Mr. Jamie, is that the case law has crystallized as to this question of whether you can change or supplement your reasons. I don't need to take your ladyship there.
Not really. I do understand that point.
But there's a recent judgment that's in our bundle. It's Forum, I actually can't pronounce the name. It's a Portuguese name. It's about a Mozambican minister. And it's a High Court judgment that summarizes the various case law. We've cited in our heads of argument. It starts at page 9 of our record. It cites all the cases, including in Mortal, where Justice Khampepe also referred to this national lotteries point. And then, my lady, the last point, quickly, is just this question of what are we looking at here when we're reviewing this decision? Is this just a rationality test, or are we looking at whether or not, as a matter of fact, the ground of misconduct existed? Now, both Mr. Borgstrom and Mr. Jamie submitted that, no, this is not a question of whether or not, as a matter of fact, misconduct existed. It's a value judgment for the minister. And it's not for the court to, interfere with that because this is not an appeal. But our respectful submission is that where, like in this instance, there is a factual scenario is a prerequisite for the exercise of a power, the fact has to exist before the power may be lawfully exercised. The case law is legion in this regard. There's a case from 1967, the South African Defence and Aid Fund case. It's cited in our heads of arguments. It's a judgment of Justice Corbett, as he was in the High Court. And he says, if a jurisdictional fact does not exist, then the power may not be exercised, and any purported exercise of the power would be invalid.
What judgment is that?
Oh, it's South African Defence and Aid Fund versus Minister of Justice, and it's cited in, I can just give you the page number of our heads, 32 in footnote 93.
Okay.
The point is this, though. In this act, it doesn't say something like the minister may remove a director if the minister is satisfied that the director is guilty of misconduct, or the minister may remove the director if he has reason to believe that the director is guilty of misconduct. Those sorts of phrasings are the sort of value judgment phrasings, and there was this whole dispute in the old days that the court will be aware of between if it is phrased subjectively or objectively. What we have here is just a simple test. The minister may remove may remove a director for misconduct, full stop. If, as a matter of fact, there was no misconduct, there was no power to exercise, and any purported exercise of it would be unlawful. Those are our submissions, my lady.
Thank you, Mr. Trippier. It's very late in the afternoon. I would imagine everybody wants to go and relax and retire for the day. Thank you so much. Let me hear from Mr. Borgstrom and Mr. Jamie if they've got nothing to add from the reply. I'm just giving them an extra time, otherwise they're not entitled to this.
We're happy to I think everything's been said that needs to be said.
Okay, thank you. Okay, I will take time to consider your arguments then, and the judgment will remain reserved up until Ms. Johnson advises you otherwise. Thank you so much.
Lady, can I just say, I'm sure on behalf of all of us, if I can abuse my power as the oldest here, we're very grateful to your ladyship for her patience in listening to us over a long day and giving us extended time. Thank you very much.
Thank you so much, Mr. Padlender.
I agree, Justice Mantashe. I was about to say I've got 10 points that I want to raise, but my junior refuses to let me.
Okay then. Okay, have a lovely evening.
You
Thank
too,
you.
Judge.
Thank you.
you.
Bye-bye.
Thank you.